Mr. Williams. Did you take a piece? You drove? Okay. Get that done. Okay, absolutely. Right.
Testing.
Oh, yeah.
Well, I say I'll just be here till like 9, but yeah, I'll try. Thank you. is a moment. Yeah, really do that. And that year, so I said, I wanted to get her to because he asked the mom, he's like, Matt's not responding.
Hey, Matt. Matt. That's what it is. It's no glasses and your hair doesn't look like
Thank you.
I respond?
I said, hey, it's
I'm pleading guilty. I'm pleading guilty. There's no need for this. It's okay. Can I just?
I heard the only response was just wait till he needs a transfer. That's all.
I remember exactly where I was when I got I was just leaving the day. I was leaving the Cap County Jail in Parkland, and I was actually on my way to meet with Shannon.
So you were driving to the hospital.
Well, I had to start my
Oh, so you could have sat on the way to the scene, but you're not. Oh, but you
correct. So I saw your text. I said, oh, that's very nice of her. I said, oh, that's very nice. See, they don't let me. They don't let me.
All right, let him. You know how I don't like interruptions. Yeah,
I'm guilty because there's one day. So I said, oh, that's very nice. I was Shannon at this weekend. And once I leave Shannon, I'll give her the most updated information. I went into the hospital and I said, what I'm going to do is just ask me about you. He said, I know I didn't. You don't ask Shannon before I can. My error was I forgot that I didn't respond to you. But I remember everything.
Luckily, I saw an article.
I'm sorry, Mr. Mayor. Thank you. No.
Everyone says it looks different now. It's just both of you can. I'm self-conscious.
I'm gonna just shoot and I'm saying, I don't want the judge to freak out. So the camera point that way. It'll need an out of focus.
Let's try to tell you what, let me ask you that before you do that. That way we both be okay.
Yeah, because I don't know.
Hello? Okay, appreciate it. We here waiting.
Well, I guess good. I need help. I need my
We'll keep going. We'll keep that. I know he was here.
Is there anything in there? Because I got bags here. I got more down here.
We slimming down. So I'm not doing any sweets. No sweet fast. I ain't doing no sweets.
And stay out the drawer.
Don't worry.
Doesn't mean other people. I'm just trash talking. Like, as soon as you get out and pull the sound cleans, so it's like hungry. I feel like I don't even want to go out and show my Jesus. I feel like it should be a little. 50 days. Oh, about the guns? No. Yeah, but they said they don't need to.
This was under normal circumstances where we think we'll be safe.
But I'm glad you said that. I came in here and I said, I'm taking him to my office. So I'm in the office and I see him sitting on the couch. I said, I went crazy. Overnight, that was just because it was
a little bit out of it and started, taking out trying to sell it. Hey, still ain't got the governor. Get me. Hey, it's charged up, ready to go too. It's charged up, ready to go.
One of these days.
Yeah. Hey, we might catch it early this week.
Okay.
I might catch it early this week.
All right, sounds good.
Okay.
I did. Oh, I do. And I read it. I'm a fan of the yeah.
My sister went and she just went because I was going. She's not a big fan. She actually, it's different.
It's very different.
All rise. Superior Court of Fulton County is now in session. The Honorable Chief Judge, you're glad to preside.
Good morning, ladies and gentlemen. Please be seated. Happy New Year, everyone. Happy New Year, Judge.
You can give me the function check.
Say what? For me, excuse me.
This is just for
No, sorry.
from the witness. down, Ken. We had to do this since last year.
No. I said they didn't know this.
Did you tell them why they were here?
Yeah. He said no.
They're down. They're always under here. No.
On the paper right here.
Oh, okay. They're always down here, so if I'm not in here, you don't want to get started. Just go ahead and grab them right here, just leave me the ones with the red,
upstairs.
and that's all I need. No. Leave them there.
Yeah, they made it over.
Christine, you want to do it right? What do you want me to do? Let's talk about it. So this is about the sensitive matter for you. Let's come on up here. Let's see if Can you hear me better? Excellent. Good. So this is. Good.
More familiar face, have you been? Okay, thank you. You just hold that. Here you go. I'm just gonna nice to meet you.
Nice to meet you. This one's on now. What do you mean? There, it's on. Yeah. All right, parties and those interested parties, we'll go ahead and get started at this point in time. Let me go ahead and take roll. We're back on a record in the matter of the State of Georgia versus Khalif Adams et al. And 22 SC 183572. Let me go ahead and take roll for the morning. Mr. Stillwell, Mr. Botts, and Mr. Short, good morning. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Ms. Renard, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning.
Good morning, Your Honor.
All right, Mr. Huey and Mr. Matthews Jr. and Sr., good morning, gentlemen. Mr. Nichols, Mr. Harvey, Ms. Westmoreland, and is Mr. Garner over there? Oh, there he is, okay. Mr. Garner, good morning. And then Mr. Ryan and Ms. D. Williams, good morning. All right. Man, it seems like every time I look at the state, they're either growing or they're changing parties. All right. Ladies, Ms. Hilton and Ms. Love, good morning. Mr. Smith, Mr. Brown, and Mr. Adkins, good morning.
Good morning, Your Honor.
All right. Okay. It's been brought to my attention that all of our jurors are here. Also from looking at Odyssey, Mr. Steele, you have been busy over the holidays, I see right now. Are there any of these motions in limine I need to take up at this point in time?
Not at this point in time, except, can I just make a request of the court?
You can. I don't know if I'll honor it, but, you know, it depends. What's up?
Your Honor, this was done by Your Honor court already, but I presume that we're continuing with the supposed threat of July 7th, 2015 Berman Mall. I just want to refresh everyone's memory not to bring up that Mr. Williams, in the report, not to bring up that Mr. Williams was run by Officer Stevens to Atlanta Police Department. Arrest in 2014 has not been admitted. It's not in the indictment. And that's where I got a photograph. And also not to mention anything about when Mr. Williams was arrested on July 15, 2015, that there was also a contemporaneous search warrant executed at his home. I'd like to, as we ordered previously, but make sure that we don't have an issue with either of those incidents, and also the double hearsay for what the valet people said about Mr. Williams and the other persons he was with always, quote, caused trouble. They're not on the list. So that's a free thing.
Does the state have any issue, or are there any, have you advised or admonished your witnesses accordingly?
We have, but we will remind Officer Stevens about that admonition. We did it prior to the break, but we will make sure we do it again.
Is he testifying first, or?
No, he will be testifying either second or third.
Okay, so before that, just go ahead and do that, okay?
Yes.
All right. Anything else I need to take up before I bring up our jurors?
Thank you, Your Honor.
Okay, all right. Sergeant Ingram, can you bring out our jurors for us, please, sir? Do you have any candy down there? Can I have a couple pieces, please? Hard candy. Cool. Okay.
jury president.
All right, thank you, Sergeant. And ladies and gentlemen, please be seated. All right, members of the jury, how we doing? Happy New Year to all of you. Happy New Year. All right, that's wonderful. Y'all sound good, good. I hope you all had a good period of respite, and we're going to go ahead at this point in time, continue with the presentation of the state's case. As I mentioned earlier, we'll go ahead and by the end of business today, we'll go ahead and take up kind of our plan for the next 2 or 3 weeks to kind of give you some indications as to now since the beginning of the year. I'm sure that there are other things that you need to kind of business-wise you need to take attention to, so I'm going to give you an opportunity to do so. So we'll talk about that certainly end of the day or no later than tomorrow, okay? All right, so with that, State, if you call your next witness, please.
Thank you, Your Honor. Your Honor, the state will be continuing with Act 51 where we left off. The state called Dwight Hudson.
All right, summon Dwight Hudson, please.
He's in the wheelchair. He's in the wheelchair.
Yeah. Can he?
If he can't stand up.
Okay, we'll just see how it goes. Mr. Hutchins, good morning, sir. Come on up. Mr. Hutchins, would you prefer to stay where you are? Would you like to be assisted into the witness stand? Your choice.
Yes, thank you.
Okay, all right. Let's see if we can't. We're going to turn you so everybody can see you. Okay. To begin with, is that okay? All right. Christine, you okay?
Yes.
All right. All right. Mr. Hutchins, let me get you to raise your right hand if you're able to do so, sir.
Raise your hand. You
All
swear.
right, go ahead.
You swear affirm the testimony you give today the truth, the whole truth, nothing but the truth?
Yes.
Speaking to the mic.
Yes.
All right, state and spell your first and last name for the court so you can put your head down. Speaking to the mic.
My first name is Dwayne. D-W-I-G-H-T. My last name is Hudson. H-U-T-C-H-I-N-S.
And good morning, Mr. Hudson. How are you?
I'm good.
And Happy New Year to you.
Thank you.
Mr. Hutchins, do me a favor. I want you to yell in that microphone, okay? So we can all hear you, all right? Or I'll put it this way, use your outside voice. Let's see how that goes. Can we do a test?
Testing.
All right, okay. Just try and keep that level up, if you wouldn't mind for us, okay?
All right.
All right, thank you, sir.
And Mr. Hudson, where are you from?
Atlanta, Georgia.
All right. And do you currently reside within the metro Atlanta area?
No, I live in Loganville.
Okay. And how long have you been in Loganville?
Like a year and a half.
You said a year and a half? Okay. And are you currently working?
No,
Why aren't you working?
because I had a stroke.
How long ago did you have your stroke?
Back when COVID started, 2020.
And with you having a stroke, has it affected your memory at all?
Yes.
Now, let me ask you, prior to having your stroke, did you work?
Yes.
What type of work did you do?
Security.
And how long were you in the security industry?
Give us take about 25 years.
25 years. And while in the security industry, did you ever work for Velour Security Services?
Yes, I have.
And if you can recall, approximately when did you work for Velour Security Services?
About from 2013 to 2015.
And when you worked for Velour Security Services between 2013 and 2015, did you have a particular location that you were responsible for securing?
We secured the whole mall,
And when you say the whole mall, which mall are you referring to?
Perimeter Mall.
And did you work at Perimeter Mall for that entirety of that 2013 to 2015 period?
Yes.
When you worked at Perimeter Mall, what were some of your job duties and responsibilities?
To help out people to go to accident scenes, wherever they may be.
You said to go to accident scenes? If you shook your head, is that a yes?
Yes.
And is that accident scenes within the mall?
Yes.
Did you ever have the responsibility for patrolling outside of the mall as well?
Yes.
Within Perimeter Mall, was there a particular unit or area where the security team was housed if you weren't patrolling? Did you have an office area?
Yes.
And in that office area, was that a shared space or did you have your own individual office within the security office area?
All of the officers shared that area.
And was that area a secured area?
Yes.
And just generally, if there was an incident that occurred at the mall, say an accident or anything like that, would you have to make an incident report, an internal incident report?
Yes.
And generally, when there was, say, an accident at the mall, did you always have to call outside law enforcement, or was that only on certain occasions?
No. It was only a certain occasion.
Why would you have to call law enforcement out?
If somebody slipped and fell and hurt themselves, well, catalytic converters, things of that nature.
And we say catalytic converters, what do you mean?
They were cutting them off.
They were cutting them off at the mall.
Yes.
Like people would come up and cut off people's catalytic converters.
Yes.
If there were any crimes like theft, would you have to call the police?
I wouldn't have to call him per se.
Okay. Who would have to call?
Mr. May.
Mr. May. And who is Mr. May?
He's the director of security.
He was director of security? And was Mr. May your director of security the entire 2 years that you were at Perimeter Mall?
Yes.
As your supervisor, what was some of his responsibilities? As Mr. May, he was your supervisor?
He was over the whole department.
And do you know, as his job over the entire department, some of his responsibilities?
No.
Would he sometimes be called to assist you if you needed assistance?
If I called him.
Now, I want to direct your attention to July of 2015. Were you working for Velour Services at Perimeter Mall?
Yes.
And taking you back to July 2015, which is a while ago, did you have the occasion to encounter a group of men on hoverboards?
Yes.
If you can tell the jury, what do you remember about your first encounter with them?
Well, my first encounter was when I spoke to him, I explained the policy that it could be injured and liability issue. One guy stepped down, then the other guy said, get back on your board.
So how many guys were on hoverboards?
2.
Right. And you were explaining to them why they could not be on hoverboards?
Yes.
Right. And was that part of the mall policy why they could not be on hoverboards?
Yes, due to liability issue.
And I believe you just said, I just want to clarify, that when you spoke to them, one person got off the hoverboard, the other remained on the hoverboard. And you're shaking your head, is that a yes?
Yes.
And the one who stayed on the hoverboard, I believe your testimony was, he told the other person to get back onto their hoverboard.
Correct.
Once that occurred, what, if anything, did you do as it relates to those 2 individuals still on their hoverboards?
I just kept explaining the policy.
And did they say anything to you as you kept on explaining their policy? Your policy, though.
They said they were leaving.
What was their demeanor?
Okay, toward me, it was all right.
I'm sorry, say that one more time.
Toward me, it was okay.
Towards you, it was okay. All right. Now, when they did not get off of their hoverboards, what did you do?
I called Mr. May.
And why did you call Mr. May?
That's for his job. When I can't handle something, I call him.
When you can't do what?
Handle something.
And when you say you can't handle something, what couldn't you handle with this particular incident?
Well, they kept riding, and I ain't gonna put my hand on nobody. So I called him. Let him explain it to him.
And were you able to reach Mr. May?
Yes.
All right. And did Mr. May, what happened with Mr. May?
He asked for my location. They came to my location.
All right. And what location were you at the time?
Champs.
And what type of store was Champs?
A shoe store.
And when Mr. May got to the shoe store, what happened?
I advised him of my situation, and he went and spoke to him.
And what happened when he began to speak with them?
They were leaving, so he said they're leaving anyway.
And what was their demeanor like when they said that they were leaving?
I mean, I don't know what you mean by it.
Okay.
Were they hostile or what?
Yeah. How were they acting?
They were acting normal. They were just riding.
They were just riding. All right. All right. And did they get off the hoverboard?
No.
All right. What happened next?
We escorted them to the front of the mall, up the escalator.
And were they still on the hoverboards when you
Yes.
put them out the mall?
Yes.
All right. And what happened after you escorted them out the mall?
We escorted them to the valet where they were parked.
All right. And did you go down to the valet area where they were parked?
Yes.
All right. What happened once at the valet area?
During that time, I got checked out because we already got them at the mall, so it's all good.
Okay. You said you checked out because it was all good at that point. All right. What if, did you hear them saying anything at that point?
I just heard a lot of profanity.
And who was giving profanity?
I'm not sure.
Oh, you don't know which one? Okay. Do you remember anything specific that they were saying?
No.
And you said they were yelling profanity. Was it the individual on the hoverboard yelling profanity?
Just the guys in the car.
Just guys in the car. How many guys were in the car?
3 or 4.
And today, so you don't recall what they were saying?
No.
No, okay. Now, back in 2015, did you have to make a report to the police regarding what happened at the mall with these two individuals on hoverboards?
I don't think I ever read a police report.
Did you ever remember talking to the police about what happened?
No.
You don't remember? Okay. Do you ever remember writing a statement?
No.
Okay. Do you ever remember seeing a statement with your signature on it?
Yes.
All right. Permission to approach, Your Honor?
You may, madam.
I believe the defense counsel all has this statement, but I'm going to show this to Mr. Hutchins. Ms. Hutchins, I'm going to show you what's been marked as State's Exhibit 190P. And looking at State's Exhibit 190P, do you see your signature on State's Exhibit 190P?
It looked like mine, but it's not mine.
It looks like your signature, but it's not your signature.
That's how I write now.
That's not how you write now.
I write like this now.
Okay, but you're saying back in July of 2015, that's not how you wrote.
No.
All right. Let me ask you, looking at that document though that has your name on it, is there a date indicated on that document?
Yes.
Yes. Yeah, but you have an objection?
Yes.
Basis.
Document has been,
Basis.
a document has been disowned. There's no foundation.
Foundation, okay, that's what we're looking for, all right.
Your Honor, it's impeachment. And he's saying I don't want to do a speaking.
Okay, all right. I'm gonna overrule your objection, so you may proceed this time.
Is there a date on that document?
Yes.
Okay, what is the date?
7/7/2015.
Okay. And in looking at the document, you've had the opportunity to read this document previously?
Yes.
Okay. And is this document written in first person, meaning as if you wrote the document?
Your Honor, same objection.
Given what I've learned already by the witness, I'm gonna give him a little attitude, Mr. Steele. I'm gonna overrule your objection, okay? Ordinarily, I wouldn't allow it to leave, but I'm gonna, in this particular circumstance, make an exception, okay?
Is it written in first person?
Yes.
Okay. And so it says, I, Officer Hutchins, right?
Correct.
Okay. And this document also has a date in which it was written, right?
Yes.
What is the date that the document was written?
July 7, 2015.
All right. And this same document was written closer in time to the incident that we're referring to, which was July 2015.
I can't say.
You can't say. But there's your signature.
It looked like mine, but it's not mine.
All right. And there's a date of July 7, 2015.
Asked and answered.
I stand the objection.
And today you're saying that you did not write this statement.
I don't recall
You don't
writing
recall?
this statement.
Okay. All right. And you do not recall writing the statement.
Correct.
Okay. Thank you.
Who made that objection? I'm sorry?
Objection as for answer.
I sustain the objection.
Now, a few weeks ago, do you recall one of my investigators coming to your home?
Yes.
All right. And when my investigator came to your home, did the individual show you this document?
On his phone, yes.
Okay. And do you recall what you told him about your signature when he showed you the document on the phone?
Correct.
Okay. And what did you tell him about your signature?
I said at that time, it looked like mine.
Okay. And this same signature, was this the same document that he showed you on the phone?
It was so small I couldn't hardly see it, but it looks to be the same.
It looks to be the same document. Okay. Now, Mr. Hudson, as it relates to, you said that you kind of had to escort these individuals from the hoverboards out of the mall. Was this your first time ever having to escort anyone out of the mall?
No.
And when you previously had to escort individuals out of the mall, do you always have to call the police when you're trying to escort individuals out of the mall?
Objection, relevance.
I sustain the objection.
On this incident day, back in July 2015, were the police called after this interaction with the individuals on hoverboards?
Yes, they were called, but I didn't call.
You did not call, but they were called. All right. Now, back in 2015, when you first encountered the individuals on hoverboards, did you know their names or who they were?
No.
Back in 2015, is it safe to say you had never met those individuals prior to that interaction that you had with them on the hoverboards?
Correct.
All right. And at the conclusion of the interaction with those males, did you learn their names at any point in time?
After they left the mall,
How did you learn their names once they left the mall?
well, they are people that recognized them.
People at the mall had recognized them?
Right.
Okay. And who did you learn it to be?
Well, I don't remember the name.
You don't remember who it is? All right. I'm going to show you what's already been admitted as State's Exhibits 184P. And I'm going to hand this to you. Sure. Yeah, 184. Mr. Burns, can you share capabilities? All right. And Mr. Hudson, I'm going to show you right here. And for the juries on the screen, State's Exhibit 184P. Have you seen that picture before?
Yes.
Okay. And do you see yourself in State's Exhibit 184P?
Yes.
If you can tell the jury, where are you at in State's Exhibit 184P?
At the top of the escalator.
Okay. And at the top of the escalator, there's two individuals. Which one are you?
I'm the one on the left with the flight deck.
With the flight deck, with the vest on? All right. And now I'm going to show you what's been marked as State's Exhibit 185P. And have you seen that picture before?
Yes.
All right. And looking at State's Exhibit 185P, do you recognize the individual in 185P?
I don't recognize him, but that's the gentleman that I spoke to.
That's the gentleman that you spoke to. And when speaking about the two individuals, initially one stayed on the hoverboard and one came off the hoverboard. The individual in 185P, Which one was he?
He was the one that said, get back on your hoverboard.
Okay, so he's the one that stayed on the hoverboard and directed the other person to get back onto the hoverboard. You're not
Yes.
Yes. Okay. And down at the valet, when you said that people were cussing, was he one of those individuals that was cussing down at the valet?
I don't know.
You don't know.
I didn't see him per se
Okay. So that's your testimony today. You did not see him per se.
because, like I said, once we got him out the building, I kind of checked out because we had already done our job.
Okay. And you were the one who first had the first interactions with these individuals?
Yes,
And you were the one who called Mr. May?
yes.
Leading and repetitive.
I'm going to overrule the leading. I'll sustain the repetitive.
I have no court's indulgence.
All right?
Just one last question, Mr. Hutchins. Earlier, you said that the demeanor, earlier, you testified that the demeanor, that they weren't fussing and cussing towards you. Were they fussing and cussing towards anyone else earlier in the day? Earlier in your interaction?
No,
No, you don't recall that.
they were not.
Hold on. Basis. I'm going to overrule the objection.
Also object, Your Honor.
I'll overrule the objection. I'll overrule the objection as to yours. One at a time, gentlemen. Mr. Matthews, yours is overruled, or yours is, yeah, overruled. What's your objection, sir?
District Attorney mischaracterized the answer.
I'm going to overrule your objection. Jury will be determine what they heard, okay? All right, anything else? All right.
I have no further questions.
Any examination of Mr. Hutchins, gentlemen?
Very brief.
Okay, come on.
For ease today, question from that corner.
You may, sir.
Good morning, sir.
Good morning.
We all hope that you feel better and keep recovering.
Thank you.
Do you, have you read what was shown to you as a number 190P? It's that document that the district attorney was asking you if your signature was on that?
Correct.
Okay. Do you know where that document is right now by any chance?
No, the original.
Is that it right there? Your Honor, may I approach 1 second?
You may.
May I approach you, sir?
Yes.
I'm going to show you this, and if you can't read it, just let us know, okay? I see you with reading glasses. With your permission and the court's permission, I just want to ask you a couple of questions about that document, okay? The district attorney was saying that it was written. Is that a written document or a typed document?
It's typed.
Okay. And the only part written would be at the bottom of that document, is that fair to say?
Yes.
With a, I'm not saying, I understand, it's your testimony, purportedly, meaning potentially or seemingly your signature and then the date of 7/7/2015. Is that true?
I mean, what's the question again?
That's the only handwritten part of 190P. Okay. And in that document, even the type part, you never mentioned anything about any of the people on the hoverboard being rude to you or Mr. May in the mall. Is that true?
Correct.
And what you do write is that you were being ignored and Mr. May was being ignored about your warning to please get off the hoverboard, and it could be a dangerous situation for them as well as others. Is that fair to say?
Correct.
And the people on the hoverboard made it known, and they did leave the mall. Fair to say?
Yes.
And then they went peacefully to their car.
Yes.
And at that point, the way you recall is it was pretty much they were leaving. It was over. Any issue was over. Is that fair to say?
Yes.
Okay. But then in this statement, the 190P, it's written that Mr. May continued to ask them to leave the property, and I stress this, one of the males shouted he would come back and shoot Mr. May in the face. Do you remember that? Right, at least that's what it says. The last 2 lines?
That's what it says.
Okay. And you never identified anybody as saying that. You were just saying that it came from the car. Fair to say? If this is yours.
Well, all I heard, like I said, was a lot of profanity.
Okay. All right. And you don't know Mr. Jeffery Williams, do you?
No.
And you don't know a performer known as Young Thug personally, do you?
No.
All right. Thank you so much for your time. I can take that from you unless you need to see. Thank you, Your Honor.
Anyone else? Anything further from the state?
Mr. Steele just asked you if you knew Mr. Young Thug personally. Once this incident was over, did you learn if Young Thug was one of the individuals on the hoverboard?
Yes.
Yes, you did. But you did not know him personally?
No.
All right. And Mr. Steele asked you a lot about the statement that I asked you about earlier. And again, looking at State Exhibit 190P, today your testimony is that you heard a lot of cursing. Looking at 190P and that last line, what is in that statement regarding what the individuals in the car said upon leaving the location? So regarding that statement, do you have any memory writing that statement?
No.
You have no memory writing that statement. And is your testimony today that you did not provide that statement to police officers?
I don't remember providing this statement at all.
Okay. Okay.
There's some things wrong with it.
All right. Thank you. No further questions.
Anything further?
Don, get this away.
All right. Anyone else? Okay, may Mr. Hudson's be permanently or temporarily excused as a witness?
He can be permanently excused.
All right, Mr. Hudson, I'm going to permanently excuse you as a witness. Thank you for your patience with us. And please don't discuss your testimony with anybody except the attorneys in this case, okay?
All right.
All right, thank you, sir.
Thank you.
All right, call your next witness.
Your Honor, state calls Mark Stevens to say.
All right, summon Mark Stevens, please. Mr. Stevens, good morning, sir. Sir, if you could please approach the witness stand. Once you get there, if you'd be so kind to turn and face Sergeant Ingram, who's sworn as a witness before you sit down.
Yes, sir. Raise your right hand. Swear affirm testimony you give the truth, the whole truth, nothing but the truth?
I do.
Absolutely. Thank you. State the civilian first last name for the court.
Mark, M-A-R-K, Stevens, S-T-E-V-E-N-S.
Mr. Stevens, good morning, sir.
Good morning, sir.
Mr. Stevens, are you currently employed?
I am not.
Where did you work prior?
In November, I retired as a police officer from the Dunwoody Police Department.
Okay. And prior to your retirement, where did you work prior to your retirement?
With the Dunwoody Police Department.
How long did you work for the Dunwoody PD?
Almost 15 years.
Mr. Stevens, what units were you assigned to during your time with duty?
When I was hired as a patrol officer. In 2016, I was transferred to the community outreach section.
What were some of your responsibilities as a patrol officer?
To answer 911 calls or any other call for service, enforce traffic laws, and those were our two primary.
And what years were you assigned to the patrol unit?
I started in 2009 with the Dunwoody Police Department and I was a patrol officer until January of 2016.
And were you court certified during that time?
Yes, sir, I was.
So on or about July 7, 2015, did you respond to a call at the perimeter mall?
Yes, I did.
What was the nature of that call?
It was a threats call.
After you arrived on scene, who did you speak with?
I met with the Director of Security, Chris May.
And to your knowledge, was the person who made the threat still on scene?
No.
Were you given any vehicle information to identify the person who made the threat?
Yes, sir. It was a white four-door Jaguar with a partial Georgia temporary plate.
And were you able to get any information with this partial tag?
No, sir. Unfortunately, there was a digit missing, so no returns were available.
Mr. Stevens, who else did you speak with to identify the person who made the threat?
After I spoke with Mr. May and I both spoke with a gentleman named Reggie. He's the manager at Champs Sports.
Without telling me what he said, were you able, was the manager of Champs able to identify him?
Yes, he was.
What was the name of the person he identified?
He identified the subject that made a previous purchase as a rapper known as Young Thug.
Was Mr. May able to identify the person who threatened him?
Yes, he was.
And how did Mr. May identify the person who made the threat?
Mr. May did an images search on his phone and pulled up a picture where he identified that person. In the photograph was the one that made the threat against him.
And once you learned the person's name was Young Thug, what did you do?
At the time, I was just still gathering more information. Once I was done with that and left the mall, I went back to do I did some further searches to try and determine a government name for the individual known as Young Thug.
And what did you determine the legal name to be?
I was able to determine it was Jeffery Williams.
Did you prepare an incident, a report for this incident?
Yes, sir, I did.
Mr. Stevens, do you recall what the language of the threat was?
It was paraphrased. Mr. May did not provide an actual quote. He just said that Young Thug said that he would shoot Mr. May in the face.
Did you take out any arrest warrants or any other additional charges?
No, sir, I did not. I completed my incident report and forwarded it to the case investigator, and the investigator is the one that swore out a warrant.
And did that complete your involvement with this case?
Yes, sir, it did.
Court's indulgence?
Yes, sir.
Mr. Stevens, do you recall a Mr. Hudson being present?
The name I do not recall off the top of my head. It's possible that that might have been one of the security officers involved, or, but the name does not, I don't recall the name off the top of my head, no.
Do you recall the demeanor of any of the perimeter mall employees?
I sustain the question.
Who do you remember being present during this interaction?
I was not actually there, so I did not witness the interaction between the mall personnel and any other individuals. The only persons I spoke to were Mr. May and then the gentleman at the Champ Sports, Reggie. There were other security individuals that were involved with the incident. They actually spoke with the investigator and not with me.
Objection, that's outside the witness's knowledge.
I'll overrule the objection.
No further questions.
All right, cross.
Good morning, former officer.
Good morning, Counselor.
Thank you for your service.
Thank you, sir.
If you need to see anything with your report to refresh your memory, just let us know. If it's in front of you, just let us know that you're looking at something, okay?
Yes, sir.
Okay. Just want to ask you a couple of things. I think this is clear, but just to breeze through this. You were not there at the time this supposed incident occurred. Is that fair to say?
That is correct.
And you get a call later through your dispatcher coworkers to come to Perimeter Mall, and you do it when you do that.
That is correct.
And when you arrived at Perimeter Mall, you met with two people. First, you met with who pronounced themselves as the security officer for the mall, named Mr. May, Christopher May. Is that fair to say?
Yes, sir. I met with him first.
And you got there, you don't have any information, so you needed to get information from Mr. May.
That is correct.
And he provided you information.
That is correct.
He was cooperative with you.
Yes, sir.
And you took notes.
Yes.
And then those notes get memorialized, is my word, but written down into a police report or an incident report. Is that all fair to say?
Yes, sir. That is correct.
And you do that timely because you go on different events for the community, so this way when it's fresh in your mind, you write down. Fair to say?
Yes, sir.
And that's what you did in this case, right?
That is correct.
And in fact, your report, let me just make sure I'm right. is dated the same day, 7/7/15, which is July 7, 2015.
Yes, sir, I looked at it earlier. It was written the same day of the reported incident.
Okay. And I want to talk to you about some things that Mr. May told you, okay?
Yes, sir.
Now, Mr. May explained to you that there were 3 men inside a white Jaguar vehicle. Is that fair to say?
At the end of the incident, yes. Initially, it started in the mall.
Okay. I mean, we could go backwards, but that's the issue we're dealing with.
That is correct.
Okay. Anything you need to say beforehand, just let me know. You'll tell the jurors, okay?
Yes, sir.
And I'm just getting to the issues we're dealing with.
Yes, sir.
All right. And Mr. May explained that it was a 4-door Jaguar vehicle he was dealing with.
That is correct.
And they gave you a partial tag, that's why you couldn't run the numbers. It was just missing a digit.
Yeah, I believe it was missing 1 digit, yes.
And then according to Mr. May, he explained to you that the rear passenger told you that if Mr. May continued to approach, he would shoot Mr. May in the face with a gun. Remember that?
That's essentially my recollection from reading the incident report, yes.
And it was that Mr. May was approaching the person, and the person said, get back, otherwise, and whatever the statement is, he would shoot Mr. May in the face with a gun. That's what Mr. May said.
That is correct.
Okay. This isn't on any recording, right?
As far as I know, it is not, sir. It wasn't recorded by me.
And when you're there at the mall, nobody else came up to you and corroborated that you know what corroborated means?
Yes, sir.
Supported.
Yes, sir.
Said the same thing. That Mr. Williams, the young thug, made that statement. Is that fair to say?
During that incident, yes, that's correct.
And then Mr. May also told you that after that statement was made, then Mr. May backed away and allowed the Jaguar vehicle to leave the mall. True?
Yes, sir, that's correct.
That Mr. May was holding the Jaguar vehicle at that time. He wouldn't let it leave. That's what he told you, right?
He was trying to, what he told me, he was trying to get them to cooperate. The only thing Mr. May wanted to do is issue them a criminal trespass ban and was trying to get them to cooperate.
And the jurors may not know what a criminal trespass ban is. That means that a person or people are notified, please don't come back on this property.
That is correct. It has nothing to do with any certain type of, they have the right to say, we have reason to ask you not to come back to the mall again. If you are, you can be prosecuted for it. So that is correct.
And because Mr. May, to his satisfaction, did not get that message across, he was detaining that vehicle, as how we explained it to you.
He never said anything about detaining, that I don't,
If you want to use it.
that I don't know.
He wouldn't let the vehicle leave.
When I was told after the threat was made, he backed off and let them leave.
Okay. Then, just to complete the picture for the jurors, there was a belief that Mr. Williams and others purchased many shoes at Champs Sports. You know what Champs sells? Do you remember?
Sports equipment, and I know some shoes, jerseys, yes, sir. I'm familiar with it.
You realize if we go there, maybe a credit card was used.
I didn't, that was not my idea. Mr. May said that the initial incident started outside the Champs Sports. He was under the impression that there had been a purchase made, so we might have been able to identify someone through that purchase.
And that's what you did?
That is correct.
No gun was alleged to have been shown, right?
As far as I know, no one, Mr. May did not report that to me. No gun.
Said anything about a firearm being shown?
That is correct.
No one said anyone came back?
That is correct. I was not told they returned.
Okay. You wrote this up as a disorderly conduct. Do you remember that?
Do you mind if I take a look? I don't know if I didn't. On the incident report that I have, sir, the crime incident is listed as assault intimidation.
Do you see the top, maybe we're looking at different reports, see the top center, and otherwise let me approach the see what you're looking at.
Yes, sir. I have the incident report that, and I'm working.
May I approach and see what you're looking at?
You may.
Counselor, this is the incident report that I did. If it starts with Dwayne Police Department, the crime is listed here. The one that I have is assault intimidation.
Can I look at it for a second?
Absolutely.
You might not want to turn the page.
No, absolutely. And then that's the end of my report there. It's just the initial back, this, and then name there, and then starting there is just further information.
I'm showing you, you know what, let me show you this return, please.
Well, Counselor, but I see what you're saying. I don't know why it is. It might have been changed because right here it
We're
says...
going to discuss it. Let me just show it to you.
Yes, sir. But I'm just saying, did you see that one too, though?
Yeah.
Okay, I just want to make sure you saw it.
Show it to me.
No, absolutely.
I'm not going to interrupt you.
It's not a problem.
Sorry, I just want to show. These are documents you brought into the I'm going to approach you again, okay?
Yes, sir.
All right, I just want to show you this.
No, certainly.
All right. You can just remember. Okay. So, if you don't mind looking at what I think yours is, what is that, page 3?
Yes,
That you were looking at?
that is correct.
And that's your incident report, right?
It has my name down at the bottom as the reporting officer, yes.
Okay. I'd like you to look also at page 25 on the lower right, and I handed it to you. I showed the district attorney already.
Yes, sir.
That's your...
Objection, Your Honor.
Basis.
I believe that's the witness's report.
Good question.
Let me see it, please. What are you questioning from, Mr. Steele?
His report.
May I start? Yeah. Okay. I've just got the 2 pages that are together. That's all right.
Okay, let me see yours, please, Mr. Steele. Can I see yours again, please? Okay. Mr. Steele, in order to ask him, I'll sustain his objection. In order for you to ask more questions, you're probably going to need to clarify what you're showing him.
Can you turn to page, what is listed 25 on the documents you brought with you?
Yes, Counselor.
Okay. And is that your reporting officer narrative?
Yes, it is.
Okay. And is that either substantially or identical to what's on page 3 of the same document you came, which is also reporting officer narrative, except for what's in the center top.
The center, the narrative appears to be the exact same on both pages. There is slightly different wording at the top and at the bottom.
Now, my question to you is, do you know how on page 25, whether you put in disorderly conduct in the center for the offense?
To be honest with you, I do not recall how I termed it.
All right. Can you explain to the ladies and gentlemen jury how the report, your report, got changed or altered from page 3 to page 25, specifically from the offense, like you told the ladies and gentlemen jury what you were looking at, assault, intimidation versus disorderly conduct? Can you explain to them how that changed?
Unfortunately, I do not. When we file an incident report, we select a crime type or types. It is chosen by the reporting officer. Once we submit that report, we don't have the ability to change the type, the narrative, anything. It seems that one is dated 2015, listing disorderly conduct, and one is dated printed out 2022, lists assault, intimidation, but that could not have been done by me. I don't know how that happened, to be honest with you.
And you wouldn't have done that, would you?
No, our system doesn't give us the ability to go back and modify.
And the disorderly conduct is the reporting officer narrative that was in July 7, 2015. Is that fair to say?
Yes, it says date and time of the report is July 7th. This was printed on July 9th and listed as disorderly conduct.
That's pretty much concluded your work on this case. Is that fair to say?
That is correct. After the incident report, the detective handled the case from there.
Thank you again.
Thank you, Counsel.
Any further examination? Any further redirect, sir?
Just briefly, Your Honor. Mr. Stevens, at the time you were interacting with Mr. May, what security personnel were present? If you recall.
If what?
If you recall.
I only spoke directly with Mr. May. I know there were other personnel there on property, but I did not interact with any of them. The case investigator ended up speaking with the other personnel.
And if you recall, did anyone contradict what Mr. May stated his statement to you?
No, they did not.
I'll object to the form of the question.
Cases, I sustain the form of the question. So you can rephrase if you like.
Did anyone say that Mr. May's statement was not true?
No, they didn't.
Your Honor.
Still, I sustain that objection.
Was this a direct quote by Mr. May?
No, a direct quote was not provided to me.
Mr. Steele asked you if Mr. May said, if you approach, I will shoot you in the face. And these were not, were these exact, Mr. May's exact words?
No, sir. I paraphrase what is said. If a direct quote, such as "my name is Smith," is used, I use quotation marks to note that that is a direct quote used by an individual. Without direct quotes is only paraphrased.
Did you put? No further questions.
Anything further?
No.
All right. At this point in time, may Mr. Stevens be permanently temporarily excused as a witness?
Permanently, Your Honor.
All right. Mr. Stevens, I'm going to permanently excuse you as a witness. Appreciate your patience with us. Just don't discuss testimony with anybody except the attorneys in this case, okay?
Yes, sir.
Thank you, sir.
Thank you, Judge.
All right, call your next witness.
Your Honor, state called Sergeant Sean Lenahan to the stand.
Sergeant Lenahan?
Lenahan.
Lenahan. All right, summon Sergeant Lenahan, please. Sergeant Lenahan, good morning, sir. Sir, if you would please approach the witness stand. Once you get there, if you would turn and face Sergeant Ingram and be sworn as a witness before you sit down, sir.
Yes, sir.
All right.
Raise your right hand. You swear firm testimony to give the truth, the whole truth, and nothing but the truth?
I do.
See, states
I'm Sergeant Sean Lenahan, first name S-E-A-N, last name L-E-N-A-H-A-N. L-E-N, no, N is in November, A-H-A-N. Yes.
And Sergeant Lenahan, where are you employed?
With the City of Dunwoody Police Department,
And how long have you been with the City of Dunwoody Police Department?
11 years.
And what's your current assignment?
I am a patrol supervisor, sergeant on the road,
And how long have you served as a sergeant?
since 2015.
And prior to your role as a sergeant, what did you do for the Dunwoody Police Department?
Prior to that, I was a detective in the Criminal Investigative Division, and prior to that, I was a patrol officer.
And how long did you serve as an investigator within the Criminal Investigations Division?
From 2012 to 2015, so 3 years.
And are you post-certified?
I am.
And were you post-certified on July 7, 2015?
Yes.
If you can tell the jury briefly, what were some of your job duties and responsibilities as an investigator in the Criminal Investigation Division?
To follow up on any criminal leads that we may have for on different cases, different types of cases, to make arrests, also to I guess make court appearances and things like that in reference to cases.
Now, in the Dunwoody Police Department, as an investigator in the Criminal Investigations Division, did you have a particular area that you were assigned, or did you handle any case that came up in all of them?
Could be any case that came up in the city of Dunwoody.
And Perimeter Mall, is that within the city of Dunwoody?
Yes.
I want to direct your attention to July 7, 2015. Did you have the occasion to investigate a terroristic threat incident that occurred at that location?
Yes, ma'am.
How did you first get involved with the investigation?
There was a police report made, and it got assigned to me.
And who made the police report?
Officer Mark Stevens.
Officer Stevens?
Mm-hmm.
And you said, is that a yes?
I'm sorry, yes, ma'am.
All right. And what was your understanding of what you had to investigate?
My understanding was that there were two gentlemen at the time riding foot scooters or hoverboards.
Who was that?
Is that Mr. Steele? Yeah.
Your Honor, the testimony has comment is no longer hearsay. Mark Stevens just testified.
Yeah, I'm going to, well, why don't you, I'm going to sustain the objection, lay a little more foundation.
When you got the police report, did you review it?
Yes, I did.
And once you reviewed it, what was your understanding of what you needed to investigate?
Objection.
I will rule the objection.
Go ahead.
Okay. My understanding was a terroristic threat of a person threatening to shoot another person in the face with a gun.
And in order to investigate what occurred, what did you do?
So I set up a meeting with the witness and the victim, or the victim and the witnesses that were present. And then I went over to the mall and met with the three, I think it was three witnesses and the victim. And I'm sorry. Okay. So then I asked them to write statements, and then I would come back and pick them up. Each person to write their own statement, and I would come back and pick it up. And then I left the scene, or I left the office, and then I went back and did other things, and came back and picked it up another day.
So let's slow that down.
Okay.
You went super fast.
Okay.
All right. So you said that your responsibility was to investigate a terrorist threat.
Correct.
And when did you first get the police report handed to you? Do you recall?
I believe it was July 7th, 2015.
And let me first ask, on July 7th, 2015, when you first get the report from Officer Stevens, did you go to the mall on that day or another day?
I believe it was the next day or the day after. I'm not sure the exact day, but it was shortly after that, yes.
And when you went to the mall, what did you do?
I met with them in the security office.
So let me ask you, said them.
I'm sorry, the victim, Chris May, and the three witnesses, turned out to be three witnesses that were present during the threat.
Okay, so you said Chris May was the victim. Who were the three witnesses that you met with?
The exact names, I think Hutchins was the last name of one of them. The other one was, can I look at my notes or do you want?
Well, let me approach. We're looking at a copy of your report. Refresh your memory as to who you spoke with.
It would, yeah.
Okay.
Mm-hmm.
I want to show you what will be marked as State's Exhibit 191P, and I can show it to you. I'm going to show him the entire page. I'm going to refer him to I'm going to show you. Oh, thank you. What's been labeled as State's Exhibit 191P to help refresh your memory. I'm going to direct your attention specifically to pages 28 through 31. Tell me if that helps refresh your memory as to the three witnesses that you met.
Christopher May is the victim, and then, yes, Officer Hutchins and Campbell and Barron.
Okay. And first with Officer Hutchins, what was Officer Hutchins' first name?
Dwight.
Okay. And what about Officer Campbell?
Officer Campbell, I don't remember his first name.
Okay. And what about, you said that one was Barron?
Yes, his name is Jonathan.
All right. And you said you met with them at Perimeter Mall. Where in Perimeter Mall did you meet with them?
In the security office.
And while in the security office, were all four of them together, the victim and the three witnesses?
Yes, they were present.
What do you recall about your initial interaction with Mr. May, Mr. Hutchins, Mr. Barron, Mr. Campbell while in security?
They seemed concerned about the threat and the possibility of it being carried out. They didn't.
Hold on.
Confrontation clause.
You're right, it's an observation.
It's not an observation.
You're right.
I'll sustain the question as to form. Why don't you rephrase?
What was your observation of the individuals as you were speaking with them?
I observed them to be concerned about the possibility of the threat being carried out, and that they were wondering and asking questions about what we might.
I'm over the objection.
Go ahead.
They were asking about what was going to be, what were the next steps, what was going to happen after we met.
And while you met with the four individuals, did you instruct them to do anything?
Yes.
What did you instruct them to do?
I instructed them to individually make statements or write statements as to their recollection of the events,
Why did you ask them to each write their own statement?
because that would be their individual. It wouldn't be one collective statement. It would be that they individually stated what they saw happen or what they recollect of the event.
And did you tell them how to write it? Did you tell them to type it, to handwrite it? Or?
No, well, I instructed them to handwrite it, but then they came back and they typed it.
So you gave instruction for hearing, but then they typed.
Objection, asked and answered, and moved.
I sustain the objection. Just ask and answer.
When you first met with them, did they give you their statements on that day?
No, they did not.
Once you gave them the instructions to write a statement out, what did you do? Did you leave?
I did, yes. I left.
And do you recall when did you go back to get the statements?
I did.
When did you go back to get the statements?
I came back. It was I would say it's about a day later. It's a day and a half.
And when you went back to go get the statements, where did you go?
Back to the security office.
And what happened once you went back to get the statements at the security office?
They each gave me their statement from their hand to mine. They directly gave it to me.
When you say they each gave you their statement, explain.
I asked them each for their statements, and they took the paper and handed it to me.
So Mr. May gave you his statement?
Correct.
Did Mr. Hudson give you his statement?
Yes, correct.
Did Mr. Barrett give you his statement?
Yes.
And Mr. Campbell gave you his statement?
Yes.
Did you ask them any questions about their statements?
No, we did not.
And I think you just testified when they gave you back the statements, were they handwritten or typed?
They were typed. Hand signed, though. They had handwritten signatures. Mm-hmm.
Once they gave you their statements, did they appear as if they were forced to give you the statements?
No.
Did they appear as if they didn't want to give you the statements?
No.
Permission to approach?
You may.
I'm going to show you what's been marked as State's Exhibit 190P. Do you recognize State's Exhibit 190P?
Exactly the same as you showed.
That's the same 190P from earlier.
I recognize it as Mr. Dwight Hutchins' statement.
And is that the same statement that you received from Dwight Hutchins' hands back in July 2015?
Yes.
And does that appear to be the type statement with the signature of Dwight Hutchins that you received from him back in July 2015?
Yes.
You're in this time state like the tender State's Exhibit 190P into evidence.
Any objection to states 190P?
Yes, sir. It's a written document. It would not go back with the jury, and there's no question, just identifying something.
Can you all approach a second, please? Okay, it's talk radio.
Can't hear him, Judge.
Okay, I'm going to overrule the objection of Mr. Steele. I'll notice continuing.
Permission to publish, Your Honor?
You may, madam.
Okay. Now, Mr. Sergeant Lenahan, I want you to read it from top to bottom.
Just a statement, madam.
Just a statement.
Just a statement. The entirety of it.
Okay. On July 7th, 2015, at 16:40 p.m., I, Officer Hutchins, approached two black males about to go down the center court escalator on motorized mini Segways. I spoke to both the males and advised them that they could not ride the mini Segway in the mall due to mall policy, and it's very dangerous to get on the escalators riding them also. The two males ignored me and the mall policy that I quoted them. I then called dispatch to advise them of the situation, and I also told them to call Dunwoody. Director May then called and asked for my location. He met me at the lower level Macy's in front of Champs. We waited on the two males to come out of Champs. As they exited the store, Director May spoke with them and also quoted the mall policy to them again, and they also ignored. They kept riding the Segways to the center court and was saying that we are leaving, as Mr. May was telling them that they needed to get off the mini Segways. They went on the escalator on the Segway and out upper level Main. Mr. May was still trying to get their attention while advising them of the mall policy. Outside upper level Main, they were greeted by Supervisor Barron and Campbell, who also quoted mall policy to them, and they ignored them also. At East Main Valet, where they were parked, Mr. May was asking them to leave the property, and one of the males shouted out that they would come back and shoot Mr. May in the face, and from there, Mr. May told dispatch to call Dunwoody Police.
And was that then signed by Mr. Hutchins?
Yes, it was.
And what's the date of the signature?
7/7/2015.
And again, this is what Mr. Hutchins handed to you.
Yes.
All right. Now, when Mr. Hutchins gave this to you, either on the day you picked it up or when you first gave him the instructions, did he appear as if he understood what you were asking him to do?
Yes.
Did Mr. Hutchins ever indicate to you or give you any indication that he was forced to write this statement?
No.
When he handed it to you, did he give you any indication that that was not his words or what he was relaying happened to him?
No.
When you initially gave the instructions to write your statement, did Mr. Hutchins ask you any questions? Do you remember him asking you any questions about what to write in the statement?
I don't know. No.
Now, once you received all of the statements from Mr. May, Mr. Hutchins, Mr. Barron, and Mr. Campbell, what did you do next?
I left the location.
Did you eventually take out charges for Mr. Jeffery Williams?
I did.
And what charges did you take out?
One count of terroristic threats.
And why did you take out the terroristic threats warrant?
I had corroboration of...
Basic. I'm overrule the objection.
I took out the threat because I had the corroboration of three witnesses that heard the threat, and the threat is to harm or seriously injure or kill Mr. May.
Use the word corroboration. What does that mean?
The three witnesses all had the same recollection of what happened, and they stated that to me.
If you did not have corroboration, would you have taken out those warrants?
No.
After taking out this warrant, as it relates to solely the terroristic threats portion of it, did that include your involvement in the case?
Yes.
No further questions.
Cross.
Oh, before you begin, I'll admit, it's the state's 190?
Yes, when I.
I'll admit with the objections that were made.
Good morning, sir.
Morning.
I'd like to ask you some questions. Start with corroboration, okay?
Okay.
Ladies and gentlemen, the jury, the three witnesses you're talking about is Mr. Hutchins, correct?
Yes.
Mr. Barron, correct?
Correct.
B-A-R-R-O-N, if that sounds right.
It sounds correct. I'm not sure.
And Mr. Campbell, C-A-M-P-B-E-L-L, fair?
Yes.
Tell the ladies and gentlemen of the jury whether any of those witnesses said that Mr. Jeffery Williams, young thug, person in the back seat, person in the front seat, made that statement that you're telling the jurors.
Objection, compound question.
That's the standing question. You can just break it up, Mr. Steele.
Did Mr. Barron say that Jeffery Williams, young thug, or a specific person identified in any way made that statement that we're talking about to corroborate Mr. May's statement that it was said by Mr. Williams?
No, they did not.
Did Mr. Campbell say in any way that it was Mr. Williams, young thug, or, a description of this is the person sitting here wearing this, looking like that, made that supposed statement?
In their statement or just... Okay. Not in their statement.
Okay. And did Mr. Hutchins, the jurors already saw it, did you read it to him? He also said one of the people said that, right?
Correct.
And that was consistent throughout, correct?
Correct.
Now, when you explain to the jury, I think you remember meeting with these three people and Mr. May in a room. Is that what you said?
Correct. The security office.
Okay. And do you know what was discussed, if anything, about this incident, about what supposedly went on and what people heard before these statements were written between the three of them or before that?
No, sir, I don't.
You wouldn't have any knowledge?
No, sir.
And when you were asked by the district attorney whether you took out a warrant for terroristic threats, you're aware the district attorney office in DeKalb County dismissed this case, correct?
Yes.
For no corroboration, correct?
Objection, speculation.
I'll sustain the objection.
Do you have it in your report in front of you?
That is what that says.
I couldn't hear you. I apologize.
It says lack sufficient corroboration that the threat would be consumed or consummated.
And it's me. I'm confident it's me, but I couldn't hear the end. You said it lacks sufficient corroboration, then you started to say something.
I'm just continuing to read. It said was conditional and lacks sufficient corroboration that the threat would and could be consummated.
And that was pretty much your end of the saga in this incident, correct?
Yes.
Just so the jurors know, there's no recordings or anything that you could share with them about meeting with any witness. Is that fair to say?
No, sir.
Am I correct?
You're correct.
Thank you, sir.
Yes,
Thank
sir.
you, Your Honor.
Any other examination? Any further questions from the state?
Sergeant Lenahan, Mr. Steele asked you about whether or not in any of the witness statements did they mention Mr. Williams or Young Thug.
Mhm.
You recall that?
I do.
With all of the statements, did they indicate how many males made that statement? They said one male, two males. Do they indicate?
I think they did say one of the males makes the statement in each one, but they didn't specify.
Okay, just confirm that they say one of the males.
Basis. I sustain the question.
Given what Mr. Steele asked you, in looking at any of those things, would it help refresh your memory as to how the witness identified the individual who made the threat about shooting someone?
I'm sorry, can you repeat?
Sure. Looking at the three statements, would it help refresh your memory as to how they identified the person who made the threat?
They identified the man who made the threat by looking at him and then speaking with the manager at Champs, and then the photos on the internet is how they identified exactly who he was. The manager at Champs said that it was.
I sustain objection.
When each of the individuals who wrote their statements, you had to read
Yes, ma'am.
witnesses.
Yes, ma'am.
Did they indicate if it was only one of the males that made that statement about shooting him?
Only one of the males, yes.
Only one of them.
Mhm.
Now, Mr. Steele asked you a lot about what the district attorney's office did. As a law enforcement officer, do you have control over how the district attorney's office disposes of their cases?
Oftentimes, no.
Oftentimes. When you took out your warrant, did you, based on your experience, take it out based on the corroboration that you had?
Yes.
And in your experiences, has the district attorney's office in DeKalb County done things opposite than the warrants that you've taken out?
Yes.
So this is not the first time that that has happened for you?
No.
I have no further questions.
Anything further, sir?
Sergeant, point to where in any of your reports dealing with what we're calling the three witnesses, Mr. Hudson, Mr. Campbell, or Mr. Barron, does it say anything about looking at a photograph, identifying Young Thug, identifying Mr. Williams as the person who made that statement? Anyway.
From the witnesses?
Sure. That's what we're
No,
talking
it's
about.
it's in the victim's written statement.
Okay, but now you say the victim, that's Mr. May.
Right.
I'm ignoring because you separated him from the three witnesses.
Well, when they went back to the store.
Matt, which of you look at the report done by Officer Stevens?
No, I'm looking at Mr. May's statement.
Okay, well, okay.
Mr. May's statement is when they went back to. Oh, I'm sorry.
Well, let's be specific. Who is they?
Okay.
You know, you can, I don't mind talking, but just instead of using the word they in Mr. May's statement, who are you?
It says, Thunder Officer Stevens arrived and together we went to Champs, where the manager of Champs, Reggie, informed us that the male who was on the device was a known rapper by the name Young Thug.
Now, that is Mr. May, Christopher May.
Yes.
According to Mr. May's statement, right?
Yes.
Officer Stevens, a co-worker of yours at that time.
Yes.
And speaking with a gentleman from Champs.
Correct.
Just want to make sure. That's the entirety, right?
Yes.
Thank you, sir. Thank you, Your Honor.
Anything further? Mistake?
No, no mistake.
All right. At this point in time, may Sergeant Lenahan be permanently or temporarily excused as a witness. All right, Sergeant Lenahan, appreciate your patience with us. I'm going to go ahead and permanently excuse you as a witness, so you're free to go about your usual duties and avocation. Just don't discuss your testimony and except the attorneys in this case, okay?
Yes, sir.
Thank you, sir. All right. All right, ladies and gentlemen, it's about almost 10 after 12. How about some lunch? All right, excellent. Okay. Ladies and gentlemen, we're going to go ahead and recess once I finish all my announcements and pronouncements to you, and ask you to come back for 1:30. Okay? Remember all of my ad nauseum admissions here at this point in time. In particular, are you okay? Are you allowed to, now that you've heard some more testimony, discuss the matter in your headquarters jury deliberation room? No, you're not. Okay, all right. And remember all the other things that I told you in terms of just your behavior up to this point in time. Do not discuss this case amongst yourselves in onesies and twosies. Don't discuss anything that you might have heard in the courtroom today until such time as the court gives you instructions on how you to consider what you've heard within the four walls of this courtroom. If anybody should try and touch base with you in any form of transmission, email, text, phone call, or otherwise try and talk to you in person, please, you need to let Sergeant Ingram know immediately and let me know. All right? Okay, ladies and gentlemen, it looks like for the after we come back from lunch, we should have a regular workday conclusion, and then we'll see where the rest of the week leads us at that point, okay? Any questions of me? Okay, all right. Enjoy your lunch, and we'll see you back at 1:30, okay? All right, all rise. He's ready to go. He's been ready. Okay, our jurors left us. You may be seated. All right, counselors, I'll see you all back for 1:30, okay? And we'll start back then. All right? Okay, we're in recess.
Going to merge their questions in here for the 2024 first question of the year. And do you have any idea of how many witnesses that we can expect here? And generally, what's this trial about?
Yeah. Well, thank you both for those questions. In terms of generally how many witnesses we have, don't forget, when we start off this trial, the judge restricted or tried to restrict the prosecutor from that 700 plus witness list down to 400, something that was manageable. But because of the stall in the case, I think we're still looking at hundreds of potential witnesses coming up. We really haven't gotten to the meat and potatoes of this case. And what overall this case is about is it's a RICO case. And so what the attorney in Georgia is saying is that this gang, YSL, has intricate criminal and some non-criminal activities that lead to the furtherance of a gang. And so it could be purchasing a vehicle that was used in a hit and run. It could be possession of a firearm, possession of drugs, intimidation, murder. All of these crimes are supposed to be intertwined towards the furtherance of the YSL gang, with Young Thug as the quote-unquote king slime, as the prosecutors believe.
Okay, excellent, excellent. Gene Rossi, I'm going to merge two more questions just to make sure that we're fair and balanced here and that you get a double whammy as well here. So we have Jerry Michael QQQ from YouTube and Mr. Mike 070 from YouTube. And here are the combined questions. How will the state tie everything together after this being such a long trial to prove RICO? And similarly, in your opinion, up to this point, has RICO been established by the state? If not, what else does the state have left?
Well, first off, what they've charged is a racketeer, influence, and corrupt organization. You need an enterprise. This gang is the alleged enterprise. And all these acts that they're going to bring into the trial are in furtherance of the enterprise and to maintain it. So to answer the question, have they proved RICO? I would say they're moving in the right direction. We just had at least two great football games yesterday. So we're moving towards the goal line, but I don't think we're there yet. Now, here's the thing. Here's my concern about having 700, 400, or over 200 witnesses. And all of us here have tried cases that are lengthy. You're going to bore the jury with too many witnesses. So the prosecution needs to be careful in selecting those witnesses that are absolutely essential to the RICO and don't cause the jury to make their eyes glaze over. So Mike's question, Jerry's question is very valid. If this trial lasts 6 months, I think that's 2 months too long, in my humble view.
Yeah, and Gene, I've also found too, when you have a really, really lengthy trial, I tried a case one time, it was 2 years in the making. You got to be precise, you got to keep their attention, but I think that if you put too many witnesses on, it looks like they're stretching, like they really don't have a lot when you're putting all these little dots together. So it's such a strategic question. Brian, let me go to you. This is Chitin Lily, I'm sorry if I'm getting that wrong, Chitin Lilio from YouTube. What does the mall incident have to do with the RICO charges?
Well, Chairman Leo, thank you for that question. I think I might have missed some of the testimony in this, so please correct me if I'm wrong here. It's, again, another aspect of RICO in that the defendants who participated in the mall incident are doing something to further the enterprise. And I think that's the difficulty here that Gene is kind of alluding to, in that how do you take all of these witnesses and tie together all of these actions to say that they're furthering the gang? And I think the difficulty in this mall incident that you're kind of alluding to as well is that, does it seem all that criminal? And the answer is, it doesn't need to be criminal to be in furtherance of a gang. I know I say this facetiously sometimes to my wife when she asks. I said, if YSL technically had a bake sale selling gingerbread cookies or leftover Christmas cookies, and those proceeds went towards the furthering the gang, then that cookie sale could technically be a RICO violation. And so sometimes it's hard to predict what is in furtherance of RICO. Sorry, you just got to see how it all connects together at the end.
Brian Buckmeyer with the gingerbread cookie, bringing a little bit of the holiday bakery into the analysis. I love it. Okay, on that note, we're going to take a quick break here on Law&Crime. We'll be back on the other end with more of your questions, so please put them in. We'll be right back. Welcome back to Law and Crime. We're catching you up on the testimony from this morning in the trial against Young Thug and the co-defendants. Court resumed today after an extended hiatus following the stabbing of a co-defendant in the case at the Fulton County Jail. The jury's been sent away for their lunch break, where they are due to come back around 1:30 p.m. Eastern Time. And while we wait for court to return, we're continuing to take our questions live with our legal panelists. If you have any questions for us that you'd like us to answer, please post your question in our YouTube chat or on social media, because we're watching and they're feeding it to me. I love this question, Gene Rossi. It implicates so much nuance about the reality of the trial world, and it's not legal. It's all about human nature. So Jerry Michael QQQ from YouTube asks, how do you think the state decides which attorney questions which witness? And let's of course say ego never comes into the equation. Never.
Okay, putting aside ego and competence, I just finished a trial. I didn't prevail. But when you decide who does a direct exam or a cross exam of a witness, it's a dance, and you have to complement each other. So you want an attorney that is going to get along with the witness whom you're calling. There has to be some chemistry. I can give you 20 to 30 war stories that illustrate that. My style, I am patting myself on the back. I consider myself very easy to get along with, and I calm witnesses. You don't want a prosecutor or defense attorney who raises the anxiety level of the witness so that they're freaking out, if you will, before they take the stand. You try to have somebody that can calm them. I think I can do it well. The opposite is you want somebody in cross that is not going to be obnoxious, but will be aggressive. And so that gets into another dynamic. Who's going to cross this particular witness? So those are things you have to consider. But who dances with the witness, whether direct or cross, is a crucial decision of a prosecutor or defense attorney.
Yeah, I just to add my own 2 cents into that question, because I really love it. It's very difficult when 2 lawyers are trying a case, especially as prosecutors, because there's a lot of you're into it. You've got a lot of heart into it. And I can remember a case where we literally debated tooth and nail who was going to cross-examine the defendant if the defendant took the witness stand. And even though we got along very well as partners or whatever, I was hungry to do it and he was hungry to do it, and we had to come to a resolution. But listen, all those things are important. What's most important is who's got the better skill set to cross-examine that particular witness. Not every witness is the same. Brian, so do you have any insights into that? Because I think that's a really good question, and I don't think that's such an easy answer. I think sometimes it literally waits, at least it has for me, until the time comes a witness is going to take the stand on cross.
What I often do, even in planning the trial, is I try to have a co-counsel who is different than I am in terms of personality, sometimes the way that I look. I often like to do trials with my good friend Anna Carlson, who's a very tall, kind of like mixed complexion, attractive woman. And the reason why I do that is because there are witnesses who sometimes the jury doesn't mind if a very large man yells at them. Sometimes I can get away with yelling at a cop and the cop will respond back and forth and we can spar. But I'm not going to do that with a female victim, for example. I may ask my co-counsel, who's a woman, and he can talk to that. The way I think about it is, who will the jury allow me to be when in front of that witness? And is that person the appropriate person to cross-examine them as a defense attorney? And so that's how I look at it.
Yeah, Gene, let's play this out, because that's a really good response that Brian's given. How you're cross-examining a witness, when I was training, saying you're not one speed with every witness. You have to understand the jury. You have to understand the witness. A lot of times you have to wait for the witness to become like a little bit of a wise person or whatever before you get into them, because it could look like you're beating them up. So your cross-examiners, and any lawyer for that matter, has to be very flexible to make sure that they're able to get data from the witness but not offend the jury. Do you have any thoughts on that?
Oh, and that's addressed to me. Absolutely. And in the case I just finished, there was one witness. There was a female witness. And I stood up, I just said my name, I said good morning, thank you for coming. And from the word go, she treated me like I was Darth Vader and I was the evil empire. Now, if you have a thin skin, you're going to take that personally, but in front of a jury, you've actually won the case or won that witness with just your introduction, because they have become a Jekyll and Hyde witness. And on cross-examination, this is the key for me, is they're going to do great on direct. If they don't do great on direct, then they really lost. But on cross, you want to puncture that professionalism, that calmness with your cross, and you have to do it in a way that doesn't offend the jury. And Brian brought up a good point. Female attorneys can do certain things with female victims that I could never do. I would look stupid if I did it. But female attorneys can do things with female victims that are appropriate, professional, and ethical, and I can't do that. And I realize that's not one of my strengths.
Okay, yeah, you have to know what your strengths are as a lawyer. I think that's very important too, especially if you're trying with a partner in a case. All right, I'm going to try to combine, Brian, two more questions again because they're kind of similar. Cavell O from YouTube asks, after such a long holiday break and with the state resuming as they left off, not really tying this to RICO, could this lose more jurors? Okay, time off, not even connected to RICO. And then Rachel Ellis from YouTube asks, how is the case going so far? Is defense cooking? Now, I'm presuming this is not about food. We're talking about, are they cooking in terms of doing a good job? So, exactly, it is the holiday season, but, I had enough to eat for cooking. So let's move away from the food cooking. What do you think, Brian?
So I'll start from the first question. Yeah, timing is an issue, but it's an issue for two things. One, this jury was told that they may be here for 6 months or so. When you take off December 11th to January 2nd or 3rd, whatever it is now, I'm still kind of on the holiday myself, I guess. That time wasn't allocated to be how long this case will extend. So you've got to think about timing on the back end. Are you going to lose potential jurors who say, I've got to go to work, I've got childcare, I've got a life, I can't sacrifice this much time? And that's a possibility of a hung jury or a mistrial because you don't have enough jurors to deliberate on the case. And then also just remembering what happened before. Now, I'm not really concerned about them remembering things that happened in December from today. I'm concerned come summation when it's 9+ maybe months. I don't know how many delays we're going to get in this case. When the prosecutor is saying, oh, you remember what happened December 1st of 2023? And we're somewhere in the middle of July or August, that's going to be difficult for them. And then in terms of the defense cooking, I think they want this case to stay with the heat on, cooking for a long, long, long time because the defense is hoping the prosecution burns the meal for the jury. They're hoping that time destroys this meal for them. I don't think they're in any kind of hurry to get this case through because the longer this draws out, the more the jury forget, the more the jury will be like, how is this connected? And I think that's a plus for the defense.
Yeah, that's really true. And I'm sure prosecutors, if they're any good, and I think they are, they're concerned about that very thing that you just brought out there. It is a really, really tough balance in a case where you have so many witnesses, so much complexity, and so much time going by for prosecutors. Okay, guys, excellent commentary. Of course, I don't expect anything different in 2023, 2022, 2024. These two guys are the best. We're going to take a quick break. We'll be back with more of your questions. If you have them, put them in the YouTube chat or on social media. We'd love to answer them. We'll be right back. Okay, the jury is currently on lunch break in the trial against young rapper and the co-defendants. They're back due in court around 1:30 Eastern Time. So we're continuing to take your questions live with our panel. If you have a question you'd like to pass on to us, please post it in our YouTube chat or on social media. Now, we can have a little fun, guys, because this is the first show of 2024. Okay, so I'm taking poetic liberty to have a good time as we roll into the next season. So Brian used an analogy before, about making gingerbread cookies, okay, for the cooking question. And so I have a question for Brian. It's not in the chat. It's a Bob Bianchi question. Brian, for a night out, fun and frivolity from me, what is Gene Rossi's favorite food to eat during the holiday season?
Polenta, isn't it?
Oh my! You got it! You got it!
Is that it?
Oh man, I'm done.
Polenta?
Yeah, it is. It's polenta.
Excelsior! Got it.
But you gotta mix polenta with something. You can't have it by itself. You have to have a sauce, a cheese, something. It can't be a standalone appetizer.
See, Brian, personally, I've always argued with Gene about this because if you have to add something to it to make it good, it's not good in the first place. But listen, I don't want to get into a war about Italian food here with Gene, of all people. Great job. Okay, guys, so let's go back to a question here that has been hot. Now, Big Facts TV is talking about the judge allowing lyrics to be used in the courtroom. Gene, I know Brian and myself talked about this the other week. I'm just curious. I haven't gotten your opinion on this. Fair game or not? And I think it could be wrought with problems, but is it fair that prosecutors are able to use these lyrics?
Absolutely, because the defense, at least one defendant, is arguing that this is not the name of a gang, it's the name of a record label. The Young Stone Life, I guess it is. So the prosecution has the right to use lyrics that show that it wasn't a record label, it was a gang. And that's relevant to the RICO and all the other things that are part of the charge.
Yeah, Brian, I before we ask you the same question, I mean, the judge did, I believe, based on my understanding, eliminate some of the lyrics. And, the judge has to make a determination as to, under the evidence rules, whether it's relevant, that's number one for any evidence, whether or not it goes to motive, intent, opportunity, plan, preparation, mistake, things of that nature. But also under evidence rule 403 wants to make sure it doesn't create undue prejudice, confusion with the jury. So the judge kind of had a middle of the road approach here. And typically speaking, I just want our audience to understand that sometimes a court could say, look, I don't think it's very persuasive, but that goes to the weight the jury is going to give that evidence as opposed to whether or not I'm going to completely not allow it. Can you talk to us a little bit about your thoughts?
Yeah, so the history of this, as people probably know from following this case, is that it happens a lot. I'm sure I've represented clients where their rap lyrics have been used against them. I'm sure we've all seen this in cases. This is where I come down on it. And it's similar to how the legislature in California has been arguing that it should be used after the YSL case, and many people like P. Diddy and Jay-Z got involved for advocating against this. If you can prove by preponderance of the evidence that these rap lyrics are actually connected to a crime, then I say by all means, go forward and use the rap lyrics. But for example, one of the rap lyrics that are being used against Young Thug comes from a song by him and Nicki Minaj called Anybody, where he says throughout the rap lyrics, I have nothing to do with that body, but I got something, so I didn't kill anybody, but I got something to do with that body. And they're trying to use that lyric to then say, well, when he purchased a vehicle for other people to then commit a murder, that is him rapping about it. And I'm thinking to myself, whoa, that is far, that's a far leap. Now, can you make that articulate argument in front of a judge and say, yes, it's relevant because he's talking about not actually committing murders, but furthering a gang to commit the murder? Sure, you can make that argument, but now you can pull in any amount of rap lyric. And in terms of the last part, in terms of 404B, and where we talked about the undue prejudice, rap by its nature, especially gangster rap that became very popular in the 90s, is full of hyperbole and other forms of lyrical analysis that is used to further the idea of violence to get more sales. And so if people are creating music to become more violent to get sales, for them to then turn around and say, well, we'll prosecute you for it as well, does have a chilling effect in terms of both the art and in terms of prejudice. I always make the argument, no one went after Bob Marley for shooting the sheriff. No one went after Eminem for all of the domestic abuse he supposedly put in his lyrics. No one went after Johnny Cash for shooting a man in Reno just to watch him die. It always happens in one genre of music, and that's where people argue the prejudice exists.
And let's just, for a full record, make sure it's clear, he didn't shoot the sheriff, he shot the sheriff, but he didn't shoot the deputy.
He didn't shoot the
Exactly.
But he didn't shoot the deputy. Okay, very good, Brian. Okay, really good question here from Tallglass from YouTube. And again, we're getting into evidence issues, right? And I really love these questions because there's a book of evidence that tells you what can get in and what can't get in. And so often people have like a knee-jerk reaction, what they think should get in, but it's not necessarily what the evidence rules say. That's why lawyers have to know the evidence rules like the back of their hand. So here's the question from Tallglass. Should the judge have stopped Mr. Hudson's testimony as he clearly had a medical impairment hindering his ability to recall? Gene Rossi.
Well, I think a judge has a lot of discretion in allowing a witness to testify because they make the determination under the rules of evidence. A judge makes a determination at the beginning whether a witness is qualified to testify. You take an oath, you're with it. You have the capacity to remember things. What this question is addressing is when a witness is saying they can't recall or they have faulty recollection, that goes to the weight, not admissibility. That goes to the amount of credence the jury gives the witness if a witness has a faulty memory, is misremembering things, is forgetting things. So those are two different things.
Right. Once again, Gene, we're talking about the difference between something being admissible as opposed to a judge saying, look, it may be weak evidence, but that's up to the jury to determine the weight they're going to give that evidence. So, but it's a very, very good question. And of course, the lawyer's job is to make a witness on the other side look as if they can't recall, they forgot, they're lying, they're fabricating, all going to the weight of testimony. Great question now. Brian, do you have any thoughts on Purple Dinosaur asking, how does the jury isolate themselves from outside influence over such a long trial?
Oh, Purple Dinosaur, I think is one of my son's favorite animals right now, actually. So thank you for the question. I have a lot of thoughts, not only in terms of the length of the case, but also the length of this break. Now, Gene kind of talked about in other situations where the judge has a lot of discretion. I understand why a judge would say, we are not going to do a mistrial after one of the co-defendants gets stabbed. We are just going to wait. But that wait from December 11th till today had Christmas, Hanukkah, Boxing Day for those Canadians and people from the UK who celebrate, Kwanzaa for those who celebrate as well, the New Year's. You're with family, you're with friends, you're traveling, you're listening to the radio. You're probably seeing Bob Bianchi and Gene Rossi somewhere at Law&Crime, and you're hearing part of their expert legal analysis. It just becomes that much more dangerous and that much more possible for a jury to hear information they're not supposed to. But again, it's a balancing act. We took so long to get to this point to pick a jury. I understand why the need to push this through, but I think this case is going to be ripe with appeals when we get a verdict, whenever that is, with did a jury hear this, did a jury hear that, whatever it may be.
All right, guys, Gene, we have some good kind of lawyer-like questions, and I'm gonna ask you is, when this kind of question is asked, it's not only relevant to somebody with a big defense background like Brian's got, but also a big prosecutorial background like you. We're all observing what's going on in that courtroom and how it's affecting the jury. That's the most important thing. So Teresa Trice from YouTube asks, how do you feel it makes the prosecutor look that a retired officer verified that his report had disorderly conduct versus a report dated years later that it was changed to assault?
You know what? Something is rotten in Denmark. I got to tell you, that little nugget and that Teresa picked up on this. That officer said when I inputted it was disorderly. And I think I did it in 2015, and I couldn't touch it once I put submit. That draws a conclusion, and defense attorneys are going to latch onto that there's confirmation bias, there's hanky-panky, and someone later on changed the narrative and altered that report. That looks incredibly bad. That is obstruction. That is obstruction classic. So the jury's going to be reminded of that during closing about that little nugget. I found that testimony, that little bit, very interesting.
Brian, I was very disconcerted to hear because I'm seeing more and more of this going on. And I go back in a day where there wasn't monitoring reports. And if you pushed the button, it logged it and it had a number associated with it. I'm seeing more and more of this creative police report writing or things changing and you get a record that says something different. When you try to drill down on it, all of a sudden nobody has any idea how the system works. Nobody, it's amazing to me. And of course, in the real world, trying to get a judge to say, Judge, we want information on the computer system, the IT, you get kind of pushback. Well, that's a fishing expedition. No, here a report has changed. And as a defense lawyer, with the skill set that you have here, to Gene's point, as a prosecutor, I'd be cringing. But in a case like this, I mean, it almost looks like they're just setting up the pieces here. This is bad.
I mean, if I'm the defense attorney here, my question becomes, come summation, who's the enterprise? Like, who's the group of people that are piecing things together to do something criminal? Is it a rap label who has ties to a community that they are trying to elevate? And this is me making an argument. I'm not saying this for any other reason, but is it a rap community of 5 people who have made it out of this community of violence and who are helping the people in their families and trying to pull themselves out of poverty? Or is it law enforcement who can't understand or seem to really give us explanations as to how something goes from disorderly conduct to assault, how a case seems to get strengthened over time and over years just by the flick of a couple of keystrokes? I think whenever you're a defense attorney, and oftentimes you find this in the middle of a trial, you don't usually see this in discovery. Whenever you see an opportunity, kind of plant that conspiracy bug in a juror's mind of something is, to Gene's point, something's wrong in Denmark or there's hanky-panky going on. That really helps a defense when it comes to a jury to say, there's not only reasonable doubt in what we do see, there's reasonable doubt in probably what we don't see based on the conduct of these officers.
Yeah, that is like such great analysis from both of you guys. And if I were the prosecutor on this case, and I did not know about this, I would be telling my people, you go down there and you find out what went on here so that hopefully I have an explanation that I can give to the jury down the road. Because to your point, if they changed this, what else did they change? It is not a good look for prosecutors. And having been one, I would not be happy about this. We're going to take a quick break. But again, if you have any questions, these have been awesome. Send it in through the YouTube chat or our other social media platforms, and we'll hope to get to it. We'll be right back. welcome back. The trial against Young Thug and the co-defendants are on break right now. They're due to be back at around 1:30 Eastern time. In the meantime, we're counting down that time with questions that we're given to our legal panel from questions that you are actually asking as you post them on the YouTube chat and social media channels here at the Law and Crime Network. Gene, a couple of questions came in. I'll try to put them together as best I can. Mania from YouTube asks, there's a couple, but they're around the same area. Haven't seen much of Miss Love in action since things went poorly with her opening statement ideas, and then follows up with, has Miss Love been moved to second chair since her dismal opening? And then another Ms. Love question is asked by Content Channel from YouTube. Is Ms. Love still the leading attorney? Now, you may not have the specifics with regard to all that, but as you recall, the opening was deemed a little bit of a disaster there. So anything with regard to Ms. Love, the prosecutor, openings, and answering those questions, have at it.
All right. Having had experience with openings by a colleague that weren't home runs, I can say that she has not been demoted. They probably gave her some frank advice on her performance, but I don't think she's been demoted. But she has eaten a couple pieces of humble pie.
Brian, let's segue to that a little bit there. I watched it, but I hate to be critical and armchair quarterbacking, but I mean, one thing they drill into your head in prosecutor world is to avoid the big boogeyman of mentioning something that implicates the defendant's right to remain silent or their right to be able to say nothing and have the case proven beyond a reasonable doubt. It is the singular number one way prosecutors get themselves into reversal trouble. And what happens, Brian, is that a defense lawyer has a free crack at a trial in a situation like that, because it may be found not guilty, but at the end of the day, at least in the courts in Jersey, and I know every place is a little bit different, anything that even intimates the burden being shifted to the defense or the right to remain silent, you can pretty much assure it's probably going to be reversed. What were your thoughts?
Oh, when I was a younger man, when that happened by a prosecutor, I would be leaping over the table, screaming burden shifting, objection, because I don't know if there's a bigger rule, to your point, that most judges hold to be true, and that is the Fifth Amendment, the right to remain silent. The idea that someone has to prove that they are innocent is such a huge idea that jurors usually get kicked off of because they say, well, I want to hear both sides. I want to know what the defense has to say. I can't judge whether or not he's innocent unless I hear from him. That's something that judges will quickly snuff out. So the fact that a prosecutor brings it in, they definitely go from the starting lineup to, I think, the sixth person on the bench, but they're still on the team, to Gene's point. But that, I think, was a big mistake and something that I hope the prosecutor never makes a mistake for again, and hopefully something that doesn't ruin a potential conviction if they do get one.
Yeah, Gene, I won't belabor the point. I mean, I've seen circumstances where prosecutors can get goaded into. That's why I always say, when you're listening to the defense attorney in their summation, do not, to the best of your ability, respond to what they are saying. If you go off script for what you want to say and where you want to be, and you start you're going to go down a rabbit hole, and that's where people start to make the mistake by saying the thing. By the way, it's not just saying it, it's even inferring if it was reasonable that the jury could have it been inferred to them that's a burden shift or violation of the right to remain silent. Got to be really, really careful with that. Gene, let's go to a practical question that's being asked here by Tall Glass from YouTube. How do you feel about the defense not knowing who the state is calling daily, as they have not yet finalized their witnesses? Now, I want to preface this. I just want to preface this first because Gene Rossi, because Gene Rossi's a Fed. That's his background, the Feds. Brian and myself come from more of the state court system. where the discovery rules, just to your point, are much more open to the defense attorneys. You get all the data the prosecutors have, and you usually get a witness list in advance. The feds, though, a lot of times have this ability to like kind of sometimes, oh, by the way, you're in the middle of a witness. Here's something that may be interesting to you, or not necessarily have to say who their witnesses are going to be, but some judges, Gene, I'm sorry, you can correct me if I'm wrong here, will require in the federal courts that the prosecutors do it. What are your thoughts?
Well, prosecutors are very fortunate that I'm not a judge. If I were overseeing a criminal case, state or federal, I would tell the prosecutors by 6 p.m. each day, business day, you have to give the next 5 witnesses in the order you're going to call them, or maybe 4. We're not going to do this blindsided stuff. And that happened in my last trial, where they did give me the list of their 4 or 5 witnesses in the order they're going to call them the next day. Now, with respect to discovery, when I was a federal prosecutor, to the extent I could, I provided open file discovery, unless it was violence, national security, things like that. But I always provided open file discovery. I didn't hold back. Yeah. I didn't disclose it the week before. Right. That's how I rolled. You know why? I want to look in the mirror every morning and say, Gene Rossi, you're a good guy.
Well, you are a good guy, but a lot of, unfortunately, your colleagues don't follow that same philosophy. I got about 20 seconds, Brian, real quick. How difficult is it to prepare with all these witnesses when you don't know who the witnesses are going to be as a defense lawyer? I got 20 seconds, Brian.
You're flying blind in the dark with one eye taken out and a stigmatism in the other. Yeah, it's horrible. It's hard. Especially when you got 4 other people, 5 other people going to cross-examine too.
Yeah, and I guess you exacerbate that when you got hundreds of people on your witness list. It's just really tremendously unfair to the defense. And as a prosecutor, I wouldn't do it either. All right, Brian, I know you got to go, but it was great having you as the first set of guests here on the Law&Crime Network. Gene and Rossi's going to stay with us. We're going to take a quick break. Don't go anywhere. We'll be right back. Welcome back to Law and Crime Network. If you're just joining us, my name is Bob Bianchi, and Happy New Year. I hope you have a great and blessed one for sure. Thank you for joining us on our second hour of live coverage in the beginning of this new year. The RICO trial of Atlanta rapper Young Thug and co-defendants resumed today after a hiatus following the stabbing of a co-defendant in the Fulton County Jail. According to Fulton County Sheriff's Office, one of the individuals, the co-defendant, was stabbed by another inmate, Willie Brown, during a fight between the two men. Judge Earl Glanville dismissed court the following day and for the rest of the 2023 year. Pretty significant delay. Rapper Young Thug, whose real name is Jeffery Williams, stands trial with 5 co-defendants accused of violating Georgia's racketeering laws and participating in an alleged criminal street gang known as YSL, an acronym for Young Slime Life. Prosecutors say Thug founded YSL back in 2012, referring to the name in his songs and on social media. Defense attorneys say YSL is nothing more than the rapper's record label. The state called another witness to testify in the 2015 mall incident involving Young Thug. This was Mark Stevens, a former police officer. Now, we're going to take a listen to some of that testimony, but for those of you who were in the preceding hour watching our question and answer, so with our great guest, that's going to continue after we have this clip and a little bit of an interview with our guest rather. And so please go to our YouTube and or social media channels. If you have a question, we'd love to answer it. We've got a couple in the queue right now. So let's take a listen to this testimony and we'll be back on the other end.
On or about July 7, 2015, did you respond to a call at the perimeter mall?
Yes, I did.
What was the nature of that call?
It was a threats call.
After you arrived on scene, who did you speak with?
I met with the director of security, Chris May.
And to your knowledge, was the person who made the threat still on scene?
No.
Were you given any vehicle information to identify the person who made the threat?
Yes, sir. It was a white 4-door Jaguar with a partial Georgia temporary plate.
Were you able to get any information with this partial tag?
No, sir. Unfortunately, there was a digit missing, so no returns were available.
Mr. Stevens, who else did you speak with to identify the person who made the threat?
After I spoke with Mr. May and I both spoke with a gentleman named Reggie. He's the manager at Champs Sports.
Without telling me what he said, were you able to, was the manager of Champs, did you identify him?
Yes, he was.
What was the name of the person he identified?
He identified the subject that made a previous purchase as a rapper known as Young Thug.
Was Mr. May able to identify the person who threatened him?
Yes, he was.
And how did Mr. May identify the person?
Mr. May did an images search on his phone and pulled up a picture where he identified that that person, the photo in the photograph, was the one that made the threat against him.
And once you learned the person's name was Young Thug, what did you do?
At the time, I was just still gathering more information. Once I was done with that and left the mall, I went back to do some. So I did some further searches to try and determine a government name for the individual known as Young Thug.
And what did you determine the legal name to be?
I was able to determine it was Jeffery Williams.
Did you prepare an incident, a report for this incident?
Yes, sir, I did.
Mr. Stevens, did you recall what the language of the threat was?
It was paraphrased. Mr. May did not provide an actual quote. He just said that Young Thug said that he would shoot Mr. May in the face.
Did you take out any arrest warrants or any other additional charges?
No, sir, I did not. I completed my incident report and forwarded it to the case investigator, and the investigator is the one that swore out a warrant.
And did that complete your involvement with this case?
Yes, sir, it did.
All right, special treat 2024. We have Michael Seiden with us. He is a reporter for WSB TV. He's out there watching all of this going down. So the first, just give us a general sense. There's probably not a lot really happening here today, but what's the vibe out there, Michael? What are your thoughts that our audience would want to know that we don't see necessarily in the studio?
Yeah, good afternoon, Bob. Happy New Year to you and your viewers. You know, it has been a 3-week break, which in my opinion has been much needed for everybody, not only the jurors, but everybody from the extra security that you see in there, prosecutors, defense attorneys, and I'm sure the defendants as well. You know, we picked up today, focusing on, again, one of those overt acts in the indictment. We're talking about an incident in 2015 that happened at a local mall here right outside of Atlanta. But what I can tell is, I mean, as you know, there are hundreds of witnesses that are expected to be called on behalf of the prosecution. So what I saw today is right when they got in that courtroom, they wasted no time getting after. We've already heard from, I believe, 4 witnesses today. But for the most part, it seems to still be that same vibe that's inside this courtroom. Obviously, there are some family and friends of the defendants who are inside the courtroom, a lot of media, but it's really just picked up as business as usual today. As you mentioned, you know, we got kind of a little bit of a late start today, so we have only gotten through a couple of witnesses before they broke for lunch, but we expect some a more compelling testimony after the break.
Michael, I was watching some of the testimony of one of the police officers in the case and was kind of, using my old prosecutorial hat or now my criminal defense lawyer hat, where his report had changed. When he submitted that report, it said one thing, and now it says something different, and he had no explanation for it. At least to me, it seemed like a pretty riveting thing, especially when the defense is arguing a lot of this stuff is manufactured and distorted and taken out of context. Did it come off that powerful in the courtroom like it did to us that were watching that?
Yeah, Bob, that's a great observation. And in fact, sitting in the press gallery, we kind of all looked at each other, a little bit surprised. Yeah, that was pretty impactful. And for people who didn't see it live, so basically the incident, there was an initial report in 2015, and then what the defense was calling attention to was that the report somehow had changed in 2022. They kind of got into it a little bit about that, but that's about as far as it went. But yeah, that was definitely one point of today's testimony. You kind of had everybody sort of just wondering what's going on.
Yeah, I mean, geez, Michael, that could have a rippling effect through the whole trial. If a jury loses confidence that prosecutors and police are accurately reporting things and not changing them, then everything that they touch could be subjected to some nefarious explanation. That just doesn't seem good. Our viewers, Michael, were asking a lot of questions about this hiatus, how long it has taken, and how many witnesses that are expected to be called. Do you think this jury is going to lose attention to this case or lose sight of the prosecution's case, or are you anticipating that these hiatuses and breaks and witnesses are necessary and the jury's paying attention?
Yeah, so Bob, let's start off with the hiatus. It was going to be planned anyway for 2 weeks that there was going to be a break over the holidays. But if you remember, we started off early. That's because one of the defendants, Shannon Stillwell, also known as Shannon Jackson, was actually stabbed on a Sunday night during a fight with another inmate at the Fulton County Jail, the infamous Fulton County Jail. And I mean, a number of things have happened, a number of deaths in custody. So he was unable to be there that Monday morning. They said, okay, let's push it another day. He still was in the hospital recovering. So we go on this long break. As far as keeping the jury's attention, obviously not able to talk to the jurors, but you have to remember there are 6 people, including Young Thug, who are standing trial right now. There is a lot of acts in this indictment, a lot of information. So I think really the challenge today, coming back from that break, and what viewers are asking is, I think that for prosecutors, they've got to remind the jury why they're here, what they're trying to prove. And obviously for the defense, they're not putting on their case yet, but they've got to be ready for just about anything. Now, one thing I will say that you didn't see during the live coverage that has been a nice change, there's been moments where Judge Glanville has really let the prosecution have it, whether they've been unorganized with some of their PowerPoint slides, or there was information that shouldn't have been on there, or, for example, the defense has complained about, you said that we don't know who's testifying. So today, when we came into the courtroom, prosecutors had a printout of people you can expect and some of the acts they're going to be looking at. So that's a change that I've seen for sure. But who knows what kind of impact this is going to have. Again, with the amount of social media coverage, you hope that these people abide by what Judge Glanville tells them, but you just never know.
Michael, you just hit something that I really wanted to get into, and I'm glad you kind of got there. So we've had a lot of questions from our audience that are curious about Miss Love and the prosecutor's opening statement. Now, we know the judges rebuked them for PowerPoint presentations, in my opinion, sloppiness, not knowing what witnesses they're going to call or not. But let me ask you, down there, what the temperature is, when she flipped the burden, if you will, onto the defense in her opening statement, kind of commented on well, they can explain to you why X, Y, and Z. In my jurisdiction, this would be almost a certain reversal if there were a conviction for commenting on the defense's right to remain silent, and that the burden always is with the prosecution and never shifts to the defense. So our audience wants to know, first off, was it as bad an egregious error as it seemed to me in an opening statement to start a case? And two, what is her role any longer in this case?
Yeah, so I missed the second part of your question, but Bob, if I heard you correctly, I believe Brian Steele, who's the defense attorney for Young Thug, if I recall, I think he had made a motion for possibly a mistrial after that had happened. And I know that they excused the jurors, and there was a meeting and whatnot between the judge and the attorneys. Obviously, they denied that motion. But yeah, that was a moment, as I try to think back to the beginning, that was November 27th. Yeah, that was a big, compelling moment. But I did miss your second question, Bob. So
yeah, so the second question real quick is our audience wants to know what's happened to Ms. Love since that time. Is she still active in this case, and if so, in what capacity?
Oh. Absolutely, yeah. She's obviously heading this up. She's extremely active. I mean, there's several prosecutors involved, but yeah, she is obviously a high-ranking member of the district attorney's office here in Fulton County, and yes, she is still active and involved.
All right. Well, Michael Seiden over there at reporter for WSB TV, always bringing the heat with this case, and I'm sure we're going to be dancing a lot more in the next couple of months. Michael, Happy New Year to you. Thanks for being on the show. Okay, we are going to take a break here, but our questions are still going to be answered because that jury's on break. So if you have any questions you'd like to be answered, I can see on my computer screen there are a couple of really good ones coming up. Feel free to put them in our YouTube chat or social media sites, and we will try to get those questions answered for you. We'll be right back. Welcome back to Law and Crime Network. We're catching you up on the case with the co-defendants that are now being charged with racketeering and various charges involving Young Thug and his co-defendants. Court resumed today after an extended hiatus following the stabbing of co-defendant Shannon Stillwell at the Fulton County Jail. Court is currently on their lunch break until 1:30 p.m. Eastern Time, and we're continuing to take your questions live and with our legal panel. If you have a question that you'd like for us to answer, please post it on our YouTube chat or on social media. So let me bring in my two guests still with us, Gene Rossi, former federal prosecutor and criminal defense lawyer, and Afi Patterson, trial attorney. Welcome, Afi. Happy New Year to you. I've already wished Mr. Rossi a Happy New Year. How are you?
Thank you. I'm fantastic. I just had a win. I got my framing right. So that's my first win for 2024.
Yeah.
Good to see you.
Well, you know, as lawyers, we don't like to say we got our framing right, at least with prosecutors, you know. So you get that, Rossi, right? The frame, you know, the person was little 2024 humor today. Okay, Afi, so we got some of our people that are putting in some really, really insightful questions here in our chat. And one of the questions from Danny from YouTube is, and this could be a very real reality, a really long trial, lots of witnesses. Who knows what can come up in a trial, like maybe somebody will get stabbed in the middle of the case. So the question here from Danny is, what happens if they run out of alternates?
Oh my goodness. So that's a question. That's a very good question, and it's something that the judge takes into account in the very beginning. I believe that with a jury of this nature, they have a significant number of alternates. And you know, correct me if I'm wrong. When you have a 12-member jury, sometimes you'd have 2 alternates, sometimes you can have 4. It just depends. But I think that it's going to be a rough situation if they do run out of alternates. I don't know that the judge would have to stage a mistrial, and I think that that's something that he does not want to do in a situation like this, because it's gone on for a while and you've had these defendants who are in custody and haven't been given a bond. So I think that, you know, that would be a nightmare situation. Great question.
Yeah, I run out of alternates. As far as I'm concerned, that's the end of the day. That's a mistrial, and that's a big loss for prosecutors. Like you said, I don't know. Sometimes you get judges that make it really tight. You try to tell them we need a lot more, and they're like, no, 14's enough, 16's enough, and then things happen, and you're down to one last one, or no alternates left over, and it could really be a nail biter. I know Gene Rossi knows that, but I also know Gene Rossi knows this. David Gaffney from YouTube says he still wants to know if the state is successful, Gene. Will the defendants in YSL as a record label lose all assets, even legitimate assets such as record sales? Good question.
Well, if they can show that the proceeds of their enterprise were used to fund the record label, then you could trace those assets. It's just classic money laundering, and you're going after substitute assets or assets that are traceable. So yes, it's possible that those proceeds of the record label could be forfeited.
Okay, excellent. Yeah. And that would be a whole procedure, right? Afterwards, I assume a court would have to go through all of that to make that kind of connection, or does a jury decide that? I assume it's a judge.
At the federal level, you can have the jury decide whether certain assets are forfeitable, or a defendant generally waives it and allows a judge to do the forfeiture rulings at the sentencing.
Very interesting. Okay, great. Afi, let me go to Teresa Trice from YouTube, and she asks, I assume it's a she, given the majority of witnesses who have testified to charges dropped for this case that are apparently brought back, let me see if I get it right. Witnesses have testified to charges dropped and for this case apparently brought back. How does that affect the trial? I think what's being asked there is that a majority of the witnesses have testified and had charges dropped or received plea agreements and may be coming back to testify. How does that affect the trial? I think that's the import of the question.
I got it. Fantastic question. And this goes back to the importance of opening statements. I think the second defense attorney that got up, he knows that we're going to have a lot of witnesses who've taken plea deals. And he said something, he talked about Fulton County, and he talked about all of the prosecutors' witnesses. He said, when they get up there, these are their men in blue. And he really emphasized how horrible a reputation that Fulton County jails are, and how you just do not want to be in Fulton County blue. And if you're faced with that prospect of being in Fulton County, you'll say whatever you need to do so you don't have to be in that Fulton County blue. So I think that, that was really good that the defense counsel said that, because that's the nugget that I've held on to even after all this time.
Yeah, I want to answer that, and I'm going to flip this one to Gene because I think it's a really good question. It really depends. I think somebody had mentioned this before, how your witness testifies, how credible they seem to be. Of course, the defense is going to attack them, that they have a motive, an expectation of benefit, they call it, in order to get a favorable resolution from the government. But many times the feds included, Gene could talk about that, use those very kind of witnesses, especially in a RICO case, in order to testify. By definition, they're involved in bad things. Gene, what do you think about using those witnesses, flipping them, and giving them light plea agreements? Do you think that they're valuable? Does it depend on a case-by-case basis? Thoughts?
It's a case-by-case basis, and I'll give you a couple examples. I had one drug trial, organized crime and drug trial, where we had two witnesses that pleaded guilty to perjury before a grand jury. In our trial jury, the jury loved them. They admitted they lied. They admitted why they lied, but their demeanor and the way they explained things, and that their testimony was corroborated, the jury believed them and they were found guilty. Case I just had, we had witnesses that were given immunity that had admitted they lied. I tried to attack them, but at the end of the day, it just depends on a case basis, whether a jury will believe what they say, and will they say something that is corroborated by uncontested evidence, like a document.
And Alexa Rose from YouTube, I think that pretty much answers your question. It seemed very similar about if they plead guilty and testify, how does that affect the state's case? So I think we knocked that question off as well. Afi, let me ask you, inquiring mind from YouTube wants to know, how does a judge get selected for a high-profile case? With all due respect, this judge seems overwhelmed.
It's different in every jurisdiction, but usually it's sort of, I'll just give you an example for, when I first got out of law school, when I was a public defender, it would depend on the day that, it's kind of like a lottery. If it was a murder, for example, it would depend on who was on duty, the duty judge, when the murder was committed. It really depends by jurisdiction. Sometimes jurisdictions are divided into judges who handle just arraignments, judges who handle felonies, judges who handle misdemeanors. So it's usually a lottery system. You don't get to select a judge, because you always want to have just an appearance of a neutral and detached magistrate, which is the judge. So from my experience in different jurisdictions, it's kind of like a lottery system. And it just depends on, the luck of the draw, if you will.
All right, guys, I'm going to ask each of you this question because it's deep and maybe complex, and we may have different points of view. Lisa Simpson Rules from YouTube asks, what are the most probable causes for a future appeal if the jury convicts them? There have been a number of fishy things so far, in my opinion. Afi.
I think, it was mentioned earlier, I hate to use the word, I'll just say it, the sloppiness of the prosecution. I think they've slipped a number of things before the jury that they really shouldn't have. And I think the judge has been, the judge is getting a little bit more stern with them. But, just from day one, when we started with the opening and you put someone's criminal charges up there and, that was a complete violation. I think Steele got up there and did what he was supposed to do, call for a mistrial right away. But I think, and as the trial goes on, they're going to, if they don't tighten up and they continue to be sloppy, they're going to expose themselves for reasons for appeal. And, they just started out of the gate with day one with that.
Yeah, you know, and things can become cumulative too. Sometimes an appellate court will say, you know, after all of these things get that. But Afi, I want to add, you know, one thing. Let's be clear, in my opinion. You guys tell me if I'm right or wrong about this. I think that that's the biggest, most egregious error that's been done because it violated the cardinal rule of burden shifting and commenting on a defendant's right to remain silent. In my mind, that mistrial motion, though, made by the defense, which is something that they had to make. How much, Afi, do you believe they were crossing their fingers saying, Judge, please don't grant it. Please don't grant my mistrial motion. I want to preserve it for appeal, but I want a shot at trying to win at this trial.
That's how I would have felt. You know, please don't grant it. I have to do this. I have to preserve this, but you know, I think we're gonna do pretty well at this trial, because the problem that the prosecution has in this trial is, of course, losing their jurors. They're piecemealing so many things together, and it seems like the issues that they're focusing on seem so minute. So I think that you know, the defense definitely wanted to continue, but they had to do, you know, what was in the best interest of their client, which is preserving this matter for appeal.
Gene, I think you're going to agree with that comment that Afi had as well, but please opine on that. And what about the RICO law, the stretching of the RICO law, the use of the lyrics, the introduction now of all this other evidence that typically would not be admissible if it wasn't for a RICO charge? What are your thoughts about the success on appeal?
I want to address the appeal issue. My experience is a lot of appeals are result in reverses because of bad jury instruction. The elements of the crime were not properly presented to the jury. I've had a couple of reversals where, as a prosecutor, I got a little greedy and the jury instructions were a little too aggressive. So that's one area. Second area is what we've just been talking about, the burden shifting. And since you got some educated listeners here, in 1963, Griffin versus California, Supreme Court said a prosecutor cannot comment on the failure of a defendant to take the stand. Before that, they could, but then they said they couldn't. And then Doyle versus Ohio is when a defendant invokes the Fifth Amendment during an interrogation, you can't comment on that. So what happened in that opening is she kind of touched on both of those landmines, and I agree, I don't want my motion for a new trial granted. I want it denied because I want two bites of the apple. One on the opening statement and two on the hung jury or acquittal. And the last thing is evidence. Allowing evidence in or excluding it are also bases for reversals. Mm-hmm. I go back to Bianchi. Other crimes evidence. Prosecutors get very greedy on putting in other crimes evidence. And Bianchi has a case where they complimented him because he held back a little bit and didn't get greedy.
Yeah, definitely. And I think that that's where I bring in the RICO piece to it, because RICO allows so much more evidence to get in there that if it's a weak case and they get greedy on that evidence, you may be right into that situation that you're talking about. A lot of landmines for sure, guys. Okay, awesome commentary. We're going to take a quick break. Don't go anywhere. We're still waiting for that jury to come back, but please get us some of your questions on YouTube and social media and the chat sections, and we'd love to be able to answer them and appreciate you for sending them in. We're going to be right back. Okay, we're still waiting for that jury to come back on their lunch break. You know how it is in a courtroom. Hurry up and wait. But anyway, it gives us an opportunity to go through the racketeering trial against rapper Young Thug and the co-defendants, and they were due back in court at 1:30 Eastern Time. We'll wait to see when that happens. Court resumed today after extended hiatus following the stabbing of a co-defendant in the case at the Fulton County Jail. And while we wait for them to come back, again, we're taking your questions with our great legal panel. So if you do have any questions, feel free to post them on YouTube chat or on social media. Okay, so Sway, S-W-A-E, I hope I got this right. Dollars, D-O-L-L-A-Z, Sway Dollars, from YouTube says, G. Rossi, if the state loses, will the feds refile charges?
Well, practically, no. Academically, yes, because the double jeopardy clause is sovereign-centric. If a state tries a case and they lose, the feds, even if it's a similar charge, identical, because it's a different sovereign, they can try him, but practically, no.
And just for me to round that out, Afi, I don't know how you feel, but I have seen instances in which the prosecution did not go well stateside and the feds decided to pick it up, like Gene says, on it's not double jeopardy because it's a different sovereign, and typically they're different charges like civil rights violations or things of that nature. What do you think, Afi?
Yeah, it's interesting. For some people, it's very unfortunate. I remember seeing a lot when I first started out. A defendant would be thinking he's getting a win because the state would unceremoniously dismiss a charge and he'd remain in custody, but only to have the matter picked up immediately by the federal government. So it happens all the time.
Yeah, Gene, let me play this back with you because I think this is a good question, can be fleshed out a lot. I've also seen circumstances and been involved in them where we are the ones doing the investigation, we're the ones that build the case, we're the ones that file the charges, and the next thing you know, the feds come swooping in and file their own charges, and they wind up taking the case. That did not happen here, to my knowledge, in any way, shape, or form. This doesn't seem like the kind of case, if the government loses it on stateside, that the feds are going to want to pick up. A lot of witnesses, a lot of tangential pieces of evidence, and we know one thing about the feds. They never want to charge a case that they could possibly lose.
They can't win.
And you are absolutely right on that. There are a lot of prosecutors at the federal level who have an affliction called timidity. But here's the thing. I would say that given Afi just hit on a nail on the head, I think there's no sense that they're waiting in the wings. The feds are waiting in the wings. I call it like a blister. They show up when the work's done. Once the state folks do all the work, they say, oh, we'll take it. That's happened. I don't see that occurring at all. And the main reason is this is a long trial, a lot of witnesses, a lot of transcripts that a prosecutor at the federal level will have to eat inconsistent statements. It's just a hot mess. So they're not going to go near it.
Funny, Gene, I never told you the story. I had one where we investigated for many months a bank robber who had robbed the plethora of banks, and we were going in to make the arrest. We did the right thing to call our partners and say, hey, I want to let you know we're going in and make an arrest. And our guys went and brought the guy out, and the next thing you know, a federal agency grabbed the guy and said, thanks very much, and they took him away and charged him. And we were like, literally took him out of the hands of law enforcement. That's how it can get. Okay, Afi, if the state loses, will YSL, and this comes from Purple Dinosaur, be able to be compensated for their loss of revenue?
So no, that would be a civil matter, and this is a criminal matter. I think the only way that I could see some type of claim if there was some sort of malicious prosecution. I don't think that that's anything that's viable here. So I would just say no. I don't. Purple Dinosaur. That's a great question, but I can't see it. Gene, Bob, maybe you guys can help me out with that.
Yeah, I personally, Gene, I'm not going to see that. Prosecutors are given a tremendous amount of immunity and discretion, and that would have a significant chilling effect unless they could show there was a custom or practice, a policy of malicious prosecution, false arrest or something of that nature, which is very hard to prove. What do you think, Gene?
Well, I had to settle the case. if at the federal level, if you bring a case that is in bad faith or it is frivolous or both, and you have an acquittal or there's a dismissal, there's a federal statute that allows you to get attorney's fees. It's very hard, it's very difficult, but that's one remedy. But I don't see that here.
Yeah, and just to round that out, the statute you may be referring to is 42 U.S.C. 1983 and 1988. That is the civil rights statute, which again, if you are found not guilty as a favorable determination and you could show that that injury was a result of a custom, practice, or policy, those are the real words, based on a decision named Monell, then you have a shot at it. But they're entitled to all sorts of qualified immunity. It's a very, very difficult prospect. But great question. Afi, does the prosecution have a case for witness tampering based upon a defendant being stabbed in custody? And that comes from 23F23 from YouTube.
Okay, so I'm assuming this is about the Shannon Stillwell Jackson issue. So you would have to do an investigation on the young man who allegedly stabbed him, and you'd have to look into, were there orders given? What is the reason? Was it just the result of a dispute in-house? There are just so many things that they'd have to look into. I think that if there was a case for it, that would be, they could do it. But for me, I would wonder if they could use that evidence to show that Stillwell is a part of a gang and it's witness tampering, and it was maybe done by one gang member against another gang member. So I think that could help the prosecution in that way.
Yeah, I was thinking the same thing. Gene, this is an extremely deep and philosophical question, so be careful about how you answer it. Danny from YouTube says, since this case will drag out, should the judge respect the court's time more? And the reason I say it's deep philosophical is that the judge really is the court. But but not really. The judge is, but isn't. What do you think?
I'm a little confused by the question. Could you repeat it, please?
Yeah, since the case will drag out, should the judge respect the court's time more?
You mean respect the court's schedule? Is that it?
I think so, yeah.
Okay, let me tell you this. I know both of you have been in front of judges. I've said this many times. Judges guard their schedule almost as much as their own family members. It is a precious commodity. So at some point in time, probably March or April, this judge who I'm looking at right now, he's going to say, listen, I have a schedule. The jury has a schedule. I'm going to rein these prosecutors in, and I'm going to cut this trial by a month, maybe 6 weeks. There will probably be a moment in this trial when he does that. And I can't wait till it happens, because I don't care what kind of case it is. It shouldn't last 6-7 months.
Yeah, for sure. But like they say, you dance with the one you brought, Gene Rossi. Okay, we're gonna take a break here in a long crowd. That's my advice for 2024. We'll be right back. Okay, the jury's still out in the racketeering trial against rapper Young Thug and co-defendants. They are due to be back at 1:30 Eastern Time. We're waiting, but we are answering questions from the audience. So, Afi, let me go to Alexa Rose. How are I think we talked about this a little bit earlier, but those who pled guilty, how is that going to affect the state's case?
So again, I kind of mentioned already about how we had the second defense counsel on an opening. He kind of already has planted the seed that these witnesses are going to be witnesses who are in Fulton County blue, and basically they'll say anything to not have to wear the Fulton County blue and to be free. So he's kind of planted a seed already to kind of discredit these witnesses' testimonies. But again, as Gene mentioned, sometimes jurors love what I call snitch testimony. It just depends on how they answer the questions, if there's corroborating evidence, and how they present themselves. So it really just depends.
And let me ask Chanel Holback, and let me go to you, Afi, on this as well. Is there any overwhelming evidence against Williams, like something heavy, quote unquote, murder, assault, felony possession, something that would be so-called RICO?
You know, that's what they're alleging. We haven't seen anything yet, but we've got, again, hundreds of witnesses. But it's not, you don't need the heavy hitters. You don't need the murders. You don't need the armed robberies to be considered RICO. Any act in furtherance of the criminal enterprise can be considered RICO. And I think that's what the prosecution is banking on. They're presenting all of these small acts and saying that, hey, this is RICO. All of these things are going toward the furtherance of the criminal enterprise. But you're going to have to explain that to a jury who, like, you're a jury member, you're a member of the public, but the jury, they think the same. We're all regular people. They're not going to understand that these tiny little acts are in furtherance of a gang. Like, we'll take the mall incident. You know, any jury member can discount that and say, hey, these are just people who don't know how to act in public, you know, don't have the best home training, you know, or we're young at the time, we're silly at the time. You know, I don't know how this is going toward a RICO. So it's going to be interesting to see how the prosecution wraps that up, because most people associate RICO with heavy hitting crimes and violence, or, you know, big drugs, big robberies, big murders.
Gene Rossi, you're a former federal prosecutor where RICO first came into existence, specifically with regard to the organized crime with mafia, and very, very, very effective tool. Some have questioned the use of RICO in charges like this. Does it set a precedent in your mind? And in your mind, does RICO apply, and are the facts here to prove a RICO?
I think focusing on this case, I think you have a quasi-enterprise, but I don't think you have a full-blown enterprise. And is that enough to persuade a jury? You have a lot of, you know, interrelated dots. You have the mall incident. And Afi brought up a good point. Is this a person at the mall that's just having a moment of immaturity and recklessness? Or is this actually connected, and is it directed towards maintaining, promoting, and enhancing an enterprise? That's the key. Are they throwing in overt acts, I call them overt acts, RICO acts, that are wholly attenuated and disconnected, or they are part of a montage and a final mosaic? And that's going to be what the prosecution has to do in their closing, and show that it's a mosaic, not some box of pieces of a puzzle that are unrelated.
Well, DC71 Gene from YouTube wants to know that if these RICO charges in Fulton County are in fact successful, would it set a precedent?
I don't think so, and I'll tell you why. RICO cases are very hard. They're laborious. They last long. I don't care if it's the federal level or the state level. So it's not going to change the desire of prosecutors to use RICO or to stand down. If there's a case for RICO, they will charge it. It won't have anything to do with this case. I will say this.
Everybody's present and accounted for.
Thank you, Sir Ingram.
food cart.
All right, councils, before we go ahead and bring in our jurors, just to let you know what I'm going to tell them, I have some unrelated matters I got to take up just for about 30 minutes at 3 o'clock, so we're going to break right before 3, come back about 3:30-ish, and we'll see where the day leads us at that point in time, just so you know, okay? All right, unless there's anything else I need to take up with you all, I'll summon our jurors at this point in time.
All right, from the jury.
All right, ladies and gentlemen, please be seated.
All jurors present, count forward.
All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, we're going to continue with the presentation of the state's case. Let me just kind of just tell you where we are going to head for the afternoon. We are going to take about an hour's worth of testimony. I have some unrelated business about 3 o'clock I need to take up for about 30 minutes. We'll come back, and then we should work somewhere around the 5 o'clock hour thereabouts, and that'll be the conclusion of our first workday, okay?
Yes, sir.
All right, okay. State, summon your next witness, please.
Thank you, Your Honor. The state called Richard Randolph.
All right, summon Mr. Randolph, please. Mr. Randolph, good afternoon. So if you would please approach the witness stand. Once you get there, turn and face Sergeant Ingram and be sworn as a witness, please.
Raise your right hand. You swear firm testimony you give the truth, the whole truth, nothing but the truth.
I so swear.
Have seen. State, spell your first and last name for the court.
Richard Randolph. Richard Coleman spelling. Randolph, R-A-N-D-O-L-P-H.
And good afternoon.
Good afternoon.
Where are you employed?
I'm currently employed with the Fulton County District Attorney's Office.
And how long have you worked with the Fulton County District Attorney's Office?
Approximately 2 years.
And what is your current job title with the Fulton County District Attorney's Office?
I am currently the Executive Deputy Chief of Investigations.
And what are your job duties as the Executive Deputy Chief of Investigations?
As the Executive Deputy Chief of Investigations, I am the number 2 amongst the investigators. I assist the chief with the day-to-day operations of the office and whatever needs may be. I supervise the deputy chiefs along with a team of called the High Profile Difficult Witness Task Force, which is HP+.
And prior to working at the Fulton County District Attorney's Office, were you employed?
Prior to, I was the chief investigator at the DeKalb County Solicitor General's office.
And how long have you been in law enforcement?
Approximately 25 years.
And are you post-certified?
Yes, I am.
I want to direct your attention to this current case. Are you a part of the investigative team assisting with this current case that we are in?
Yes, I am.
And as a member of this investigative team, what are some of your job duties and responsibilities?
I supervise the investigators that are assigned to this team. We collect evidence, we interview witnesses, we locate witnesses, and anything and any investigative needs that are needed with this case.
I want to direct your attention to December 10th, 2023, where you asked to locate and subpoena an individual by name of Dwayne Hutchins.
Yes, I was.
And were you able to subpoena Mr. Hutchins?
Yes, I was.
Where did you subpoena Mr. Hutchins?
I located his home and I subpoenaed him in his living room.
And was he present when you went to his home?
Yes, he was.
And while at his home, did you speak with him?
Yes, I did.
And did you speak with him about his testimony, what his testimony would be?
Yes.
And if you could tell Jerry briefly about your interaction with Mr. Hutchins while at his home on December 10th, 2023.
While at his home, they was very nice and cordial. They invited me in. We went inside, and I told them why I was there, and I told them that I was there because of part of this case. And to refresh his memory, I showed him his statement, and that's why I was there. And he looked at the statement.
And I'm going to show you what's already been admitted as State's Exhibit 190P. Showing you, I believe, it's not on your screen, so if you can turn around to the screen above.
Yes, ma'am.
There's a statement. Is that the statement which you showed Mr. Hutchins on December 10th, 2020?
Yes, it is.
And once you show Mr. Hutchins that statement, tell the jury about your interactions with Mr. Hutchins as you showed him that statement.
First, I showed him the statement, and I was using my phone, so I blew up the bottom portion where the signature. And I asked, "Is this your signature?" And Mr. Hudson said, "Yes." And then I proceeded to read the statement to him.
And did you read the statement verbatim as it is on, as it is on the actual statement?
Yes.
And when you read him the statement, what happened?
When I read him the statement, he was familiar. He remembered this statement. He said he did not type it, but that's his signature. And he told me that he was okay with, he remembered everything verbatim except the last lines of the statement. He did not agree with the last lines of the statement.
And what were the last lines that he said that he didn't remember?
Mr. May was asking him to leave the property, and one of the males shouted out that he would come back and shoot Mr. May in his face. And from there, Mr. May told dispatch to call Dunwoody Police. He was vague on that part. He said he did not remember that part. He remembered everything else, but not that part.
Just the last sentence?
Just the last sentence.
When you asked him about his signature, what was that interaction? Solely about his signature?
He was clear that was his signature.
Was there any explanation that was his old signature and not his new signature?
No, he took one look at it and said that was his signature.
Now, you said you read him the statement. Did he ever read the statement himself?
I saw his eyes moving, but I wasn't, I'm not sure that he actually, read it verbatim.
Was it a point where you handed him your device for him to look at the statement?
I held it up to his face and slowly scrolled down the statement.
And after reading his statement to him, was there any other interaction regarding his coming to testify?
He was served a subpoena.
And was that?
Yes.
And was this interaction recorded?
No, it was not.
Course indulgence? Outside of the last line, because I think you said that he didn't know where that last line came from. Any other part of the statement that he said that he did not write that?
He was in agreement. He was in agreement with the entire statement except the last line.
But he acknowledged that after that last line, that was his.
Objection, meeting.
Sustained.
However, after that last line, is his signature after that last line?
Yes, his signature is after the last line.
I have no further questions.
Cross. All right. Any cross?
I don't have any questions.
Okay, all right. Can we permanently temporarily excuse Investigator Randolph?
Permanent, well, temporarily.
All right, Investigator Randolph, I'm going to temporarily excuse you as a witness. Please don't discuss your testimony with anybody except the attorneys in this case, okay?
Thank you, Your Honor.
All right, thank you, sir. All right, call your next witness.
State called Officer Cogdell to the stand.
What's his last name, Ms. Sawyer?
Cogdell, C-O-G.
Cogdell?
Yes, L-L. And Your Honor, we'll be starting a new at 9.
All right, Officer Cogdell, good afternoon, sir. Sir, if you would please approach the witness stand. Once you get there, if you would turn and face Sergeant Brown to be sworn as a witness before you sit down, sir.
Please, right here. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I'm seeking to justice to the microphone. State your first and last name. Spell them both, of course.
So, first name is Curtis, C-U-R-T-I-S. Last name Cogdell, C-O-G-D-E-L-L.
And Officer Cogdell, where are you employed?
Atlanta Police Department.
And how long have you been with the Atlanta Police Department?
A little over 15 years.
And where are you currently assigned?
Zone 3.
And where's the Zone 3 area?
South side of I-20, all the way down to South Central.
What's South Central?
Like one into Hateville.
Okay. And how long have you been assigned to Zone 3?
A little, about 5 years.
And tell me a little bit about your work history within that department.
My career, I started out in Zone 4 as a patrol officer, which is the west side of Atlanta. From there, I went to the Zone 15, and then from there to Apex K9 unit, and then to Zone 3.
And are you post-certified?
I am.
And were you post-certified September 2019?
I was.
Direct your attention specifically to September 25th, 2019. What unit were you assigned with?
What unit?
Yes.
Zone 3 patrol unit.
And just tell the jury a little bit about your job and your responsibilities as a patrol officer.
Patrol officer, we respond to 911 calls. You try to help reduce the crime by 5%, and traffic accidents, stuff like that.
And as a patrol officer in Zone 3, are you assigned to a certain beat or a certain area within Zone 3?
Assigned to a beat.
Okay. And back in 2019, what beat were you assigned?
309.
And where is beat 309?
It is south of 166 all the way to Cleveland, right there by 75 if you're going east on Cleveland, or 85 if you're going west on Cleveland.
And is there a certain
Say that again, I'm sorry.
Is there a certain roadway, is there a major roadway that sits within beat 309?
It is. There's two. You have Metropolitan, and then you have Cleveland. Parts of Cleveland, right?
Got permission to approach?
You may.
And I'm going to show what I believe all defense counsel may have, which is a copy of our exhibits. I'm going to show you what's been marked as exhibits 28 and 29Q. Do you recognize exhibits 28 and 29Q?
I do.
And how do you recognize exhibits 28 and 29Q? 28 and 29Q?
Well, it's part of my area that I patrol.
And is that a fair, accurate depiction of a portion of the area that you patrol within Zone 3?
It is.
And is that a fair, accurate depiction of the area that you control back in 2019?
It is.
Your Honor, this is kind of state like the 10 exhibits 28 and 29Q.
Any objections to states 28 or 29Q?
May I just approach Ms.
You may.
Are you going to move to civil order?
Okay. For the most part.
Any objection?
No, Your Honor.
Hearing none, 28 and 29Q were admitted and may be published as you see fit.
Thank you, Your Honor. And Your Honor, of course, that screen is not on. I didn't anyone from tech just says Zoom, but it's sure. I apologize. The witness screen is not on. It just has Zoom. It doesn't have the images on the screen. So at the break, if you could.
There's a reason that one's been disabled, so you're gonna have to use the other one.
Okay.
Okay.
Thank you.
And he can get up and relocate himself if he'd like to. Okay.
Okay. Thank you for that. All right. If you can just orient the jury, and if you need to stand, you can, to what we are seeing as State's Exhibit 28Q.
Say that again?
If you can orient the jury about the map location in 28Q.
Yeah, Metropolitan, you have the Cleveland area.
Okay, and on 28Q, where is Metropolitan?
It is, it runs north and south of Cleveland. There it says 41.
Okay, and when you say 41, is what we're referencing?
Yes.
All right, and you just referenced Cleveland Avenue. Is this what we're discussing?
Correct.
Okay. Now, where would your beat, or where is beat 309?
309 would be...
You can step down if you need to. Okay.
309 is Cleveland from 75 going westbound. So you would have Metropolitan.
Going this way?
Correct.
All right.
And it would stop right there at Springdale going north.
Okay, so this block here.
Yeah, up to 166.
Up to 166. So this square is 309.
Correct.
All right. And back in 2019, that square was your general beat of 309. Okay. Now, taking back to September 2019, did you have a certain shift in which you worked?
Yes.
What was your shift?
Evening, which is 2 p.m. to 10 p.m.
And is that your current shift now?
It is.
Have you worked any other shift while in Zone 3 outside of the evening?
No, ma'am.
I want to direct your attention specifically to September 25th, 2019. Were you working that day?
I was.
And were you working the evening shift as you just testified to?
I was.
And where were you? Were you on patrol?
I was.
And where were you on patrol?
That day I was posted up right there in Metropolitan and Peg Road.
And you said Metropolitan Peg, right here?
Correct.
All right. And is there a business location at Metropolitan Peg?
It is. It's a storage facility.
All right. And coming southbound on Metropolitan, would the facility be on the right-hand side of the street or the left-hand side?
If you're coming south, it will be on the right.
All right. And were you Where were you within that facility?
I was sitting right there at the entrance of the parking lot to come into the storage.
And why were you sitting there?
They had several complaints about people breaking into the storage unit, so I was just patrolling that little area.
Okay. And as you were patrolling that area, what, if anything, happened?
I observed a red sedan traveling southbound on Metropolitan.
And what, if anything, did you notice when you saw the red sedan traveling southbound on Metropolitan?
I observed the driver dancing around in the driver's seat, and as he passed me, he wasn't wearing a seatbelt.
Okay. And let me ask you this. When you were sitting at the Q Smart, were you facing, was the front of your car facing Metropolitan?
It was facing in front of Metropolitan.
Okay. And do you recall what kind of red vehicle it was?
It was a red Nissan.
All right. And you said you saw the driver dancing around in the
Correct.
Right. Did you see anyone else from your vantage point at that time inside the vehicle?
There was nobody else in the vehicle.
Okay. As you saw the individual dancing around your vehicle, what if anything happened next?
Say it again?
Once you saw the driver dancing around in the vehicle, what if anything happened next?
So as soon as he passed me, I noticed that he wasn't wearing a seatbelt, so I immediately got out in traffic to get behind the vehicle.
Okay. And what happened once you got behind the vehicle?
Once we approached the intersection of Metropolitan and Cleveland, I activated my emergency lights to get the driver to pull over.
And did the driver pull over?
He turned on his left signal to turn into the Dollar General parking lot.
And where's the Dollar General parking lot?
It sits on the corner, east corner of Metropolitan and Cleveland.
All right, looking back at our map, where is the general vicinity where the Dollar General would be?
It would be right up here.
Right here?
Yes.
Okay. And what happened once the vehicle turned into the Dollar General?
As soon as we entered the parking lot, it immediately continued to the other side of the parking lot, back out onto Cleveland.
I'm going to show you what's been marked as Stacy Exhibit 35Q, which should be picture 3. Do you recognize what's the Stacy Exhibit 35Q?
I do.
How do you recognize what's the Stacy Exhibit 35Q?
That's the Dollar General right there at the corner of Metropolitan and Cleveland.
And is that the same Dollar General that we just referenced on the map?
It is.
And is that a fair and accurate depiction of the Dollar General back in 2019?
It is.
Your Honor, this time say like 10 or 6 to 35Q is that?
Any objection, states 35Q. All right, states 35Q is admitted and may be published as you see fit.
Thank you. Okay. For the jury, this is the Dollar General that we've just been speaking of. Is that the Dollar General?
It is.
And if you can just orient the jury right now to what we're seeing, where's the intersection, and what we're seeing in Stacy Exhibit 35Q.
The intersection is right there where the red light is at, so that's the main street you're looking at, that's Metropolitan, and where the red light is at, that's Cleveland. And then he enters the parking lot right there where the gentleman is walking across at the entrance of Metropolitan to the Dollar General.
And is it fair to say that that gentleman wasn't there back in 2019?
No.
Okay. All right. So when he made the left into the parking lot, and if you have to stand up, you can tell the juror, show the juror what direction he walked into.
So we entered the parking lot. He immediately continued around the building to the other side of the parking lot, which is another entrance that leads onto Cleveland Avenue.
Okay. And did you go behind him?
I did.
All right. And what happened once you get to the other side of the Dollar General?
Once we get to the other side, he immediately made the left onto Cleveland. And then we were traveling eastbound on Cleveland towards 75.
And let me ask you, back in 2019, driving southbound, was there any traffic driving southbound back on this date, September 2019?
It was. Matter of fact, the light is red, so it would be a picture perfect. There was cars there, so we had to turn it to the General.
Okay. And was there any traffic going northbound on Metropolitan?
No.
All right. So once he goes left onto Metropolitan, what if anything? Left onto Cleveland. What if anything happened?
Once on Cleveland, the vehicle started picking up speed and continued towards 75.
When the car began picking up speed, what did you do?
I advised radio that I had one refusing to stop. Let her copy my traffic. and I proceed to follow the vehicle.
Okay. And what, if anything, occurred as you see the body?
I noticed the vehicle went around traffic into the center lane, and right there it says Cleveland and Forest Hill. He ran the light.
What happened? You just point to?
29Q.
All right, we'll show you 29Q. Okay, so you said that he was going around traffic.
Correct.
Show the jury the general area where he was going around.
You got Forest Hill right there in Cleveland. There's a traffic light right there. And then the light was red and you went around traffic and ran the traffic light.
Okay. So right here at Forest Hill in Cleveland, there's a traffic light at Cleveland? Mm-hmm. Is that a yes?
Yes.
Okay, and you said, did the car run that light?
Correct.
All right. And what happened once the car ran the light?
He crossing over 75, still on Cleveland. At this time, I'm approaching Forest Hills at the light. Once I get through the light, I noticed that he was in a vehicle accident.
Okay. And at this one, do you know about how fast y'all were going?
My speeds were probably around 45, 40, couldn't say about how fast he was going, because he had a little bit of distance ahead of him.
Okay. And once the accident occurred, what happened?
I noticed that he was already out of the vehicle, and then he was running on foot.
And when he ran on foot, I'm probably going to do exercise today.
Okay.
Where did he go?
There's a check cashing place and a cleaners right there at that corner, which there's a fence blocking to keep traffic from running into the buildings and stuff. So he hopped that, scared the fence, jumped over the fence, and then started running through the parking lot.
Okay. And when you said the check cashing place and the dry cleaners, where approximately on this map is the check cashing place and the
It's
dry
going to be
cleaners?
that first small square building.
Right, in this little block up here?
Yes.
Okay.
And then the cleaner's going to be the little L shape.
All right. So the first small block is the check cashing place. The L shape is the cleaners.
Correct.
There's another gray box. What is that?
That is the admission place.
The admission place. Okay. What direction did he run?
He's running kind of south in between the check cashing place and the cleaners, and then he runs behind the cleaners, in between the cleaners and the admission place.
Okay. And I believe we keep saying that he. Did you recognize the driver to be a male?
Yes.
All right. Now, as he runs through the check cashing place and runs in between the dry cleaners and the admission, what did anything happen?
He started running towards the parking lot, which is 230 Cleveland Avenue, which is that big gray square. Then he enters that parking lot still running. There's a gray sedan, possibly a 7, not for sure, that's parked there. A female is getting out of the car. As the female is getting out of the car, he pushes her out of the way in an attempt to get in the car, but there was another person in the driver's seat.
Did you
I sustain the objection as to, you can rephrase.
Let me ask you, were you observing him running towards the vehicle?
Yes.
And did you observe him trying to go to the vehicle?
I sustain the objection.
Sure, I'm sorry. What did you observe?
I observed him pushing the female out of the way to get in the driver's seat, but
That's direct, so I'll overrule the objection. You may
Did you
finish.
observe him trying to get into the vehicle?
I do.
And did you observe him trying to get into the vehicle after he pushed the lady out of the car?
Not out of the car, but out of the way.
Out of the way?
Yes.
Was he able to get into the car?
No.
What happened?
He continues to take off back running. This time he's running northbound in the parking lot, and then he crosses over Cleveland Avenue.
And at this time, are you behind him?
From a distance, yes.
And are you chasing behind him?
I am.
What, if anything, happens once he crosses Cleveland Avenue?
Once he crosses Cleveland Avenue, I heard something drop, which was later my flashlight. Kind of paused for a second, but he's running in between the Checkers and the other business.
Okay. And time for your exercise again. where is the checkers, and approximately where is the checkers at within this map here?
The checkers are going to be on the other side of Cleveland where the little T square is at.
Okay.
And then you got the block building where he runs in between.
All right. And what direction is he running into?
He's running northbound, which leads into another apartment complex.
And where's that apartment complex?
It's 2612 Still Avenue.
Okay. And at this time, do you still have sight of him?
Once he goes behind the checkers, no, I don't have sight.
All right. And do you actually go over to where, to this side where 2612 Still is?
I did.
And why do you go over there?
To see if he was hiding or laying down somewhere.
All right. And did you see him over there?
No.
All right. Did you eventually learn if he was ever apprehended?
Yes.
And where did you see apprehended?
Right there, the entrance that says Old Hateville and Colony Square.
Okay. And where it says Colonial Square, is that another set of apartments?
It is.
All right. And once the individual was detained, what happened next?
I started, checking, walking back to where they had him detained, and then I came back to where the scene was at.
And let's go back and talk about the observation of the accident.
Mm-hmm.
What type of car did the red vehicle hit?
It was a white sedan. I believe it was a Honda.
And did you see anyone inside the white vehicle?
Yes.
Okay. Do you know, how many people were inside the white vehicle?
From my knowledge, just that's one.
And within the red vehicle, did you see anyone else get out of the red vehicle?
No.
Now, on this thing, did you have body cam video?
I did.
All right. And did your body cam capture, have you been able to review your body cam?
I did.
And has your body cam captured your interaction from what you just testified to on Peg Road up until you running behind checkers at 2612 Steel?
Yes.
All right. And back then, tell us what type of uniform you were wearing.
Similar to what I have on without the outer vest.
Without the outer vest?
Yes. So all the equipment that you see up top was on my waist.
Okay.
Except for my camera.
And where was your camera?
Center mass in the middle of the chest.
All right. And did you get out of breath at some point in time?
Yes.
Okay. All right. And is that indicated on the video?
Yes.
All right. I'm going to show you what's been marked as State's Exhibit 1Q. Tell me if you recognize Exhibit 1Q.
Yes.
And how do you recognize Exhibit 1Q?
I have my signature on it along with today's date.
And what's contained within State's Exhibit 1Q?
My body cam footage.
And did that appear to be a fair and accurate depiction of your body cam footage from September 25th, 2019?
It did.
And has there been any additions or deletions to that body cam footage?
No.
Your Honor, this time the state by the State's Exhibit 1Q into evidence.
Any objection to States 1Q? All right, States 1Q is admitted, may be published as you see fit.
And Your Honor, I spoke with Mr. Shaw. We're only going to play the initial portion of the video, which captures what has just been testified to.
From when to when?
From 0 to about 4 minutes.
Okay, thank you.
Your Honor.
Sir.
May I clarify for the record? I don't object to the portion that the state is indicating that they will publish. We've had prior conversations.
Okay, thank you, sir. Yes. Yes.
Red and color. Copy, Roger, speed and your traffic. Speed 40, 45, still on Cleveland. That's 41, that's 41. Radio copy, still on Cleveland, 45 miles per hour. How is traffic lighter? Yes. What's your location? 230 Cleveland, 230 Cleveland. 230 Cleveland. Black male, plaid shirt, black jeans. Black male, black shirt, black jeans. Tempted to 44, tempted to 44. Get down, get down. Copy, tempted to 44. Tempted on right up. Right towards 191. 191 Cleveland. 191 Cleveland. You still have visual? Okay, talk to me. You still have visual? Running towards the apartments. Running towards the apartment. Any unit 59 Wisdom. First unit Wisdom, advise me. What's your location now? 309, what's your location now? Have you made it to the apartment? Where you're raising off the Cogdell? Yeah, he's back here somewhere. Back in the apartment? Received 3309, checking on you. 309, you still have visual of the subject? Negative. I lost him back here behind the checkers. Lost back behind the checkers. You okay? Yeah. Where's your copy? Break tango. Trying to have a very reasonable perimeter where you went. One unit in route to 309 location advised you are set up a perimeter in the area on Steve Avenue. Break 10 received. 5, 4, area. 305, 4 and 2 and one thing in the area. 2343 radio copy, getting the subject the same. James 103, so you got checkers on Cleveland. I'm there advising that getting the subject the same. 3309, was it just one person or
I in the video. One, what's a 41?
Accident.
Accident?
Mhm.
Okay. And then what's a 44?
It's a robbery.
And in looking, first, what we have depicted on the screen right here, there's part of stick.
Mhm.
So we're gonna use that.
Okay.
What are we looking at here? What, is this an apartment complex?
Yeah, this this is the backside, or as you saw, we walked through the cut, but this is 2612 Still Avenue.
And on the other side of 2612 Still, I'm just going to fast forward slightly to about 6 minutes, maybe about 7 minutes. And I want you to tell me what we're seeing a little bit past 2612 Still. So stop, pausing right here. What area, what are we looking at if we go straight
If you go,
towards the steps?
if you go straight up to the steps, there's a fence right here, and then on the other side of the fence is another apartment complex.
And is there a way to get from 2612 Steel to that other apartment complex if you were going to?
Yeah, if you were to run behind this building right here, further up, there's a makeshift cut or path that leads into that other side.
And was the male apprehended? And where was he apprehended?
He was apprehended right at the entrance of that next complex in O'Hateville.
And I'm going to fast forward again just slightly to about 7 minutes. And pausing right here, can you see the general area of the entrance of that second apartment complex?
Yes, ma'am.
Okay, and if you can show the jury where it is, the front part.
The front entrance is right here. There's a gate gated for vehicles to come in. That would be the entrance right there.
And earlier you talked about the cut. Do you see the cut?
Not on my camera, but it's right up in here.
Okay. All right. Now, what the individual was, the male was detained, was he brought back to where you were?
Yes, ma'am.
And where did you actually go back to?
I went back to the scene of that, where the car was ended up at.
And when the individual was brought back to your location, did you learn who the individual was?
I did.
Okay, and who was the person driving?
Shannon Jackson.
All right. And had you ever met Shannon Jackson before?
No, ma'am.
Had you personally had any interactions with Mr. Jackson before?
No.
Once Mr. Jackson was brought back to where you were, what if anything occurred?
He was saying that he couldn't breathe, stuff like that, so we already requested the ambulance to come out.
And did the ambulance come?
It did.
And did you ever obtain a driver's license from Mr. Jackson?
Not off from Mr. Jackson, but from another officer.
And was it a valid license?
No, ma'am.
And did Mr. Jackson have any belongings on his person?
He had money in his pockets.
And how much money did he have? How much money did you get from him while on duty?
Seeing the officer had counted out $5,000.
And do you know where that money was located on his person?
I believe it was in his front pockets.
Was there any additional money found on Mr. Jackson?
Yes.
Go ahead.
It was roughly $500.
And where did you find that money?
In his front pockets.
And did you find that money while on the scene on Cleveland Avenue or somewhere else?
While we was at Grady Hospital.
And what if anything happened to that $5,500?
I was turned into property.
While on scene, was there anything else done while on scene?
We inventoried the vehicle,
Okay. And when you say you inventoried the vehicle, which vehicle did you inventory?
the red Nissan,
Okay. And why did you have to inventory the vehicle?
because he was in custody.
And what did you think was going to happen with the red vehicle?
It didn't impound it, so we had to inventory, see if there were any belongings and values inside the car.
And did you find anything inside the car?
We did.
What did you find?
We found a handgun in the center console.
And what type of gun was found in the center console?
That was a Taurus, I believe, with a 9mm.
And did the gun have a serial number?
It did.
And do you recall what the serial number was?
Not offhand, but
We're looking at a copy of the police report, help refresh your memory.
yes.
As to the serial number. Permission to approach?
You may, ma'am.
And I'm going to show a copy of this. I'm going to show you what's marked as 36Q. Tell me if you recognize Exhibit 36.
I do.
How do you recognize Exhibit 36Q?
This is my police report.
Is that a fair and accurate depiction of your police report for this case?
It is.
And we're looking at a copy of your police report, help refresh your memory as to the serial number of the handgun that you found inside of that red Nissan.
Yes.
Okay. Have you looked at your report?
I'm looking for it. Yes.
Okay. And what, without reading from the page, what was the serial number for the firearm?
9FW03901.
And did you run that serial number on the time?
I did.
And what amazing happened when you ran the serial number on the time?
At the time of the incident, it was showing 905, which means not stolen.
And did you determine if Mr. Jackson should have been in possession of a handgun?
We did.
Okay. And should he have been in possession of a handgun?
No, after doing a criminal history check, we found out he was a convicted felon.
Now, I'm going to show you what's been previously marked and shown to defense counsel as Exhibit 23Q, 24Q, and then 2Q through 21Q. Take a moment, flip through, tell me if you recognize those pictures, those items.
This, what number?
23, 24 Q. Do you recognize for 23 to 24 Q and then 2 through 19 Q?
I do.
And how do you recognize, let's start first with 23 Q and 24 Q.
23Q and 24Q is the vehicle that was struck.
And then looking at 2 Q through 19 Q, how do you recognize 2 Q through 19 Q?
This is the vehicle that he was driving.
And as you continue to go through the
Okay.
And so this, looking at Stacy's exhibit 19, 20, and 21Q, was in 19, 20, and 21.
That was the firearm that was found in the center console.
And look at all those pictures I was taken before, 2 through 21Q and 23 and 24Q. Does that need to be a fair and accurate depiction of the scene on September 25th, 2013?
Yes.
And does it also appear to be a fair and accurate depiction of the weapon found in the car on September 25th, 2019?
Yes, ma'am.
Your Honor, this time it's by September State's Exhibit 2 through 24Q.
Any objection, Mr. Sharp?
No, Your Honor.
All right, states 2 through 19Q and 23 and 24Q are admitted and may be published as you see fit.
And Your Honor, I believe we also had 20 and 21Q as well.
All right. Any further objection to 20 or 21Q, sir? All right, 20Q and 21Q were admitted.
And let me ask you, before we publish these images, or some of these images, the lady in the vehicle with the 44, was any information ever received from the lady in the vehicle which called the 44 involved?
No.
Why?
When I got there, she was gone.
Okay.
Her in the car.
They left the area.
Yeah.
And in running or chasing, were you able to get the tag number of that vehicle?
No.
So were you ever able to identify or locate who that individual was?
No.
At this time, we're going to first publish 23. Now, first looking at State's Exhibit 23Q, I know we saw some of this in the body cam video, but if you can just orient the jury to where we are within this photograph.
This right here is the off-ramp coming off of 75 northbound onto Cleveland.
And in the distance on the left-hand side, is that a gas station?
It is.
And what is the address of that gas station?
221 Cleveland Avenue.
And far from the distance on the left-hand side, there's a sign. Do you know what that sign is?
That's the checkers.
All right. And on the right-hand side, are you able in this image to see the red Nissan that you observed Mr. Jackson driving?
Yes.
Okay. And using the stick, I'm sure we can all see it, so using the stick, you can point where the red car.
The red car is right here.
All right, and I might just have you stand because I might have you show someone. Looking at State's Exhibit 24Q. If you're looking at State's Exhibit 24Q and you look to the left of the screen, what direction is that on Cleveland Avenue?
If you looking left to the screen, that's going westbound back over on Cleveland, heading towards Metropolitan.
Okay. And do you see that other traffic light going to the left?
Yeah. Right. To the left?
Yes.
From this, right there?
Yes.
Yeah.
Is that the traffic light at Forest Hill and Cleveland Avenue?
It is.
All right. Now showing State's Exhibit 2Q. Is that a closer picture of what we just saw in 23Q?
It is.
Now, looking at the red vehicle, did the red vehicle hit either the tree or the metal frame there?
No, it came to a resting spot. So once it, over this sidewalk part, that's where it rested.
All right, and from here, do you see either the dry cleaning or the dry cleaners?
The dry cleaners right here.
All right, now looking at 3Q. If you can orient, what's the blue building and then that kind of brownish building that has 5?
This is the dry cleaner still, and then right here is be the admission place.
And when Mr. Jackson was running, where was he running in between?
Between the dry cleaners and the admission.
Now looking at State's Exhibit 4Q. Is that just another image of the vehicle in the front of the vehicle?
Correct.
All right. 5 and 6. Now looking at State's Exhibit 6Q. Is that the check cashing place that you've been referencing in your testimony?
It is.
All right. Now, also in your testimony, you said that Mr. Jackson hopped over the fence. Where's the fence in which he hopped over?
This fence right here.
And once he hopped over the fence, is that where he ran in between the buildings?
Once he hopped over the fence, he ran between the cleaners and the check cashing place. and then he cut, so you see the original spot right there.
All right. Looking at 7, we move forward. Move forward. Is this all the picture of the inside of the vehicle?
It is.
All right. Okay. Looking at Exhibit 13Q, what is Exhibit 13Q?
This is the center console. This is the inner lid of the center console.
All right.
And then that's the bottom of the center console where the gun was located.
Okay. And so did you have to lift up the other part to get to where the gun was located?
Yes.
All right. And is that an image of the gun that was recovered out of the vehicle?
It is.
That's just a close-up. Speaking of gun, was the gun loaded?
It was. There was one in the chamber, that's the reason why that was sitting right there.
All right. And did you recall how many was in the magazine?
If you count the one in the chamber, it would be a total of 8.
It was a total of 8. All right. And is this just a close-up of the type of weapon that it was? Is it just a close-up of the type of weapon?
Yes.
Okay.
The name brand, the serial number, and the caliber.
Okay. And it's that the gun is inside of the gun box?
Correct.
All right. And is that just a close-up of the bullet?
Yes.
All right. And a close-up of the weapon?
Yes.
All right. You can take this to the floor.
You ready to come? You ready to take it out?
All right. Deputy Ingram is approaching with what has been marked with Stacy Exhibit 22Q. I want you to take a moment and look at Exhibit 22Q and tell me if you recognize what's in Stacy Exhibit 22Q.
This is the weapon that was recovered.
Is that the same picture that we're looking at on 21Q?
It is.
All right. And does that have the same serial number in which, for the gun that we see in the picture of 22Q?
It does.
Your Honor, this time state by the tender, Stacy Exhibit 22Q into evidence.
Any objections, states 22Q, Mr. Sharp?
No, Your Honor.
All right, states 22Q is admitted and may be published as you see fit.
And now permission to publish that. Thank you. No. Thank you, Deputy. Now, I know earlier when we talked about the gun being not on file, you said that means that it wasn't stolen. If a gun had been stolen but not reported, would that still come up as not on file?
If a gun's been stolen but not reported, no. It has to be reported stolen for it to be, for you to get the hit on file.
Basis, what's the? I'm overrule the objection.
I'm just asking what does not on file mean? Not on file means not.
Right, at this point, I'll overrule the objection, sir.
Just correct, not on file means that it has not been reported.
Correct.
Did you take out warrants from Mr. Gates?
I did.
What were the warrants or charges that you took out on Mr. Gates?
It would have been fleeing and eluding, reckless driving, no license, not wearing a seatbelt, obstruction of officer, and then possession of a weapon by a convicted felon.
And after being on the scene, did you eventually go down to Brady Hospital?
I did.
All right. And after going down to Brady Hospital, did that conclude your involvement in this case?
It does.
All right. Court vote. I have no further questions.
Mr. Sharp, why don't we take our break, as I indicated to the jury? You can begin your examination when we come back, okay? All right. All right, ladies and gentlemen, consistent with the court's other directions, we're going to go ahead and recess. We should be back. If you all could plan on being back for 3:30, and then once all of you have accounted for all of you, we'll bring you back out, and we'll see where the rest of the day leads us, okay? Remember my admonitions that I've given you already, okay? All right, with that, we'll be in recess until about 3:30.
All right, for jury.
In person, not an advocate. What are your thoughts about that?
Yeah, that's absolutely right. Most people, they don't have any connection to a criminal courtroom. So when they go in, they take all of their cues from the judge. And for me, I remember the first time I saw a judge, I was a lot younger, and I was like, wow, this judge in his black robe, it's like he's floating. So they look to the judge for, again, they take their cues from the judge, and they look to him or her as an authority. So they are very connected to the judge's temperament. And especially as the trial goes on, they understand the legal language a lot more. So he's got a very, very strong influence in this matter.
Yeah, just real quick, I got about 10 seconds. The difficulty with a judge on the spot having to make rulings.
I mean, it's challenging, but again, he's going to get very, very short. He's giving them a lot of leeway. He's saying, hey, rephrase your questions. Now he's going to just straight up going to start overruling a lot of objections or sustain, move on quickly. So they've got to make it work.
Yeah, and that's what you don't want the jury to see you continually not being sustained, because that kind of attitude by the judge can make it look like to the jury that you're wasting their time. Afi, that's it. But everybody stay tuned for our regularly scheduled program, and the trial's going to continue to go on. You can find me at RBianchi SQ. Have a great week.
So, are you going to vote to see? Okay, yeah. For the most part.
Any objection? Hearing none, 28 and 29Q are admitted and may be published as you see fit.
Thank you, Your Honor. Your Honor, first of all, that screen is not. Anyone from tech just says Zoom, but it's. I apologize. The witness screen is not on, it just has Zoom, doesn't have the
There's a reason that one's been disabled, so you're gonna have to use the other one.
Okay.
Okay. And he can get up and relocate himself if he'd like to. Okay.
Okay. Thank you for that. All right. If you can just orient the jury, and if you need to stand, you can. To what we are seeing in State's Exhibit 28Q.
Say that again.
If you can orient the jury about the map location in 28.
Yeah, Metropolitan, and you have the Cleveland area.
Okay, and on 28Q, where is Metropolitan?
It is, it runs north and south of Cleveland, where it says 41.
Okay, and when you say 41, this is what we're referencing?
Yes.
All right, and you just referenced Cleveland Avenue, is this what we're discussing?
Correct.
Okay. Now, where was your beat, or where is beat 309?
309 would be.
You can step down if you need to. Okay.
309 is Cleveland from 75 going westbound. So you would have Metropolitan.
Going this way?
Correct.
All right.
And it would stop right there at Springdale going north.
Okay, so this block here.
Yeah, up to 166.
Up to 166. So this square is 309.
Correct.
All right. And back in 2019, that square was your general beat of 309. Okay. Now, taking back in September 2019, did you have a certain shift in which you worked?
Yes.
What was your shift?
Evening, which is 2 p.m. to 10 p.m.
And is that your current shift now?
It is.
Have you worked any other shifts while in zone 3 outside of what you did?
No, ma'am.
I want to direct your attention specifically to September 25th, 2019. Were you working that day?
I was.
And were you working the evening shift that you just testified?
I was.
And where were you? Were you on patrol?
I was.
And where were you on patrol?
That day I was posted up right there at Metropolitan and Peg Road.
And you said Metropolitan Peg, right here?
Correct.
All right. And is there a business location at Metropolitan Peg?
It is. It's a storage facility.
All right. And coming southbound on Metropolitan, would the facility be on the right-hand side of the street or the left-hand side?
If you're coming south, it will be on the right.
All right. And where were you within that facility?
I was sitting right there at the entrance of the parking lot to come into the storage.
And why were you sitting there?
They had several complaints about people breaking into the storage unit, so I was just patrolling that little area.
Okay. And as you were patrolling that area, what, if anything, happened?
I observed a red sedan traveling southbound on Metropolitan.
And what, if anything, did you notice when you saw the red sedan traveling southbound on Metropolitan?
I observed the driver dancing around in the driver's seat, and as he passed me, he wasn't wearing a seatbelt.
Okay. And let me ask you this. When you were sitting at the Q Smart, were you facing, was the front of the car facing Metropolitan?
It was facing in front of Metropolitan.
Okay. And do you recall what kind of red vehicle it was?
It was a red Nissan.
All right. And you said you saw the driver dance around the seat.
Correct.
Right. Did you see anyone else from your vantage point at the time inside the vehicle?
There was nobody else in the vehicle.
As you saw the individual dancing around your vehicle, what did you think happened next?
Say that again.
Once you saw the driver dancing around the vehicle, what did you think happened next?
So as soon as he passed me, I noticed that he wasn't wearing a seatbelt, so I immediately got out in the traffic to get behind the vehicle.
And what happened once you got behind him?
Once we approached the intersection of Metropolitan and Cleveland, I activated my emergency lights to get the driver to pull over.
And did the driver pull over?
He turned on his left signal to turn into the Dollar General parking lot.
And where's the Dollar General parking lot?
It sits on the corner, east corner of Metropolitan and Cleveland.
All right, looking back at our map, where is the general vicinity of where the Dollar General will be?
It will be right up here.
Right here?
Yes.
Okay. And what happened once the vehicle turned to the Dollar General?
As soon as he entered the parking lot, he immediately continued to the other side of the parking lot, back out onto Cleveland.
I'm going to show you what's been marked as State Exhibit 35Q, which should be picture 3. Do you recognize what's the State Exhibit 35Q?
I do.
How do you recognize what's the State Exhibit 35Q?
That's the Dollar General right at the corner of Metropolitan and Cleveland.
Is that the same Dollar General that we just referenced on the map?
It is.
And is that a fair and accurate depiction of the Dollar General back in 2019?
It is.
Your Honor, this something like 10 to 6 to 35Q.
An objection states 35Q. All right, states 35Q is admitted and may be published as you see fit.
Okay. For the jury, this is Dollar General that we've just been speaking of. Is that Dollar General?
It is.
And if you could just orient the jury right now to what we're seeing, where's the intersection, and what we're seeing in State Exhibit 35Q.
The intersection is right there where the red light is at. So that's the main street you're looking at. That's Metropolitan. Then where the red light is at, that's Cleveland. And then he enters the parking lot right there where the gentleman is walking across at the entrance of Metropolitan to the Dollar General.
And is it fair to say that that gentleman wasn't there back in 2019?
No.
Okay. All right. So when he made the letter to the parking lot, if you have to stand up, you can tell the juror, show the juror what direction he walked.
As soon as we entered the parking lot, he immediately continued around the building to the other side of the parking lot, which is another entrance that leads onto Cleveland Avenue.
Okay. And did you go behind him?
I did.
All right. And what happened once you get to the other side of the Dollar General?
Once we get to the other side, he immediately made the left onto Cleveland. And then we were traveling eastbound on Cleveland towards 75.
And let me ask you, back in 2019, driving southbound, was there any traffic driving southbound back on this date, September 2019?
It was a matter of fact, the light is red, so it was just be a picture perfect. There was cars there, so he had to turn into the Dollar General.
Okay. And was there any traffic going northbound on Metropolitan?
No.
All right. So once he goes left onto Metropolitan, what if anything? Left onto Cleveland, what if anything?
Once on Cleveland, the vehicle started picking up speed and continued towards 75.
When the car began picking up speed, what did you do?
I advised radio that I had one refusing to stop. Let her copy my traffic, and I proceed to follow the vehicle.
Okay. And what, if anything, occurred?
I noticed the vehicle went around traffic into the center lane, and right there where it says Cleveland and Forest Hill, he ran the light.
What happened? You just point to?
29Q.
All right, I'll show you 29Q. Okay, so you said that he was going around traffic.
Correct.
Show the jury the general area where he was going around.
You got Forest Hill right there in Cleveland. There's a traffic light right there. And then the light was red and he went around traffic and ran the traffic light.
Okay. So right here at Forest Hill in Cleveland, there's a traffic light at Cleveland?
Mm-hmm.
Is that a yes?
Yes.
Okay, and you said, did the car run that light?
Correct.
All right. And what happened once the car ran the light?
He crossing over 75, still on Cleveland. At this time, I'm approaching Forest Hills at the light. Once I get through the light, I noticed that he was in a vehicle accident.
Okay. And at this point, do you know about how fast y'all were going?
My speed was probably around
45, 40, can't say about how fast he was going, because he had a little bit distance ahead of him.
And once the accident occurred, what happened?
I noticed that he was already out of the vehicle, and then he was running on foot.
And when he ran on foot, probably did your exercise today.
Okay.
Where did he go?
There's a check cashing place and a cleaners right there at that corner, which there's a fence blocking to keep traffic from running into the buildings and stuff. So he scaled the fence, jumped over the fence, and then started running through the parking lot.
Okay. And when you said the check cashing place and the dry cleaners, where approximately on this map is the check cashing place?
It's going to be that first small square building.
Right, in this little block up here?
Yes.
Okay.
And then the cleaners going to be the little L shape.
All right. So the first small block is the check cashing place. The L shape is the cleaners.
Correct.
There's another gray box. What is that?
That is the admission place.
The admissions place. Okay. What direction did he run?
He's running kind of south in between the check cashing place and the cleaners. And then he runs behind the cleaners, in between the cleaners and the admission place.
Okay. And I believe we keep saying that did you recognize the driver to be a male?
Yes.
All right. Now, as he runs through the check cashing place and runs in between the dry cleaners and the admission, what did he have?
He started running towards the parking lot, which is 230 Cleveland Avenue, which is that big gray square. He enters that parking lot still running. There's a gray sedan, possibly a 7, not for sure, that's parked there. Female's getting out of the car. As the female's getting out of the car, he pushes her out of the way in an attempt to get in the car, but there was another person in the driver's seat.
I sustain the objection. You can rephrase.
Let me ask you, were you observing him running towards the vehicle?
Yes.
And did you observe him trying to go
I sustain the objection.
What did you observe?
I observed him push the female out of the way to get in the driver's seat, but
that's direct, so I'll overrule the objection. You may finish.
Did you observe him trying to get into the vehicle?
I did.
Did you observe him trying to get into the vehicle after he pushed the lady out of the car?
Not out of the car, but out of the way.
Out of the way.
Yes.
Was he able to get into the car?
No.
What happened?
He continues to take off back running. This time he's running northbound in the parking lot, and then he crosses over Cleveland Avenue.
And at this time, are you behind him?
From a distance, yes.
And are you chasing behind him?
I am.
What, if anything, happens once he crosses Cleveland Avenue?
Once he crosses Cleveland Avenue, I heard something drop, which was later my flashlight. Kind of paused for a second, but he's running in between the Checkers and the other business.
And time to exercise again.
Mm-hmm.
Where is the Checkers, and approximately where is the Checkers at within this map here?
The Checkers is going to be on the other side of Cleveland where the little T square is at.
Okay.
And then you got the block building where he runs in between.
All right. And what direction is he running into?
He's running northbound, which leads into another apartment complex.
And where's that apartment complex?
2612 Still Avenue.
Okay. And at this time, do you still have sight of him?
Once he goes behind the Checkers, no, I don't have sight.
All right. And do you actually go over to where, to this side where 2612 Still is?
I did.
And why do you go over there?
To see if he was hiding or laying down somewhere.
All right. And did you see him over there?
No.
All right. Did you eventually learn if he was ever apprehended?
Yes.
And where did you see apprehended?
Right there, the entrance where it says Old Hateville and Conley Square.
And where it says Colonial Square, is that another set of apartments?
It is.
And once the individual was detained, what happened next?
I started, checking, walking back to where they had him detained, and then I came back to where the scene was at. And
let's go back they talk about the observation of the accident. What type of car did the red vehicle hit?
It was a white sedan. I believe it was a Honda.
And did you see anyone inside the white vehicle?
Yes.
Okay. Do you know how many people were inside the white vehicle?
From my knowledge, just us one.
And within the red vehicle, did you see anyone else get out of the red vehicle?
No.
Now, on this day, did you have body cam video?
I did.
All right. And did your body cam capture, have you been able to review your body cam?
I did.
And has your body cam captured your interaction from what you just testified to on Peg Road up until you running behind checkers at 2612 Steel?
Yes.
All right. And back then, tell us what type of uniform you were wearing.
Similar to what I have on without the outer vest.
Without the outer vest?
Yes. So all the equipment that you see up top was on my waist.
Okay.
Except for my camera.
And what was your camera?
Center mass in the middle of the chest.
And did you get out of breath at some point in time?
Yes.
Okay. All right. And is that indicated on the video?
Yes.
All right. I'm going to show you what's been marked as State's Exhibit 1Q. Tell me if you recognize Exhibit 1Q.
Yes.
And how do you recognize Exhibit 1Q?
It has my signature on it along with today's date.
And what was on, and what's contained within State's Exhibit 1Q?
My body cam footage.
And did that appear to be a fair and accurate depiction of your body cam footage from September 25th, 2019?
It did.
And has there been any additions or deletions to that body cam footage?
No.
Your Honor, this time the state by contender State's Exhibit 1Q into evidence.
Any objection to States 1Q? All right, States 1Q is admitted, may be published as you see fit.
And Your Honor, I spoke with Mr. Shaw. We're only going to play the initial portion of the video which captures what has just been testified.
From when to when?
From 0 to about 4 minutes.
Okay, thank you.
Your Honor.
Sir.
May I clarify for the record? I don't object to the portion that the state is indicating that they will publish. We've had prior conversation.
Okay.
Advise your speed and your traffic.
Speed 40, 45, still on Cleveland. That's 41, that's 41.
Radio copy, still on Cleveland, 45 miles per hour. How is traffic lighter? What's your location?
230 Cleveland, 230 Cleveland.
230 Cleveland.
Black male, plaid shirt, black jeans.
Black male, black shirt, black jeans.
Tempted to 44, tempted to 44. Get down, get down.
Copy, attempted to 44. 59 right of way. What's your location now?
Run towards 191. 191 Cleveland.
191 Cleveland. You still have visual? Okay, talk to me. You still have visual on them?
Running towards the apartments.
Running towards the apartment. Any unit 59 Wisdom. You first unit Wisdom, advise me. What's your location now? 309, what's your location now? Have you made it to the apartment? Where you're raising off your Cogdell?
Yeah, he's back here somewhere.
Back in the apartment? Received 3309, checking on you. 309, you still have visual to touch it?
Negative. I lost him back here behind the checkers.
Lost sight behind the checkers. You okay?
Yeah.
Where you copy? Where you go?
Trying to have a very sort of perimeter where we went.
All units en route to 309 location advised you are set up a perimeter in the area on Steve Avenue. Break down, return. 305, 42 on scene in the area. 2343 radio copy, getting the subject to time.
One's on 3, you got checkers on Cleveland.
Affirmative, there, advising they're getting the subject detained. 3309, was it just one person or what?
I thought it said five minutes and 10 seconds. Stop it. They did not read 5 minutes and 10 seconds. There's a few things that were shouted in the video. One, what's a 41?
Accident.
Accident?
Mm-hmm.
And then what's a 42?
It's a robbery.
And in looking, first, what we have depicted on the screen right here, there's verbal 6.
Mm-hmm.
So we're going to use that.
Okay.
What are we looking at here? Is this an apartment complex?
Yeah, this apartment this is the backside, or you saw when you walked through the cut, but this is 2612 Still Avenue.
And on the other side of 2612 Still, I'm just going to fast forward slightly to about 6 minutes, maybe about 7 minutes. I'm telling you what we're seeing a little bit past 2612 Still. So stop pausing right here. What area? What are we looking at? If we go straight.
If you go straight up to the steps, there's a fence right here, and then on the other side of the fence is another apartment complex.
And is there a way to get from 2612 Steel to that other apartment complex if you were going to?
Yeah, if you were to run behind this building right here, further up, there's a makeshift cut or path that leads into that other side.
And was the male apprehended? And where was he apprehended?
He was apprehended right at the entrance of that next complex in Old Hateville.
I'm going to therefore again just slightly to about 7 minutes. pausing right here. Can you see the general area of the entrance of that second apartment house?
Yes, ma'am.
Okay, if you can show the jury where is the front part.
The front entrance is right here. There's a gate gated for vehicles to come in. That would be the entrance right there.
And earlier you just talked about the cut. Do you see the cut?
Not on my camera, but it's right up in here.
All right. Now, what the individual was, the male was detained, was he brought back to where you were?
Yes, ma'am.
And where did you actually go back?
I went back to the scene of that, where the car was ended up at.
And when the individual was brought back to your location, did you learn who the individual was?
I did.
Okay, well, who was the person dropping?
Shannon Jackson.
And had you ever met Shannon Jackson before?
No, ma'am.
Had you personally had any interactions with him?
No.
Once Mr. Jackson was brought back to where you were, what happened there?
He was saying that he couldn't breathe, stuff like that, so we already requested the ambulance to come out.
And did the ambulance come?
They did.
And did you ever obtain a driver's license from Mr. Jackson?
Not off of Mr. Jackson, but from another officer.
And was it a valid license?
No, ma'am.
And did Mr. Jackson have any belongings on his person?
He had money in his pockets.
And how much money did he have? How much money did you get from him while on it?
On scene, the officer had counted out $5,000.
And do you know where that money was located on his person?
I believe it was in his front pockets.
Was there any additional money found on Mr. Jackson?
Yes. It was roughly $500.
And where did you find that money?
In his front pockets.
And did you find that money while on the scene on Cleveland Avenue or somewhere else?
While we was at Grady Hospital.
And what if anything happened to that $5,500?
I was turned into property.
While on scene, was there anything else done while on scene?
We inventoried the vehicle.
And we take inventory of the vehicle. Which vehicle did you
The red Nissan.
Okay. And why did you have to inventory the vehicle?
Because he was in custody.
And what if it was going to happen with the red vehicle?
I was being impounded, so we had to inventory, see if there are any belongings and values inside the car.
And did you find anything inside the car?
We did.
What did you find?
We found a handgun in the center console.
And what type of gun was found in the center console?
It was a Taurus, I believe, with a 9mm.
And did the gun have a serial number?
It did.
And you recall the serial number was?
Not offhand, but
We're looking at a copy of the police report, help refresh your memory.
yes.
As to the serial number. Permission to approach?
You may, ma'am.
And I'm going to show a copy of this. I'm going to show you what's been marked as 36Q. Tell me if you recognize this as 36.
I do.
How do you recognize this as 36Q?
This is my police report.
Is that a fair and accurate depiction of your police report for this case?
It is.
And we're looking at a copy of your police report, help refresh your memory as to the serial number of the handgun that you found inside of that ready to sign.
Yes.
Have you looked at your report?
I'm looking for it. Yes.
Okay. And what, without reading from the page, what was the serial number for the firearm?
9FW03901.
And did you run that serial number on the time?
I did.
And what if anything happened when you ran the serial number on the time?
At the time of the incident, was showing not on file, which means not stolen.
And Did you determine? should have been in possession of it.
We did.
Okay, and should he have been in possession of it?
No, after doing a criminal history check, we found out he was a convicted felon.
Now, I'm going to show you what's been previously marked and shown to defense counsel, States Exhibit 23Q, 24Q, and then 2Q through 21Q. Take a moment, flip them, tell me if you recognize. 23, 24 too. I think that's right. 2. You recognize for 23 to 24 Q and then 2 to 19 Q.
I do.
And how do you recognize, let's start first with 23 Q and 23.
23Q and 24Q is the vehicle that was struck.
And then looking at 2Q to 19Q, how do you recognize 2Q to 19Q?
This is the vehicle that he was driving.
And as you continue to go to work.
Okay.
And so this, I'm looking at Stacy exhibit 19, 20, and 21Q. What's the 19, 20, 21?
That was the firearm that was found in the center console.
And look at all those pictures that was presented before, 2 through 21Q and 23 and 24Q. Does there be a fair and accurate depiction of the scene on September 25th, 2013?
Yes.
And does it also appear to be a fair and accurate depiction of the weapon found in the car on September 25th, 2019?
Yes, ma'am.
You're right, this time it's like 10 to 6 exhibit, really 2 through 24Q.
Any objection, Mr. Sharp?
No, Your Honor.
All right, states 2 through 19Q and 23 and 24Q are admitted and may be published as you see fit.
And Your Honor, I believe we also had 23 and 21Q as well.
All right. Any further objection to 20 or 21Q, sir? All right, 20Q and 21Q are admitted.
And let me ask you, before we publish these images, some of these images, the lady in the vehicle with the 44, was any information ever received from the lady in the vehicle which called the 44
No, ma'am.
Why?
When I got there, she was gone.
Okay.
Her in the car.
They left the area.
Yeah.
And in running or chasing, were you able to get the tag number of that vehicle?
No.
So were you able to identify or locate who that individual was?
No, ma'am.
At this time, we're going to first publish 23 years. Now, first looking at Stacey Exhibit 23Q, I know we saw some of this in the body cam video, but if you could just orient the jury to where we are within this photograph.
This right here is the off ramp coming off of 75 northbound onto Cleveland.
And in the distance on the left-hand side, is that a gas station?
It is.
And what is the address of that gas station?
221 Cleveland Avenue.
Far on the distance on the left-hand side, there's a sign. Do you know what that sign is?
That's the Checkers.
And on the right-hand side, do we see, are you able in this image to see the red Nissan that you observed Mr. Jackson driving?
Yes.
And using the stick, we can also see the new stick, you can point where
It's right here.
All right, and I might just have you stand because I might have you just one minute. Looking at 6724Q. If you're looking at 6724Q and you look to the left of the screen, what direction is that on Cleveland Avenue?
If you looking left to the screen, that's going westbound back over on Cleveland, heading towards Metropolitan.
And do you see that other traffic light? Or to the left?
Yeah. Right. Oh, to the left?
Yes.
Right there?
Yes.
Yeah.
Is that the traffic light at Forest Hill, Cleveland Avenue?
It is.
All right. Now showing 67.2Q. Is that a closer picture of what we just saw in 23Q?
It is.
Now, looking at the red vehicle, did the red vehicle hit either the tree or the metal frame there?
No, it came to a resting spot. So once it over this sidewalk part, that's where it rested.
All right. And from here, do you see either the dry cleaning or the dry cleaners?
The dry cleaners right here.
All right. Now looking at 3Q. If you can orient, what's the blue building and then that kind of brown building that has?
This is the dry cleaner still, and then right here is be the mission place.
And when Mr. Jackson was running, where was he running in between? we just saw in 23Q.
It is.
Now, looking at the red vehicle, did the red vehicle hit either the tree or the metal frame there?
No, it came to a resting spot. So once it, over this sidewalk part, that's where it rested.
All right. And from here, do you see either the dry cleaning or the dry cleaners?
The dry cleaners right here.
All right. Now looking at 3Q. If you can orient, what's the blue building and then that kind of brownish building that has
This is the dry cleaner still, and then right here is be the mission place.
And when Mr. Jackson was running, where was he running in between?
Between the dry cleaners and the mission.
Now looking at State's Exhibit 4Q. That's just another image of the vehicle what a prior vehicle.
Correct.
All right. 5 and 6. Now look at State's Exhibit 6Q. That the check cashing that you've been referencing in your testimony.
It is.
All right. Now, also in your testimony, you said that Mr. Jackson hopped over the fence. What is the fence in which he hopped over?
This fence right here.
And once he hopped over the fence, is that where he ran in between the
Once he hopped over the fence, he ran between the cleaners and the check cashing place, and then he cut. You see the mission spot right there.
Looking at 7, we can move forward. Is this all the picture of the inside of the vehicle?
It is.
Looking at Exhibit 13Q, what is Exhibit 13Q?
This is the center console. This is the inner lid of the center console.
All right.
And then that's the bottom of the center console where the gun was located.
And so did you have to lift up the other parts to get to where the gun was located?
Yes.
All right. And is that an image of the gun that was recovered out of the vehicle?
It is.
Just a close-up. Speaking of that, was the gun loaded?
It was. There was one in the chamber, that's the reason why that is sitting right there.
All right. And did you recall how many was in the magazine?
If you count the one in the chamber, it'll be a total of 8.
All right. That's a close-up of the type of weapon that it was. Just a close-up of the type of weapon?
Yes.
Okay.
The name brand, the serial number, and the caliber.
And is that the gun is inside of the box?
Correct.
And that's a close-up of the bullet?
Yes.
Close-up of the weapon?
Yes.
All right. You can take it forward.
You ready to come? Ready to take it up?
All right. Deputy Ingram is approaching with what has been marked as Exhibit 22Q. I want you to take a moment and look inside for the 22Q and tell me if you recognize what says Exhibit 22Q.
This is the weapon that was recovered.
And is that the same picture that we're looking at on 21Q?
It is.
All right. And does it have the same serial number in which, for the gun that we see the picture of 22Q?
It does.
Your Honor, this sounds like a tender of Exhibit 22Q with that.
Any objections, states 22Q, Mr. Sharp? All right, states 22Q is admitted and may be published as you see fit.
And now permission to publish that. Now, I know earlier we talked about, the gun being not in the file. You said that means that it wasn't stolen. If a gun had been stolen but not reported, would that still come up as not on file?
If a gun's been stolen but not reported, no. It'll have to be reported stolen for it to be, for you to get a hit on file.
Basis, what's the, I'm overrule the objection.
I'm just asking what is not on file. Not on file means it's not.
Right, at this point, I'll overrule the objection, sir.
Just for not on file means that it has not been reported.
Correct.
Did you take out warrants from Mr. Gates?
I did.
What were the warrants for the charges that you took out?
It would have been fleeing and eluding, reckless driving, no license, not wearing a seatbelt, obstruction of officer, and then possession of a weapon by a convicted felon.
And after being on the scene, did you eventually go down to Brady Hospital?
I did.
And after going down to Brady Hospital, did that conclude your involvement in this case?
It does.
I have no further questions. Good morning, Mr. Hudson. How are you? And Happy New Year to you.
Thank you.
Mr. Hudson, do me a favor. I want you to yell into that microphone, okay? So we can all hear you, all right? Or I'll put it this way, use your outside voice. Let's see how that goes. Can we do a test?
Testing.
All right, okay. Just try and keep that level up if you wouldn't mind for us, okay?
All right.
All right, thank you, sir.
And Mr. Hudson, where are you from?
Atlanta, Georgia.
All right. And do you currently reside within the metro Atlanta area?
No, I live in Loganville.
And how long have you been in Loganville?
For like a year and a half.
You said a year and a half? And are you currently working?
No,
Why aren't you working?
because I had a stroke
How long ago did you have your stroke?
back when COVID started, 2020.
And with you having a stroke, has it affected your memory at all?
Yes,
Now, let me ask you, prior to having your stroke, did you work?
yes,
What type of work did you do?
security.
And how long were you in the security industry?
Give or take about 25 years.
25 years. And while in the security industry, did you ever work for Velour Security Services?
Yes, I have.
And if you can recall, approximately when did you work for Velour Security Services?
About from 2013 to 2015.
And when you worked for Velour Security Services between 2013 and 2015, did you have a particular location that you were responsible for securing?
We secured the whole mall,
And when you say the whole mall, which mall are you referring to?
Perimeter Mall.
And did you work at Perimeter Mall for that entirety of that 2013 to 2015 period?
Yes,
When you worked at Perimeter Mall, what were some of your job duties and responsibilities?
to help out people to go to accident scenes, wherever they may be.
You said to go to accident scenes? And you shook your head, is that a yes?
Yes,
And is that accident scenes within the mall?
yes,
Did you ever have the responsibility for patrolling outside of the mall as well?
yes,
Within Perimeter Mall, was there a particular unit or area where the security team was housed if you weren't patrolling? Did you have an office area?
yes.
And in that office area, was that a shared space or did you have your own individual office within the security office area?
All of the officers shared that area.
And was that area a secured area?
Yes,
And just generally, if there was an incident that occurred at the mall, say an accident or anything like that, would you have to make an incident report, an internal incident report?
yes,
And generally, when there was, say, an accident at the mall, did you always have to call outside law enforcement, or was that only on certain occasions?
no. It was only a certain occasion.
Why would you have to call law enforcement out?
If somebody slipped and fell and hurt themselves, well, catalytic converters, things of that nature.
And when we say Cadillac converters, what do you mean?
They were cutting them off.
They were cutting them off at the mall.
Yes,
Like people would come up and cut off people's Cadillac converters.
yes.
If there were any crimes like theft, would you have to call the police?
I would have to call him person.
Who would have to call?
Mr. May.
Mr. May. And who is Mr. May?
He's director of security.
He's director of security. And was Mr. May your director of security the entire 2 years that you were at Perimeter Mall?
Yes.
As your supervisor, what was some of his responsibilities? As Mr. May, he was your supervisor?
He was over the whole department.
And do you know, as his job over the entire department, some of his responsibilities?
No.
All right, Deputy, can you check and see if all our jurors are in pocket, please, sir?
There is a legal issue that's come about. I don't know if you'd like to hear from me now, but the state has indicated that they're going to seek to introduce something.
Hold on. Can I get you to step outside for me just a second, please? Okay, Officer Cogdell's not here. Our jury's not is also absent. Mr. Sharp, what do I need to take up?
Your Honor, there's two matters. The state during the break has indicated to me there showed me some what appear to be certified convictions of my client and indicated that I don't know if it's going to be later today or tomorrow, but sometime in the near future.
Wait. Can you all go back, please? Thank you. Okay, so you said these certified convictions?
Right, that they're going to seek to introduce into evidence. And
okay, and they have shown those to you?
They have, and there's four. Two of them, I believe, relate to overt acts or alleged overt acts in this indictment. My issue, other than some extraneous pages included in the certifieds, my issue is not with the admission of those subject to our prior kind of blanket Bruce Harvey rule objections. However, two additional convictions, there's one from 2010 and I believe 2011, are not listed as overt acts in the indictment. The state's stance, I believe, is that they are listed in the overt act itself, overt act 98. If you look at it, my client is alleged to have committed possession of a firearm by a convicted felon, and then the state in the pleading lists 4 separate felonies that they're alleging my client, that make my client a convicted felon. That
doesn't make sense. I mean,
that does, because you only need one.
You only need one, okay, but
right. And so they've listed 4, and now they're seeking to introduce certified of 4 separate extraneous convictions that, again, I'm acknowledging that 2 of them are overt acts in this case, and that's not my issue.
You don't have any objection to those?
There's some extra paperwork in there that I can specify what I object to.
Well, you know that when, let's assume that I admit them, okay, if they're in proper form. Before they go to a jury, I understand. There's some of the things that will be stripped out because they would violate the continuing witness rule and some other things. So,
I understand. And
so we'll get to that later, but
I do object to the two that are not listed as overt acts because
the ones in
it violates
2010 and 2011.
I don't have them in front of me. The state has them. I believe I know one of them is 2010. One's a burglary, and then one is a theft and a gang charge. Ironically, charging a separate gang, but those should not be admitted into evidence. And I'm relying on Old Chief United States 519.
Old Chief?
Yes.
519. You found anything more recent?
U.S. v. Marroquin, M-A-R-R-O. U.S. v. Marroquin, M-A-R-R-O-Q. U-I-N, Lopez, 634, Federal Appendix 758, that's 2015, but it discusses Old Chief. Old Chief's still good law, and it basically, Judge, it comes down to 403. I mean, I don't think anyone that's been watching this trial, anyone that heard my opening would suggest that that the issue of whether Mr. Stillwell is a convicted felon is really at issue. It's not at issue. It never has been an issue. I said in opening.
Well, they still got to prove it. They still got to prove it.
And they can with a prior, but they don't need to prove it with 4. And the prejudicial value substantially outweighs the probative value when things do not have probative value. And so if you look at the indictment, Act 98, they list 4 prior felonies: participation in criminal street gang activity from May 2010, which is indictment 11 SC 98860. I object to that. They list a burglary from June 2nd of 2011, indictment 13 SC 121320. I object to that. Then they also list possession of marijuana with intent to distribute from September 19th, 2013, which is 15 SC 140132. We've heard testimony about that. And my client pled guilty to that, and we understand that that is listed as an overt act. So we're not going to specifically complain about the admission of that one. And the other one is possession of marijuana with intent to distribute, possession of firearm by a convicted felon from March 10th, 2016, which is 15 SC 140132, and I don't object to that. The other one I don't object to, I'm sorry, I read it wrong, Your Honor, it's 13 SC 121320. The ones I object to are 11 SC 98860 and 10 SC 87662.
Okay, well, they pled them specifically in the act, and that's Act 98, right?
Correct.
Okay, so, I mean, if they're in proper form, wouldn't they go to an element? I mean, they go to an element of proof.
No, we could easily redact this indictment. We did it with count 25, I believe it was, on this indictment.
That was for another ground, though.
Well, it is, but I mean, it can be done. And the bottom line is, all of this still needs to pass Rule 403. Just because the state puts it on a piece of paper doesn't mean 403 doesn't apply.
I understand. Okay. Well, if I understand your objection, are you saying that the court needs to apply the 403 balancing test? I mean,
yeah, as discussed in the Old Chief case and the other case that I cited, and many other cases, Your Honor, and also I'll just point out the prejudicial value. The prejudicial value of these priors that are not listed as overt acts, specifically 10 SC 87662, is particularly great based on the charge being participation in criminal street gang.
All right. What's the state's position on that?
Your Honor, the state's position.
Can I see the convictions to begin with?
Yes.
Do you have them? You have them?
Yes.
Okay.
And just for clarity, for the purposes of the record, Judge, we have labeled State's Exhibit 31Q
Hold on a second. Said 31Q, and which one's this one now?
This is the certified for Tennessee A7662, Your Honor, which is a part of the allegation in not only count 98, but count 55 as well, as we discussed with Mr. Sharp prior to speaking with the court.
Okay, what's the next one?
The next one is 32Q, which is the certified conviction for 11 SC 98860, which too is listed in both Acts 55 and Acts 98.
Okay.
We then have States 33Q, which is a certified conviction for 13 SC 121320.
So 13 SC, what was that? I'm sorry?
121320.
121130?
No, Your Honor.
I'm sorry.
13 SC 121320.
Thank you.
You're welcome.
And what does that go to? Counts what?
And that too is listed in Acts 55 and Acts 98.
Okay.
And we also intend to introduce States 30Q, which is the certified conviction for 19 SC 173371, which is the act itself that is alleged in Act 98. At least part of the act. And I will present them at the court's pleasure whenever the court tells me to present them, to approach and present.
Okay, have you seen them, Mr. Sharp?
I have.
Can you
Yes.
approach, let me look. Hand it to Mr. Kearns, please, so I can look at it.
Yes. And Your Honor, in reviewing them with Mr. Sharp, there are some sticky notes on there just to mark certain areas he wanted us to be mindful of.
All right.
That have no bearing on the argument.
Your Honor, may I add one thing to my argument? Well, actually two.
We discussed something, so we haven't.
Hold on 1 second, sir. Okay. Mr. Shaw, I'll let you know when I'm ready, okay?
Okay. Thank you, Judge.
Okay, all right. What are you doing the entire bed? I want to see you. Hey, come on, man. Really? Tell me just one thing, okay? All right, go ahead. As soon as you finish.
John, I was going to add two other things. I just wanted to call your attention to the fact that both of these convictions that I'm arguing against are alleged to have occurred prior to the alleged RICO conspiracy. But also, most importantly, Your Honor, we shouldn't have to because we've basically done it in the opening, but we're willing to stipulate to my client's convicted felon status if that clears anything up. I mean, I don't think, again, from watching this case, I don't think that's an issue at all. And they have at least two prior felonies that seem to make that pretty clear. And we're not arguing that it's not clear, but we'll stipulate to it, in fact. But we just don't think it's appropriate just because the state throws things into the indictment to bring in bad character evidence against my client.
I don't think it's bad character. It's and they're not doing it for that particular reason.
Well, what is? I mean, I just don't understand what the reason is because the only legitimate reason is to prove he's a convicted felon, and he clearly is. So.
Well, I'll let the state respond to that. Is that the two bases?
Yes, we're willing to stipulate.
Okay, all right. Yes, Ms. Lowe.
Thank you, Judge. Your Honor, what it seems that Mr. Sharp is doing is asking for essentially a striking of the indictment, something that should have been dealt with pre-trial, because where we are now in Act 55 and Act 98, these are portions of the act that the state alleges, so they constitute proof of what we've alleged in the indictment. As to the argument regarding 403 and a 403 analysis, these allegations are not allegations that, or the certified convictions rather, are not convictions for the types of crimes that are substantially more prejudicial than probative as they relate to Mr. Sharp's client. The fact that he now asserts that these crimes happened prior to the beginning of the alleged conspiracy is of no consequence, especially where it's these acts that have occurred are in fact kind of integral to other evidence that will be presented at trial. Mr. Stillwell, in that 10 SC 87662, committed those acts as part of the criminal street gang that we do reference in this indictment. We talk about 30D, we talk about not just YSL. Mr. Stillwell, in one of the songs or lyrics that may be talked about, there's a reference to the Blue Jean Bandits, there's a reference to 30D, and this is just ancillary, but this gang charge that is alleged in 10 SC 87662 is in fact one of those kind of incidents where she is alleged to have and actually was convicted of gang activity for that type of act on his part, along with others. But that aside, Your Honor, the bare fact is that the state has alleged in Act 55 and Act 98 that Mr. Stillwell had been convicted of these offenses, and the state has the right to prove up its indictment in the way that the state sees fit. This is not one of those circumstances where the convictions in any way prejudice Mr. Stillwell, and certainly they don't substantially prejudice him in a way that makes the admission of these convictions more prejudicial, substantially more prejudicial than probative. He's essentially trying to dictate the way that the state proves up its case, and the defendant doesn't have the right to do that. The state has the right to prove up its case in the most effective and impactful way that we are legally allowed to do. And given that we have made these allegations, that this indictment has been read to the jury, and that we have bona fide certified copies of these convictions, the state should be allowed to introduce that evidence to the jury, and should not be kept from doing so for reasons that are not, there's no reason to keep the state from doing so. The defendant just does not get to dictate how the state proves up its case. So we are just asking that the court deny these motions to keep out evidence of acts that have been alleged in our indictment.
And Your Honor, they keep saying I don't get to dictate how they try their case, and I acknowledge generally that's true, but that's the whole holding of Old Chief, is just because they allege it in the indictment doesn't mean they get to just let everything in, no matter how prejudicial it is, no matter how limited the probative value is. That's the whole point of Old Chief.
Old Chief is a little different. Old Chief, this is Old Chief versus U.S. 519 U.S. 172. A little different aspect. I see what you're saying about Old Chief in terms of you're willing to stipulate that particular issue in terms of the convicted felon issue, which Old Chief was a singular issue, and that's part of why the Supreme Court dealt with it in the manner that they did. The state is alleging, however, that given the other elements proof that they're alleging, in particular acts 55 and 98. 55 being the defendant from the incident involving 7/15 of 2015. Defendant Shannon Silva, associate of YSL, did commit the felony offense of possession of a firearm by a convicted felon in violation of Georgia law pursuant to OCGA 1611-131 by possessing a firearm, to wit, a handgun, after being convicted of a felony in indictment 10 SC 87662 in the Superior Court of Fulton County for the offense of participation in criminal street gang activity and burglary on the 26th day of May 2010 in indictment 11 SC 98860 in the Superior Court of Fulton County for the offense of burglary on the 2nd day of June 2011 in indictment 13 SC 121320 in the Superior Court of Fulton County, Georgia for the offense of possession of marijuana with the intent to distribute on the 19th day of September 2013, an overt act in furtherance of conspiracy. So, and then in addition, in Act 98, they allege similarly participation in criminal street gang activity and these acts in furtherance of overt acts and furtherance of conspiracy. I know it may, in looking at it from a 403 perspective, Mr. Sharp, and of course, in looking at Old Chief and looking at what the measure of prejudice is, evidence is unfairly prejudicial when it would influence a jury to decide the case on an improper basis, and courts have noted that there's a difference between evidence that is simply prejudicial and in that it hurts a party's case admissible, and evidence that's unfairly prejudicial, which is inadmissible. So the 11th Circuit, in looking at this particular issue, in the United States versus Patrick, that's 513 F APPX 882, 11th Circuit, 2013. While invoking the exclusionary elements of 403, in addition to cautioning that the rules should be used sparingly, the 11th Circuit Court of Appeals looks at the evidence in light most favorable to its admission, maximizing its probative value and minimizing its undue prejudicial impact. Consistent with this authority, courts have noted that the key term in 403 is not prejudicial, but unduly. So in this particular circumstance, I don't believe that these particular convictions, now there are some things in there that will need to be discussed and paired out before actually being handed to a jury, but I don't believe that this is going to lead to confusion of the issues, mislead the jury, be a waste of time, unduly delay, or needlessly present cumulative evidence. So applying a 403 analysis, I believe these convictions, if in proper form, would be admissible to prove the state's case, or attempt to prove, I should say, because that's a jury's issue, whether or not they proven to a satisfactory extent Acts 55 and 98.
Well, Your Honor, just briefly, if I can respond, the proof, it is cumulative.
We're gonna disagree about that. Okay.
Well, if it's just to prove his convicted felon status,
no, they're going to prove whether or not, as listed in the indictment, whether or not they're acts in furtherance of the conspiracy. So a jury's free to believe. It's just because they introduce them doesn't believe that they have to view them as proof positive.
They haven't, but there's different evidentiary means for them to get.
But they get to choose that. But
they haven't filed the pretrial motions to, like 404B. They would have to file a 404B.
They're not required to do 404B. It's not mimic evidence. Okay.
On a burglary from 2011.
it's going to be what they allege in the indictment. So they have to be able to show that.
So
prove
it's
it.
going strictly to his status as a convicted felon, because that's the only thing that they've alleged.
Well, it's part of the elements in terms of, because one, you guys show whether or not he's a convicted felon or not. So yes, that goes to one aspect of it, but it's not, as an old chief, it's not the sole aspect of it. They've got multiple reasons as to why they're seeking that particular evidence. So,
and Your Honor, all I'm saying
if it was just that, then I would more agree with your particular assessment that the 403 balancing test would tip. In this particular circumstance, it goes to more than that.
But they haven't provided the pretrial notice to use it via other evidentiary means or vehicles. So in other words, they can say, oh, well, it proves Mr. Shannon Stillwell has a propensity to do this, or whatever their argument is.
But they wouldn't be able to argue that. That would be error for them to argue that.
Well, let's just say that it proves his gang membership. That's an example. They would have to file.
As in the indictment.
And they would have to file a 418 notice.
We talked about this before.
And those aren't listed on it. That's what I'm saying.
This isn't other acts evidence.
Well, then what is it? It's just proof of conviction.
It's overt acts in furtherance of the conspiracy.
They're not listed as overt acts on the indictment.
That's what that's how the indictment's read. I read the indictment.
I'm not disputing that they can get into overt act 98. All I'm saying
55.
I'm not disputing that at all. All I'm saying is they can't bring in certified convictions after certified conviction after certified conviction as an element of that act.
It's only one element of whether or not he's a convicted felon.
They only need one conviction.
But that just goes to show. But it's more than that. They're going to show one. I mean, and look. You've asked. You're having discourse with the court. Yeah. So I'm just saying that it also goes to show whether or not they committed, or your client, whether or not they can prove your client committed any of these acts in furtherance of the conspiracy. Now, they may be able to show he's a convicted felon, but if the jury doesn't believe the other stuff, then that's only one thing. Now, whether or not he can be convicted of something else is another thing, but it is part of their proof in this case. I think it goes to multiple reasons, but State, you have anything else you want to add?
Yes, Your Honor, a couple of things. One, the state does not have to allege every overt act. And two, these are also intrinsic acts, and they don't have to be provided as with pretrial notice of intrinsic acts. These are all part and parcel of an alleged conspiracy that we have charged the defendants with in count one. So this argument about 404B fails. The argument about pretrial notice fails, and this is.
I still have to apply 403 though.
Oh, I do. I didn't argue about 403.
All right. Okay.
I didn't.
And
okay.
I just don't see how these are at all intrinsic to when they occurred before any RICO conspiracies alleged to have begun. And Your Honor, I appreciate you hearing me out.
Okay, no problem.
And there's one other issue that we could take up, but while the jury's out, we might as well now. There's a photo that the state has indicated that they wish to admit, likely through a witness this afternoon. It's 26Q. It's been previously marked as 26Q. Your Honor, I would just describe it. It's a still off of a body cam.
Can you see it? Let me see it.
And Your Honor, to add context, in this incident that we're litigating this afternoon, my client is alleged to have been involved in a car wreck.
Okay, what is 26Q?
That is the driver. Apparently, after the wreck, the police dragged the body. He's alive, obviously, but they dragged the body of the man from his car and placed him on the grass, and they didn't know if he had any spinal injuries, which he didn't have, and they told him to lay there on the grass and remain still. And so I think that's a depiction of the man laying on the grass, remaining still. I don't know why we need a picture of the man who was driving the other car, laying in the grass, remaining still, following orders. I think it gives
Is he on the phone or something like that? Or
I think he's talking to, in the body cam, I believe he was talking to a friend. But I think it gives the impression that this man was seriously injured and potentially can't move, which wasn't the case. And I just don't see the status, the state of this man that was unfortunately in this car accident. That has absolutely nothing to do with what we're litigating today. I don't see how a hit and run, first of all, I don't think it's even relevant to a hit and run, but to the extent that it is, certainly a hit and run would not be, I don't think even the state would argue that that would be in furtherance of any RICO conspiracy. So I believe that it would be, I didn't say anything about.
So you're saying it's relevancy? Is that what you're asking me to?
403, yes, it's confusion.
No, it's different. Right.
It doesn't have any relevance.
Relevant is a threshold issue.
Okay, it doesn't have any relevance.
Okay, all right. State, anything as to 26 Q or Quebec?
Yes, Your Honor. For 26 Quebec, the state feels that it is relevant. The previously admitted 23 Quebec and 24 Quebec would show this white Ford Fusion. Mr. Montgomery was the operator of that Ford Fusion. The state, that picture is just him laying on the ground, Your Honor, as you can see up there on his back. The state's not trying to get into whether he had some kind of back injury or spinal injury. It's specifically to corroborate what already Officer Cogdell has testified to and what Officer Raymond, who the state tends to introduce that through, that there was two cars and there's a diagram of this intersection that the state tends to introduce, which is 27 Quebec. And so the state just wanted to have the jury to be able to visualize the driver of the other vehicles.
All right. Mr. Short, unless you have anything else, I'll preliminarily say that I'm going to admit 26Q or Quebec, okay?
Thank you, Your Honor.
All right. As for states, 30 Quebec, 33 Quebec, 31 Quebec, and 32 Quebec, given the pronouncements of the court, I'm going to admit those. However, you have one here, should say state, let's see, that would be 31 Quebec, where you would need to redact or otherwise not include the revocation matter. Okay, so that needs to be stripped out anyways, but, and we can talk about that later anyways, because I think that there's a lot of allied papers that you probably have that probably don't have any, that wouldn't go out to the jury anyways. So, I'll admit them, but I'll say that you will have to, at some point in time later, unless you're gonna show them to the jury at this point in time.
On one of those convictions, it appears that there's one of the old Fulton County handwritten sentencing sheets, and then also the computer-generated computer-generated sentencing sheet as well. So it's almost like it's double, it's the same conviction twice. I believe that's on the Gang case.
I think, Your Honor, that is another matter that we have no problem hashing out with Mr. Sharp prior to that document itself going out with the jury. I think it's along the same lines of probation, revocation, paperwork, if it is in fact an exact implication. Otherwise, we would address it at a later time with the court.
Are you going to read it in any way to,
We're gonna read the computerized copy, because that's the one we can read.
all right. Mr. Sharp, other than your objections, is that all right with you, sir?
Yes.
All right, just make sure that you all, before, that you all, I mean, that is the state and Mr. Sharp, get together and figure out exactly what's going to be read. but I'll admit those over the objection and make them continuing objections. Okay?
And Your Honor, if it's okay with you in front of the jury, I'm just going to say that my objections are the ones that I've previously stated and assume that we will remedy the extraneous papers at a later date.
Yes.
Thank you.
Okay.
Your Honor, just permission to come approach and.
Yeah, oh yeah, you can, yeah, Mr. Kearns, go ahead and give those back, please. Okay.
Thanks.
All right. All right, before we go ahead and recall our witness, how much longer do you think we'll need, Mr. Sharp?
With this witness, I would say 10 to 15 minutes.
Okay, we'll probably call it a day after this. Okay, if that's all right with you all. Okay, all right, okay. Anything else? Can we summon our jurors? All right. Oh, bathroom break. That's right. Okay, folks, I'm sorry. I apologize. Let's just take, we'll be in recess 5 minutes. You all need, and do what you need to do, and we'll come back and we'll go ahead and finish up. We're in recess. Don't go away. Don't go away. Don't go away. Notice, we're going to probably not get to your witness today. I'll ask the state when they believe that they will get to your witness so you can schedule accordingly. But we're going to finish after this cross-examination for the day. So, counsels for the state, when do you anticipate calling Ms. Gladden's client, who is, what's your name, your client?
John Tavia Stevens.
Mr. Stevens. Okay.
Your Honor, as we have spoken with Ms. Gladden and Mr. Stevens over the weekend and informed them, we did intend that to get to him today if we had reached him. So we will be getting to him tomorrow.
Okay, all right. So, Madam, tomorrow, if you could be present for you and your client for 9:30?
Thank you so much.
Okay, all right. Do you have any other business before me, Madam?
I do not, Madam. May I be excused?
Yes, you and your client may be excused until tomorrow morning at 09:30, okay?
Thank you, Judge.
All right, we'll see you then, okay? Okay, all right. Sergeant Ingram, can we go ahead and summon our jurors first, please?
All rise for the jury. All rise for the jury.
He's like, I haven't had 2 weeks of this stuff. It's going to be great. And I was like, back here, kids. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. Okay, Mr. Sharp, cross.
Officer Cogdell?
Yes, sir.
Good afternoon. My name is Max Shard. I represent Shannon Stillwell. I think you referred to him as Shannon Jackson.
Correct.
Okay. You said that you were assigned to Zone 3.
Yes.
And a specific beat within Zone 3 that includes the Cleveland Avenue corridor, correct?
Correct.
Okay. And what year did you begin in Zone 3?
In April of 2019.
It began April of 2019?
Yes.
Okay. And are you still in Zone 3?
I am.
Okay. And that same beat?
Yes.
Okay. Prior to this incident, you did not know, or you had never personally interacted with my client before, correct?
Correct.
Okay. Is it fair to say when you saw the red car driving down Metropolitan, you did not recognize my client in the car and say, oh, that's Shannon Stillwell?
No.
Okay. No meaning you did not recognize him?
I did not know who he was.
Okay, excellent. That day, you indicated that you were in a police car in a parking lot of a storage company or storage facility. And you were by yourself in that car?
I was.
Okay. And I believe you used the word set up or posted up.
Posted.
Posted.
Mm-hmm.
How long were you posted there prior to getting behind Mr. Stillwell's car?
That I'm not for sure, probably 20 minutes probably.
In that same parking lot, looking over or looking at Metropolitan?
Correct.
And what were you looking for?
Just monitoring traffic flow. Any traffic violations that was committed.
Any traffic violations?
Yep.
Okay. Now, you indicated on direct that you saw my client in the front driver's seat, you said dancing.
Correct.
Okay.
Like bouncing around.
Bouncing around as some of us tend to do when listening to music in the car?
Correct.
Okay. You did not observe any moving violations committed by Mr. Stillwell at that time, correct?
No, just the seatbelt violation.
Just the seatbelt violation, meaning despite enjoying the music in the car, he wasn't weaving in between lanes or driving recklessly at that time?
No.
Okay. It was solely a seatbelt violation?
Correct.
Was that the only seatbelt violation you observed that day?
I'm not for sure because I got to work a little bit late that day. Who knows?
Do you always pull people over for seatbelt violations?
Not always seatbelt violations, no.
Okay. Nonetheless, you decided to get behind Mr. Stillwell's car, correct?
Correct.
And you, in fact, blue lighted his car, correct?
Correct.
All right. And eventually, you pursued Mr. Stillwell's car, correct?
Correct.
Whose decision is it to whether or not to pursue an automobile that is not stopping?
It depends. It's the supervisors monitoring. They can monitor the radio traffic. They cancel us if it's not like a forcible felony vehicle, or I can cancel myself.
Okay, so you said they'll cancel you if it's not a forcible felony, correct?
Correct.
Okay, and you would agree that seatbelt violation is not a forcible felony?
Correct.
APD standing operating procedure is not to conduct a pursuit on a seatbelt violation, isn't that correct?
That's correct. And I was getting ready to cancel myself, but by that time, he had already got into the accident.
Now, we talked about you were using some codes on your body cam that was shown to the jury.
Mm-hmm.
And you said, I believe, a code attempted 44?
Correct.
Okay. And that involved a young lady that we don't know who she is that was on the scene, correct?
Correct.
All right. And just to be clear, all the interaction between Mr. Stillwell and this person was captured on body cam.
Just that, yep.
So when you're saying you observed my client push a woman, that was what we saw on body cam. There wasn't something else.
That was it.
Okay. That interaction, did Mr. Stillwell ever pull anyone out of their car?
No.
Did Mr. Stillwell ever take control of anyone's keys?
No.
And all this was observed by you as Mr. Stillwell was running from you, correct?
Correct.
Okay. That person whom we don't know their identity did not stick around at the scene to file any complaint, correct? In the days that followed, did that person ever come into a police station and say, hey, I was on Cleveland Avenue on this date and this is what happened to me? Did they make any sort of report at all?
Not to my knowledge, no.
Okay. The $5,000 or I guess it was $5,500 ultimately that was recovered from my client's pockets. Was that money returned to him?
It was placed in evidence.
It was
placed in the property, placed on hold.
It was placed on hold for seizure, correct?
Correct.
Okay, so that it was not returned to him.
As far as I know, no.
Okay. And it was seized by the government, by you, as an agent of the government.
Yes.
Now, Mr. Stillwell had that $5,500 in his pocket, correct?
Correct.
Do you have any information as an investigator in this case that that $5,500 belonged to anyone other than Mr. Stillwell?
As far as my knowledge, no.
As far as your knowledge, that was his money, correct?
Correct.
And no one else's, correct?
Correct.
Okay. Let's talk about the red car, the red Nissan. I think we said it was essentially it was an Altima, correct?
Altima, yep.
Right. That car, certainly as an as an officer in this case, you ran that car, correct?
Correct.
To figure out who the owner of the car was, correct?
Correct.
To figure out if that car was stolen, correct?
Correct.
Okay. That car was not stolen, was it?
It was a rental car.
It was a rental car. So I'm going to ask the question again. That car was not stolen, was it?
No.
Okay. And it was a rental car.
Correct.
And it was rented by Mr. Stillwell's girlfriend, correct?
That I'm not for sure. The rental agreement wasn't in the car.
Okay. You have no evidence to suggest that someone rented the car and then it was subsequently taken from them, correct?
Correct.
Okay. Everything was legal about the car?
Yes.
Okay. And it was a rental from Hertz, correct?
Correct.
All right. Now, let's talk about the firearm that was recovered out of the center console. Do you remember on direct where the you testified that it was not reported stolen, and then the state asked you, well, if it was stolen but never reported stolen, it wouldn't show up as stolen, correct?
Correct.
Okay. And that's true, correct? All right, so let me ask you, instead of speculating, in 2019, was there any evidence at all that that firearm was stolen?
No.
Okay. In 2024, as we sit here today, do you have any evidence at all that that firearm was stolen?
As of today?
Yes. I mean, since this happened, has any other evidence come in that changes your assessment?
Not my assessment. And once it gets turned in, it gets turned into ATF.
Okay, so in 2024 today, you do not have any evidence that that firearm was stolen?
No.
Okay. Do you have any evidence that that firearm was linked to any other cases?
No, not to my knowledge.
Okay. And I believe on direct, just to clear something else up, initially you testified that that firearm was a 9mm, it was a 45.
It was actually 45, yes.
It was a 45, okay. All right, so, and you've had an opportunity to view your body cam?
I did.
All right, so and I understand that this was 4 years ago, more than 4 years ago, but in viewing the body cam, did it help you remember or recall some of the specifics about this case?
Yes.
Okay. So, in your dealings with Mr. Stillwell, and in searching the car, I want to ask you, did you find any gang writings or books of knowledge or anything else that indicated gang involvement in this case?
No, sir.
Okay. In your investigation of this case, did you find that there were any other people other than Mr. Stillwell involved in this case?
As far as like outstanders or officers?
Suspects.
Suspect, no. Just Mr. Stillwell.
Your conclusion is Mr. Stillwell acted on his own in committing this crime, correct?
Correct.
Okay. There was no one else that came and claimed possession or possessory interest in this firearm, did they?
No.
And you determined it was Mr. Stillwell's?
Correct.
And only Mr. Stillwell's?
Correct.
Okay. The money that was found on Mr. Stillwell, you determined, although you seized it, you determined that it was Mr. Stillwell's money, correct?
Correct.
And only Mr. Stillwell's money, correct?
Correct.
Okay. And Mr. Stillwell, let's talk about his clothing that day. He was wearing black sneakers, correct?
I believe so.
Black jeans?
Yep.
And a blue and teal flannel shirt, give or take.
Yeah, almost greenish.
Greenish, okay, I'll go with you. Greenish flannel shirt, okay. All right, and when it was time to charge this case, sir, you charged, and you took out the warrants in this case, correct?
Correct.
Okay, and you took out warrants for what you deemed appropriate to take out warrants for.
Correct.
And you charged Mr. Stillwell with fleeing and attempting to elude misdemeanor.
Correct.
Okay, for driving off.
Correct.
When you were trying to stop him for the seatbelt violation, correct?
Correct.
You charged him with hit and run.
Correct.
Obstruction for running from you.
Correct.
Okay, no license.
Correct.
Seatbelt violation.
Mm-hmm.
And possession of firearm by a convicted felon.
Correct.
Based on his status as a convicted felon.
Correct.
You did not charge him with any gang act violations, did you?
No.
I beg the court's indulgence.
Yes, sir.
Thank you, officer. That's all I have, Judge.
Any redirect, counsels?
Yeah, very brief.
All right, go ahead.
Officer Cogdell, Mr. Sharp asked you, I wanted if you remember if there were any other seatbelt violations. He was asking you if you observed any other seatbelt violations that day.
Yeah, I did.
Yes, you remember Mr.
Him asking the question, yes.
On that day, was that the only seatbelt violation that fled from you?
Correct.
And do you have any idea why Mr. Stillwell Jackson was fleeing from you for a seatbelt violation?
No.
And the only thing you were intending to stop him for was a seatbelt violation?
Correct. If he would have stopped, I would have told him to put a seatbelt on and let him about his business.
But he fled?
Correct.
No further questions.
Anything further, Mr. Sharp?
No, Your Honor.
Anybody else? Okay. May we permanently or temporarily excuse Officer Cogdell?
Temporarily.
Okay, Officer Cogdell, I'm going to temporarily excuse you as a witness. Please don't discuss your testimony with anybody except the attorneys in this case. The state will be back in touch with you when and if you need to come back, okay?
Okay.
All right, thank you for your patience, sir. Okay, ladies and gentlemen, the hour is almost 5:30. It's probably a natural stopping point at this point in time, so we're going to recess for the evening at this point. Tomorrow, I'm going to ask that you all be here tomorrow morning for 9:30 for an anticipated 10 o'clock start time, okay? That's what our, and then we'll work and see where we see where tomorrow leads us, okay? All right, so before we recess for the evening, let me give you your official ad nauseum admonitions. Remember, as we're going home tonight, all the things that we talked about during the time period we've been here still apply. Very important, and I know that it's really hard for those that love you and know about you sitting here and what you're doing to not ask you questions about it. And remember, you can blame me and say that Judge Glanville said, really, I cannot talk with you about this. So I'd ask that you kind of remain steadfast in that particular vein. The other thing I would also just remind you about again is that, and the reason I asked you about coming off of social media is that the temptation for third parties to reach out to you is pretty great. So if you're off social media, then that lessens anybody trying to kind of reach out to you for any type of improper purpose that I've told you about earlier. And of course, if anybody should reach out to you, you would need to let me and or Sergeant Ingram know immediately. So please consider that. And also, I would also just remind you as well, I asked you all to not use social media at this point in time. That doesn't mean that third parties won't try and talk with you about what's going on outside. And remember, what goes on outside is not of any consequence, because remember what I told you, you can only consider what's lawfully presented in the four walls of this courtroom, and you cannot consider any other source or sources to get your information from and or share that with each other. Remember I told you that most people get in trouble because they'll come in here and they'll say, hey, I was doing such and such and such and such, and then you get busted. So again, keep doing what you're doing. Be mindful of other influences, and if you should have anybody try and reach out to you, go ahead and let us know immediately. But to that extent, ladies and gentlemen, we really appreciate you continuing to honor these admonitions, because remember, as I told you, from day one, they ensure a fair trial, just trial, lawful trial as to all sides. Okay? So, okay. As you can see, we made some capital improvements in your space. Hope you like those. Our continuing efforts to make you as comfortable as possible. Is there anything that any of you need to ask me at this point in time, ministerial in nature? Okay, all right. Just to put a couple things on your radar, the week of the King Week, the King holidays on the 15th, and that week I think it follows through the 19th. We will be taking an administrative pause. So if you have any things that you need to schedule, that's a week that's good for you, okay? So just to put that on your radar as of right now. There's some other unrelated business that we'll take up, and so just to put that, as I told you earlier when we started, I try and give you as much notice so you can go ahead and schedule other things that you need to do, because your life still exists and continues to go on, even with this very important responsibility that we've asked you to take on. All right, ladies and gentlemen, unless you have anything else from me, remember also leave your notepads in the basket. Are we okay with notepads? Yes. All right, if you get down to where you need some additional ones or new writing utensils, please let Miss Omana know, and we'll go ahead and get those to you immediately, all right? Okay, unless you have anything else in me, ladies and gentlemen, thank you for your patience and continued patience that you're continuing to give this matter. And unless you have anything else, we'll see you tomorrow morning at 9:30, okay? All right, all rise. I'm walking toward the door. All right, ladies and gentlemen, please be seated. Okay, folks, just to get back in the habit, if you could turn in your listening device so we can charge them. Does anybody else have anything else I need to take up with the court before we recess for the evening? All right, hearing none, we'll see everybody here for 9:30 tomorrow morning, and then we'll start when everybody's accounted for. So we'll be in recess until that time. Thank you. All right.